Hey, what's up, guys? Welcome to Lost Point. What the fuzzy thing? Welcome to Lost Planning the Internet. I am your host, Interwebs. Oh my God, I screwed it up. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How you doing, guys? How's it going? Let's see. So today we have the curious case of Darrell Brooks. Darrell Brooks being the Waukesha Parade chauffeur. Is that the offensive way to say that? Clyde Frog, I did a day stream yesterday too. Oh my God. And didn't I do one? Did I do one the day before? I don't remember. I can no longer remember the days. But we have this hearing that is supposed to be happening for pretrial housekeeping issues starting at 1:30 p.m. Central Time. I don't know if it's going to be streamed or not. I have no idea. So what we're going to do is just see. And if it is streamed, great. And if it's not streamed, also great. That'll be fine. Everything will work out okay, whichever one it is. And then that'll be that. I've got plenty of stuff to talk about if it's not streamed. Plenty of things to go through. And yeah. Law and Cucks have it scheduled. Perfect. Okay. So here's the skinny. Here's the update. I've got an update for people for the early crew. So yeah, the stream's gonna start at 1:30. Perfect. We'll pull it then. I'll see if I can find it. Okay. Jeez. My brain is scrambled. James Hurley, the answer is always Ethan Ralph. I don't know why you bother asking. No matter how you phrase that, it will always be Ethan Ralph. Okay. A couple quick things before the show actually gets started, because it looks like it will be streamed, so that'll be perfect. Maybe I'll invite a couple people real quick. Do this. Here we go. Send these out. I have to do this all individually now. Because that's how it goes. Fucking different apps. All right. Okay. I think I've sent out a sufficient amount of invites. Okay. First things first. Locals chat is live. If you have, if you don't want to participate in the YouTube chat, or you want to participate in the YouTube chat and the locals chat to have two different chat experiences at once, it's like a double chatitration. You can do that if you join locals. If you join locals, you can do that. And I strongly recommend that you do, because it's awesome. And also because a bunch of people are really, really mad about me or about me, at me, and all of that stuff. With that said, I have not, wait a minute. Wait. Uh-oh. Guys, the Babylon Bee just commented on my live stream from last night. I hope they do the thing. I hope they do the thing. So last night we covered the only useful thing the Onion has done in a long time, which was hold on. Was file an amicus brief in a Supreme Court case, and it was a parody. It was a parody brief, and it was it's fantastic. It's actually kind of like a work of art that they did. They did the only thing useful that they were funny again and important. And I suggested it would be amazing if the Babylon Bee filed a counter amicus brief that was so much better parody that it became obvious that it was for the same side as the Onion, but it was funnier than the Onions because it's the Babylon Bee, and the Babylon Bee is funnier than the Onion. So that's that was the thing, and they they just commented eyeballs on my live stream. I love the Babylon Bee. I think they're fantastic, and I want them to do nothing but make more people mad. That's what I want them to do. So we'll see. That'd be great. All right. A couple things. I have not posted the fan mail yet on Locals, mostly because I haven't been around to do it. I'll probably get around to it after the stream today. I did get a letter, an email from one of the people who sent fan mail and begging me not to do it because they just didn't know, bro. Like, bro, like we just didn't know that maybe the information could be public because it said it was private, bro. And like, even though it does say on the forum that they would send all of the information to me, they're like, oh, well, I just like no harm, no foul or whatever. Like I just tried to impact your career to ruin the 3.5 years, $100,000 extra education that you had. Like I just tried to ruin all of that. Like, because I didn't like what you said about a fucking weirdo named Keffels. Like, and I didn't know, I didn't know that Keffels was actually bad. Like, and I think Keffels is really bad now, like totes bad. Like, please, like I'm totally reformed though. And how could I have known? Like, what was that? I just figured you went on the internet and lied about stuff and that everybody was just lying. Like, just everybody was lying. I mean, how could I have known? So what I did was I lied about you to try and get your livelihood ruined. But like, that didn't seem fair that you would then like tell the world about it. Like it seems like not, I mean, that doesn't seem right. And I'm like, oh, wait, what? Like it didn't work. So now you're like, oh, it takes these backsies. Totally like, it's fine now, right? Like it's like they didn't do anything to you. Like it's okay. I ran to your manager and your manager told me to piss off, and now I really wish I hadn't. Well, sorry. Sorry about that. I'm really regretful of your life choices. I can't. Oh, and they're like, I totally, I've been distancing myself from Keffels, like forever, a while ago. They filed the complaint on the 24th of September. Like this isn't like someone who filed this back in August. Like they filed this complaint on the 24th of September. That was 10 days ago, 11, something like that. Yeah, kind of just great. Like what you do, but I gotta say this: we have to be fearless fighting these people because they will take no missed opportunities to ruin you, to shred your life. They don't care. They think they live a consequence-free existence where everything that they do is protected and wonderful and right and righteous because they're on the right side of history or whatever. Sorry. It's not how it fucking works. I'm tired of pretending that we need to all bow and moderate and equivocate for them. No, not anymore. No, thank you. And I'm not going to sit here and be at the fucking mercy of some troon mob. It's not going to happen. That's not how I've worked I've said this many times. I've worked my whole life to not have a master. And my master is certainly not going to be a bunch of mentally crippled morons following around a Pied Piper without a Peter, trying to ruin people's life. No, thank you. No, thank you. I worked for independence from other idiots, and I'll work for independence from these idiots too. All right. Anyway. Okay. So yeah, it's all coming up. How does Long Crime get to run multiple live streams at the same time? I didn't know that was possible, but I guess it is. So anyway, Maiden Iron. The one thing I don't know, like, so who's the guy? Are we getting his name? I haven't decided if I'm gonna release who sent me the email yet, like specifically, because it was just so pathetic. Like I do feel bad for how weak they sounded, like and just how insane like that was. Like it's just yeah, I know I did that, but like I didn't mean it. Maybe now that it failed. Yeah. Okay. Got it. Yeah. So we'll see. I'm thinking about their name's on the list. Oh, I didn't release. Let me just read to you the first line from this thing. Hey, what's up, Sean?
Not much. How you doing?
Pretty good, man. This hearing's going to start in just a couple minutes.
It should be interesting.
I wanted to talk to you about something that happened with the jury selection in just a second. But okay, so we're live over on Long Crime now. I'll pull that up in just a minute. Let me crank the volume up. There's no volume yet, but let me just read the first line of this email to you guys so you can see just like how limp-wristed it was. I just hate everything about it. Hi, I'm emailing you regarding an ethics complaint filed under my name a while ago at the Minnesota State Bar with regards to comments made about Clara Keffel Sorrenti. So I read that line and I was like, oh my God, did someone use a fake? Like, someone fake file? No, it was this person who filed it. Like, but they wrote it in the most passive way about a complaint filed under my name as if they had nothing to do with it at all. It was just amazing. Like, come on.
It was funny going on Twitter, listening to some of those responses today. People just...
yeah, and I don't even go on and look, so I'm sure they're just losing their minds.
And also, Alex Caraballo for not doing his own, I think is a little...
Oh, that's so weak.
That's
actually...
Like well, he probably is limp dick being a tranny and all, but...
That's that was just such a pathetic move. Like, you guys all go do this. Totally. But not me, though. Okay.
Because, yes, as attorneys, we're on the hook if we... It's one thing if you guys, you normies out there, file a bar complaint that's kind of sketch, but if we do it, it could go very bad.
Yeah. Okay.
Also, people are saying I'm in a bathroom. I'm on my laptop in my office, so oh,
F11 of F11. That's what I was looking for.
yeah.
All right.
Well, drink that water,
Let's
Darrell.
drink
You're
that
gonna need
whole
it.
water. That's a little
Hydrate.
water. There we go. We've got fair use on their stupid fucking
Yes.
logo. Yeah, Catnip's right. They only regret it as a failed attempt and not the actual attempt. Yeah, of course. If it would have worked, they would have been like, "Ha, we got that bigot."
Yeah.
Now, the interesting thing about that whole I just didn't know. I've clarified my statements multiple times. Very specifically have not called for violence and have clarified that I never did and wouldn't, because it's not how I do things. But that, doesn't matter. None of that matters. Couldn't do that. They only had, a month or so from the original stream to figure any of that out. I posted that what they said that I said wasn't true on multiple tweets, responding and quote tweeting, all of that. So, and they chose not to investigate. It's not my problem anymore.
Yeah. Yeah. And I watched your, they all did the same one too. That's lazy.
Yeah.
Not even like 44 different versions of Re. They just,
no. That's what I was hoping for. Like, at least make it interesting.
Yeah, well, when I texted you about it, I'm like, dude, that's gonna be awesome. And you're like, no, it's all the same thing.
Yeah.
I said, aw.
I believe Court TV's cameras are the actual cameras in the courtroom on this trial.
Good.
So just in case anybody's wondering about random copyright issues, have fun. We're also going to add commentary, something that isn't done by any of the other stations covering this. Okay, so Sean, did you hear how jury selection went at the end of this thing yesterday?
I heard you talking about it, and I checked into it. That is weird, especially the whole aspect of, because I actually got done this past week. Actually, yeah, it was on Tuesday. I did standby counsel for a sovereign citizen. Unlike Darrell, this guy knew his stuff and actually he spit all that game. Thankfully, it was only a 1-day trial.
He was guilty?
Yes. Yeah. Well,
I just wanted to clarify. So you said he spit all that game. It was a 1-day trial, but he's still guilty because like you can spit all the game you want. It's not gonna work.
Yeah. It was a possession of meth case, so it wasn't like the most drawn out thing. Here we go.
CF.
We'll have some breaks, I'm sure.
48.
Did he get booty gooned? Is that why he's not sitting down?
I don't know. Hope not. Wait,
Leslie Daisy
I guess
and
I don't
Zach
care.
Show, all appearing for the state of Wisconsin.
Sir, state your name for the record, please.
Hold on just a second.
I'm here
so
as a
awesome.
third-party intervener in that matter, appearing as authorized.
Don't create that joinder, bro.
I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
No UCC claims?
Also, Your Honor, I would like to make an offer for my appeal, if I may.
An offer for my appeal?
I'll get to that momentarily. The record will reflect that the individual known to this court to be Darrell Brooks is appearing in person in custody. We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues and other legal matters.
Oh, God, this is going to be a train
So
wreck.
he is appearing today in jail attire. He is in custody.
Yeah, people were asking if he's in jail attire to try and get
Mr. Brooks,
prejudice, but he's
you were offered
in jail attire.
to
There's no
appear
jury.
in the suit.
Yeah. There's no
but
point.
Chose to come to court in jail attire, which is fine. We're not in the presence of the.
They let him wear a suit today. Nice.
At least they got that right.
Identify by the name that you stated earlier. I want the record to reflect that, if I may.
The record will reflect. Thank you. All right, I know there were some filings, and I want to make sure the parties have copies of
She is so
everything.
Wisconsin. I
The
expect her to
DA's
sweat
very,
Folks, I know there
mozzarella.
was an inmate
the DA's worse
form
when you listen to her.
filed, I believe earlier this morning, requesting 6 subpoenas as soon as possible. I instructed my staff to make sure ample copies of the subpoena forms were provided to you. I did receive verification that those were hand delivered.
Got my shake weight.
Did you receive those, sir?
No, I did not.
They were hand delivered.
We'll provide additional copies.
Yes.
Again, it's my understanding those were hand delivered
He didn't receive
to
them.
the jail, and that the jail took care of that in the event that
The
latter part
personhood of
did
Darrell
not
Brooks
take
did.
place. Mr. Brooks, I believe you were requesting 6 subpoena forms. I'm going to have my clerk print out 10 so that you have ample copies. And
Just get some
when that is
extras.
done and those are handed to you, I'll make a
Simple.
record of that.
They try this stuff like
We addressed the inmate communication form I sent about the,
I have a number of issues I need to address, so yes, we'll get to that.
we'll get around to it.
um,
Oh no.
you don't believe that has, that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up.
Let's see, Fair Frozen 55. Your
I'm not seeing it in the record yet, so.
Your gayness and lateness has been noted by the Bureau of Microaggression Assessment Board on behalf of our great
prosecution will
esteemed
receive a
client.
copy.
That'll be 2,500 plus
I
tip.
believe one was
tip
printed
is
now
received
for
through the
them.
back
It is
door.
in the record. And then I'm gonna print off something as well.
Judge already has more
Was already.
patience than you would have. This dude is. I mean, we haven't gotten to see it on video, but from the sounds of it, just absolutely insufferable in the courtroom. From what I understand,
Respectfully, would like to state for the record and would like the record to reflect that
everything you say is on the
I
record.
believe that this is an issue that should be addressed at this point before we
Sir,
go any
I'm
further.
preparing to do that. I didn't say I wouldn't do that. So give me a minute. I have some documentation that I'd like to provide to the parties as well. I want to confirm with Attorney Opper that you have now received a copy of that.
Hey, I got a phone call. I'll be right back.
Form.
Okay.
Yes, I have one in front of me, Judge. It's dated today's date, October 5, 2022.
Yes, dated today because I just learned of the protocol that I would be on as of today.
The protocol that I would be on.
Make 2 copies, one for each party. All right, I'm going to provide a document to the parties. It's a 5-page document. It is a document that was forwarded to me at my request by Monica Paz, our clerk of court, after receiving the inmate communication form from Mr. Brooks requesting an adjournment. For the reasons stated in that document, I thought it important that we all have before us the current county protocol related to COVID-19. And so this will be provided to the parties.
Now, I decline to accept that if I don't believe
Sir,
that it's
it will be
law.
placed on your table, but I will be referring to that today, so
Is
it's
it
been
law?
given to you.
I decline to accept it. It's
Is
not
it,
how it
is
works,
it
bro.
verified law, Your Honor?
Is it verified law?
Attorney Opper, do acknowledge that the COVID-19 illness reporting protocol was
respectfully
provided.
I respectfully object.
Yes, Judge.
Your Honor, I would like an answer to that question if I may,
Oh my God.
because I have not consented to or agreed to accept any paperwork that.
Sir, it's been
It's not-
provided to you. It's
So are you
something I'm going to
making-
consider. You don't want to
Are you
read it.
making,
You
Are
want to
making a
disregard it? That's
judicial-
your choice.
Are you making a judicial determination that you don't have to answer that question I just asked you, Your Honor?
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is your choice whether you want to review it or not.
You don't have to do anything. Like there's
So
nothing.
my understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is
What is the
requesting an
Wisconsin
adjournment
COVID-19?
of all proceedings due to learning that he's on a COVID-19 protocol. I don't have any other information than that, sir. But based upon,
What?
and again, I did
Oh, there we go. We're back.
grab, I didn't grab, I was provided with the COVID-19 illness reporting protocol. I wanted to make sure that I had the most recent information that at least the county of Waukesha is operating under. I also verified
order
with
real quick.
court staff that the location at which you are seated is not within 6 feet of any other individual in this courtroom.
That's probably.
Is there any other
yeah,
information you think I
basically
should
it.
know as I consider your request for an adjournment today?
Yes, I find it hard to believe that you couldn't consult with jail staff to verify the protocol, to verify that I was seen by nurses that
I don't have that
specifically-
information, sir, and let me be clear, cannot be provided to me under HIPAA. The only information I have is what you put in the inmate communication
and
form.
it could be verified because I was told when I was brought down here that everybody knew that I was on a COVID protocol. That's why everybody
Because you
had.
advised us.
That's why, no, because the jail advised them. That's why they had to wear masks to bring me down. That's why I'm essentially on a protocol that doesn't allow me out of my cell until my results come back. So I'm not allowed out of my cell at the moment because of the protocol that the nurse himself placed me on, that the jail confirmed.
Okay.
That is very easy information to
She
obtain.
can't get that.
Sir, I
Just-
have
just like-
an attorney for the
Excuse me,
county
Your Honor.
here
I
who
don't-
will
I don't wanna-
verify
I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due
I
to
don't-
HIPAA.
I don't want you to think I'm
requirements.
arguing.
So I'm not
I-
arguing it with you,
I
sir,
know, I
one
just
bit.
want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
It
So I
doesn't
need to
matter
stop
though.
you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor.
I don't
because
consent
have
to
to
being
consent.
stopped.
I don't
Here we go. Let
consent or
me- let
agree to
me-
being cut off right when I'm trying
All right,
to
I'm just
provide
going to
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding
This
the
trial's gonna take a
COVID-19
year.
protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you
Oh my
wanted to
God.
provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by
Sign that
signing an
HIPAA release.
applicable authorization to do that.
But he
Without
doesn't
that,
consent to the release.
I
I'm
have to
sure.
rely upon you to provide that information to me
That is-
if you so choose.
That is incorrect because
Wait, what?
just yesterday you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen
here
by a
to
nurse
make
that
the
placed me on
argument.
this protocol for having a loss of taste, fatigue, and I have to wait
You got fatigue, but you're
for the
standing.
results of my test. And until then, I am on a protocol which restricts me to my cell. That is very easy information to obtain.
Notice
and I
both
find
those
it very
things are
hard that Your Honor
self-reported.
cannot
Loss of
obtain
taste
that
and fatigue,
information,
not
but
testable.
can obtain a way to communicate with jail staff when there's a witness
grade A
that's
bullshit.
involved. We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a
I'm
lot
just
of
trying to
merit.
keep
And,
the
and
court
frankly,
safe.
Your Honor, I'm
That's what I'm trying
afraid.
to do.
I'm fully vaccinated and I've never had COVID. I don't know
It's fully vaccinated.
what I'm looking at here.
That
I
might
don't,
explain what happened.
that was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered. And that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I don't know the
I'm not
name
a
of the
nurse
test.
either.
I don't, like I said, I've never had this
Let me
happen.
clarify that. That was a pretty ambiguous question. So, you reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
Yeah, he's trying to delay.
I mean,
That's all
that
it
it's
is.
obvious. I mean, why can't it be verified with the nurse?
I
You
have to
sign
verify
a
it with
HIPAA
you. The nurse
release.
will not provide me with this information.
But the jail can because they control
they
the
can't.
movement. They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the
It's
moment.
not, but I'm saying, how can I tell you? How can I answer what you're asking me? It doesn't make
You
sense.
just use your
We all
words.
understand that
Use your words,
the
bro.
jail itself controls the movement of the inmates. That's common sense, Your Honor.
I'm not
It's not movement.
here to talk
I
about
can't
inmate movement
just-
at the
I can't
moment.
just
What I'm
walk to
asking
the
you is,
HSU.
do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
No, that's not actually true. If you just
Do
report
you know
The
what
nurses-
type of
they might
test was
put
it?
you on the
An
protocol.
oral swab, a nasal swab?
It was a nasal swab.
Okay.
Do you
there
know
you
when
go.
the results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to be
So they
at
gave him a
least
full.
on this protocol until the results come back, which
Were
I can go to
you-
he
Walgreens
said
and
the
get results in
earliest
2
would be
hours.
Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
If one can be
Sounds like a
obtained, are
lie.
you willing to submit to a rapid test?
I'm not willing to submit to anything right now until we take care of the issues that's at hand. I mean, I've already been placed on the protocol. I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so for
Oh
this
my
to
God.
just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor.
But what does that have
That's
to do
the
with
reason
anything?
why I submitted the ICF for the adjournment. I was thinking at least until I can get the results at bare minimum.
That's what I
I
was
don't
thinking.
think I'm asking something that's
Sir,
impossible for
if
Your
I
Honor
can
to
make
grant.
arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at
No.
this time.
Why not?
Not at this time.
Why not?
Why can't I get the results of the test I already took?
But you're telling me you're scared, you're
Yes,
fearful.
I am.
But you don't want to
very.
take a test that might
I
tell you
took-
today.
I took the test that
That'll come
he
in on
gave
Friday.
me.
Because it's bullshit.
If-
That's why.
And
if
you're
he
telling me
felt-
that test result won't be available to
Look at
you
this
until
attorney's
at
face.
least
She's
Friday.
At
like-
least Friday. That's what I was
She
told.
knows it's
tomorrow.
just-
I was told that
knows
I
it's
would
just
be placed
bullshit.
on this
After.
protocol until the results came back. The earliest that the results would be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor.
Yeah, good.
I have no
Doesn't
idea what
matter.
it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID. There are tests that can be
Judge is
what
being
we
a
call
biologist.
rapid tests, or what are
He
called
does not
rapid
consent to
tests
her
that are
knowledge of
available.
testing.
And then there's these other tests.
All right,
which
sorry,
take
I'm
a
back.
few
What I
days.
missed.
Again,
This
I'm
is
not a
just a
scientist,
shit
but I
show
think
about
the
this COVID
general belief would be sometimes the rapid tests are accurate, sometimes they're not.
No, why
Sometimes
would you
people
say
test
that?
negative when they're really positive. It just kind of depends on the
Don't tell him
circumstances.
that.
But it's my understanding a positive test would be pretty accurate. And then there's other tests that take a few days for the results to come back. It really depends on the lab that's being utilized, et cetera. I'm asking you once
I'm
again,
with
if
him
a
on this one.
rapid test can
He's
be
bullshitting like
obtained,
crazy, but
are you willing to take a
shouldn't have said
rapid
any of
test?
How would that be obtained? How would it be obtained?
I would
I was
work
told
with-
I can only go
and
by
buy
what was
one.
told to me, because when I was brought in there and they told me that they had to test
The
me for
judge
COVID,
can
I was
order
immediately
the
like,
test
what
because
do you
it's a
mean you have to
judge.
even test me for this? What is this about?
Well,
I had
didn't
a
you report
lieutenant.
symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need, what's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid.
I
when
thought you weren't allowed to
they had to
understand.
even test for
Bro.
COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue, with me feeling very
As he
fatigued. And I said,
stands
man, I don't know if it's
at the
just
table.
me being tired, or
My booty hurt.
that's what I initially thought it was. Maybe I'm just a little
Like,
exhausted.
Goose
So I
got me.
didn't know. Anybody knows their body. I said something. This got to be something more, because I'm really, really, really. I don't even have an appetite. Then when I'm trying to eat, I can't taste anything. That's what said. Okay, now I need to put the medical. Sick
When did
call
you
slip in.
report these
You know
symptoms
what, not being
to
able
the
to
medical
taste isn't
people
the
or
worst
to
thing in
even
jail
just
or
a
prison
correctional
sometimes.
officer?
A few days ago.
Depends on your cellmate,
A
probably.
few days ago, over the weekend is when I started to notice the fatigue. So I was telling officers, man, I don't feel good. I don't know if it's just I'm tired. Usually I don't just jump the gun and say something's wrong, because it may just be, it could be anything. So
When did you report the loss of taste?
I
It could be
reported
just-
the
it
loss
just
of
be
taste
anything.
last night.
And was
Shocker.
it after that they told you they wanted to test you?
No, they didn't tell me till this morning that they wanted to test me.
What other symptoms are you
Stop it, Judge. Just
reporting
stop.
at this time?
He's been
That was it
tested.
so far,
He's on the
just the
protocol.
fatigue
The court protocol
and the loss
says
of
6
taste.
feet away from all people. That's not a big deal for this hearing. He can proceed until tomorrow. Not
Which
a
is
problem.
the reason why I was told that I had to take the test.
And this is not something that would truly affect the record at all.
Which I was told at that time also.
He's already not entitled
that
to have
the earliest
co-counsel
my
or
results would
anybody
be back
at his desk.
Friday.
So there's no reason
Yeah.
that this would affect anything.
And he's not approaching any witnesses.
You said at this point you're not willing to take a rapid test.
Well, they said this is the test that they do.
But the judge
The
could
nurse
order
was
a
very
rapid
clear
test.
when he was telling me,
She'd order the
when he
bailiff
told me
to
how to
walk to
test, because
Walgreens,
like I said,
bring a
there
rapid
was
test
lieutenant
back.
and 2
Yeah,
officers
bring in a
right
nurse.
there.
She
Right
could
in
make
your
a
nose.
pee on a
Things
stick
going
if
on.
she wanted to.
I understand
And-
all of that. I have a very
I was-
specific question to
I
you,
was
sir,
asking
though.
them questions, and he specifically told me that this jail, this is the test that they do. They do not do rapid tests. I didn't even ask about the test because I know nothing about the
He
test.
didn't
This
ask,
is
he
what I was
drove.
told.
Yes.
And after he told me that,
God.
I said, okay, fine, just do the test and I'll just sit on the protocol. Because at first when he told me, you're going to have to be on a protocol where you're isolated. I said,
He's
okay,
like, I'm not on a
do
protocol,
the
I'm an
test.
amateur
I'd
call.
rather you do the test and make sure that I'm healthy than to just refuse the test and just say, I'll just wait to see if I get better or something like that. So I said, yeah, just go ahead. And that's what I was informed.
Okay.
Friday
Oh my
would
God,
be
that
the
was
earliest that I would
correct.
get the results back, and I would be placed on a protocol which is called isolation, where I'm not allowed out of my cell.
Which has no impact on this trial.
Yeah.
Anything else, sir, you think I need to know about this issue as I
He's about to
consider
deny
your
his
request?
adjournment.
Yeah.
At this time, I'm just telling you what I know.
Yeah.
Multiple
asking if you
officers
have-
were there. They can tell you the same thing that I'm telling you now. Like I said, Lieutenant Chamberlain was there. 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's
Oh, don't
available?
tell me you're going to do this.
Absolutely not.
Why would you do this?
No. So
Just
did you hear the
accept everything
DA?
he said is true. It doesn't matter.
Given
You
any
don't,
information
you
about
don't need
whether
to
anyone
adjourn
else
the
in the
court.
facility is
Yeah.
experiencing COVID right now?
I wouldn't know
If
that.
COVID.
I wouldn't know who.
COVID.
I'm in the mental health.
Oh, yeah.
Anybody
medical
else
pod as
having that
it is.
COVID dare you know?
So no information's been provided to you that there's like either a lockdown or some type of a restriction due to any like concern over COVID at this time?
I would never have that information because, like I said, I'm limited in the pod that I'm in. I have no interaction with any other inmates, and my interaction with staff is pretty limited.
All right, thank you. I appreciate that additional information.
It's,
I know, sir, what I provided to you is generally the for employees. I fully recognize that the jail may have different protocols. Just
Wait, she gave him the jail like the jail employee handbook?
facility.
just a
and,
COVID-19
inmates are,
protocol for it.
of course,
Oh.
can be very
illness
close to
reporting
one
protocol or
another.
something.
And so I don't want to presume that this is exactly what they follow. And so I'd like for them to tell me what their
Oh my
protocols
God,
are
what a
as I
waste of
consider this
time.
request. At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom.
And him.
As I consider this request, you've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding of the protocols. And despite you reporting fatigue, I know, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table. Oh, knee on the chair. Okay, but you've
Got a
been
knee-
able to very
knee on the
clearly,
chair. He called that chair
coherently
George
make
Floyd.
your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or.
Or Attorney Sewell is coming up now.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court, as an officer of the court and as an offer of proof that he is.
How could that?
Johanna, we believe he's doing a fooling on you.
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd
That's
encourage you to use
That is
paper and a
ridiculous,
pen
Your Honor.
to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another so that
There's
number
no
one, the
jury here, so it
record
doesn't
can be
matter as much.
clear.
I'm not good at
And
that rule.
perhaps most importantly, because
I do it
that
all the fucking time.
is
Yeah.
a sign
no
that
shit,
we
you're
all
doing it now.
understand that this is a place of dignity. It is a place of respect.
Well, don't oversell the
It
court here, honey.
demonstrates that, frankly, a willingness on the participants to conduct themselves appropriately. It avoids creating disorder or disruption. So
Man
I
drove
will
an
give you an
SUV into a parade of
opportunity
children.
to respond.
Yes, he's not worried about decorum.
Attorney Opper an opportunity without interruption. Go ahead, Attorney
He can
Opper.
object, though.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back.
Never talk in your
Here
prison tone.
again on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information.
What a waste of
I
time
believe
that would
Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also, I believe she would be able to provide information if the court ordered her to do so.
Waive your
I believe that even if he is on COVID protocol, it will have zero impact on his ability to prepare
Yes.
for this case.
Exactly.
As we've learned already, and I'm prepared to make a further record, he has all of his discovery materials within the confines of his jail cell.
Mhm.
He has a tablet made available to him in the confines of his own jail cell.
Well, that's nice.
And he has the ability to use a conference room in his pod. I don't believe the COVID protocol would interfere with his ability to access that conference room whatsoever. But again, I could verify that with the jail administrator if the court thinks that's an appropriate fact. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to.
I never once said.
Mr. Brooks,
I never
have
said.
an
I never.
opportunity
No,
momentarily.
No,
You
I
need to stay
respectfully
quiet.
object to that because that has no merit.
Mr. Brooks,
I-
it's not
she
your
said-
time
no,
to speak.
No, I respectfully object. I never reported saying what day. I never said a day.
Calm
And
down.
if she's saying she has
You get thrown
jail
out.
phone calls, well, why
Come on,
aren't
drop-
they present? Why
drop
can't
some
they be
F-bombs.
verified by
Let's go.
sworn affidavit and brought into this court to be shown that this is a delay tactic?
Start building that tower.
How come
He's
it can't
trying
be
to
shown
delay
by
with his
sworn
delay
affidavit?
tactic. That's 4D
Can you
chess right
provide
there.
proof of that?
All right, Mr. Brooks, I've given you a little
Just
bit of
like-
leeway
just like
because
a 3-day
we are
hearing.
outside the
That I've
presence
waived
of the
something.
jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail
have to
that
consent
this
to a waiver of
protocol is
rights.
in effect and that I was in
There is a constructive waiver.
that I was
Maybe there
in
shouldn't be,
effect
but there is.
tested for COVID-19. How could that be a delay tactic? If
What,
that was
gee,
a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
because you reported symptoms of COVID-19.
All right, Mr.
Is
Brooks,
there no-
I've
is there
given
no
Mr.
verification?
Brooks, I'm going to warn you now that you have interrupted a couple of times. You interrupted
I have to
Attorney
be able-
Opper
I have to
twice.
be able to speak up.
You're
Your
now
Honor.
interrupting me yet again. We all were polite and had you
That
provide
was not
information.
polite. That was
That's
abuse.
this is the
that was
third
abuse.
interruption of this court.
That was abuse by the
It's
prosecution.
abuse.
That was abuse.
Mr. Brooks, let me finish.
No, because that's
So he's outright refusing to listen.
I would
He's
not sit
outright
here.
talking over me
I didn't
at the
refuse
moment.
anything. I didn't refuse
Mr.
anything.
Brooks, we are at the
I'm
point
not gonna,
yet
I'm
again
not
where
gonna
I
sit
will put you in the other courtroom because
and
you
I
are
don't
not
consent. I don't
able.
consent to being removed. I have not waived the right to be present, and I don't agree with that.
She needs to remove
Mr. Brooks,
Does it?
his
does the
I have
record
ability to
reflect-
provided
represent
you
himself
Yes.
to
on
point counsel.
multiple occasions.
This needs to
the-
be
At
over.
this point, yes.
should be
That
in
would
front of
protect
you.
her.
I don't.
Not-
I don't acknowledge.
But she
that.
should.
I haven't.
Yes.
You
it
have
would
been
protect her.
advised on
given
multiple
consent of it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are now acting as your own attorney by
I'm not a named
representing
defendant.
yourself.
I don't recognize the name
That all
I
of
don't
the
recognize my
rules
name.
of courtesy and
put on
decorum
your
apply to
complaint. I don't
you.
recognize that.
The
name.
real killer's still out there.
Supreme
who I
Court
am.
Rule 62.02
He's in the parking lot.
details many of the requirements for courtesy and decorum. I've referenced a couple of them on multiple occasions, including that sub 1 sub F of 62.02 that proper conduct and attire
This
is
gonna be
Defender's
expected
the
from
office.
longest
court health
trial
and
ever.
The
Uh,
puppet defender's
where-
office is shitting
where
bricks right now.
possible,
Like, no, don't do it.
Individuals, including yourself, right, are to refrain from creating
just boxed
disorder
up his
and
files.
disruption. Sub H, you're supposed to conduct yourself in a manner which demonstrates sensitivity to the necessity of preserving decorum and integrity of the judicial process. You have been advised multiple times, sir, of the
Multiple.
expectation that this court has that you conduct yourself in a civil manner.
You have to make fun
You've
of
been
Wisconsin
advised
accents
multiple
as a
times
Minnesotan.
that this court will not
It's
tolerate
required by law.
disruptions, interruptions,
The law of the streets.
that when you do that, you run the risk of forfeiting your right to be present in the courtroom. As you know, I have available the courtroom next door that's connected to the holding area. It is connected by audio and visual means. It provides you an opportunity to meaningfully participate by also giving the court the opportunity to control the decorum, to control the disruptive behavior, because primarily your disruptive behavior is repeated interruptions of this court, talking over this court, now talking over the prosecutor. I appreciate that you have not interrupted me for quite some time. So at this point, though, I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audiovisual means. At this time, I would like to hear from the court administrator, especially as it relates to the protocol.
I think you mean jail administrator.
Jail administrator.
Did I say the court administrator?
Yes, that's all right.
That's okay. We're in court,
Shane,
and
yes, she
I would
can
like to hear
revoke
from the
his right to
jail administrator. Thank you
self-representation.
very
Well,
much.
he would effectively waive it.
And just to get some
And she
general
could appoint
information,
counsel and dismiss him from the
and
court. if she
perhaps even
needed
some
to.
specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who are present. So I believe we have Angela Wallenhaupt here, if she would come up to the witness stand.
Your
This is-
Honor, if I don't want to mix issues, but the inmate communication form from September 28th also still needs to be addressed by the court, and I think the jail administrator may have some information relevant to that issue as well.
All right, thank you. I have a
Okay,
list
cool.
of a bunch of things I want to go
Heather
over.
Whitaker
and I'm
says,
gonna-
when are you coming to San Antonio and will you have a meetup?
Just so I'm clear, are we addressing the issue at hand now,
We are.
or are
Yes.
we
Oh my
addressing
God.
something from September?
Well, I will get to the September inmate communication form at some point during this hearing, but right now I'm addressing the most recent inmate communication form that is dated October 5, and that addresses your request for an adjournment. So I'll have you sworn in. I'll just do it. Raise your right hand. Do you
Dan
solemnly
the
swear
Weather
that the
says, can this
testimony you're
judge
about
just
to
yell,
give shall
he
be the
has
truth, the
car
whole
keys,
truth,
and have the
nothing but
bailiff
truth,
just
so help me
blast
God?
him?
Yes.
Put an end to this
Thank you.
charade. He's got an SUV. Blam, blam.
Yeah. Could
Could you
happen.
please state your first and last
I don't know
names
when
for
I'm
the
coming to
record?
San Antonio, Heather.
Angela Wallenhaupt,
Whoa.
Would you spell your last name?
WOLLENHAUPT.
Thank you. If you could please
It's a stern demeanor.
advise us
Yeah.
on the record again of your
She's
Job
probably got
title
work
and
that she's been taken away from.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the division in charge of all staff and inmate issues.
Could you provide information to the court on the general COVID protocol?
She looked like she
within
just
the
went through
jail?
8 emotions in a row just then. It was
Judge, I
weird.
would prefer to not speak to the operational considerations with that. I can speak to the fact that there are different protocols that are put on people for different medical or management reasons, which may have modifications to them. I can speak to the protocol Mr. Brooks has placed on, that it won't affect the area he is living in, nor access to areas that are not other inmate occupied.
That seems fair. I don't want to certainly put all of your operations on display. That's not necessary. But if you could speak to the specifics as it relates to Mr. Brooks's current situation.
So he would remain in his current cell housing location. He would have access to a conference room if he needed it, access to a telephone.
Conference.
And we would be able to, it's a safety security measure for him as well as our staff. And we can safely produce him for court.
Right now, he's
When
picturing
I
himself in
hear
bigger and bigger
the phrase
vehicles.
being on a protocol, that to me could have more than one reason. Someone could have been exposed, someone could have tested, or someone could have reported symptoms that required testing. Would I be mistaken in any of those beliefs?
You are correct, Judge.
Would there be any other reasons for someone to be placed on a protocol, a COVID-19 protocol within the Waukesha County Jail?
No.
And would you tell me which one of those three options has prompted the COVID protocol for Mr. Brooks?
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is?
Yes,
Based on
however,
information provided to you?
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me to speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation
object
to
now.
verify the
Yes,
information
he
you
will.
provided. Is that still correct?
No.
I said that I wouldn't have any issue with
My man.
pertaining to myself. I don't know. I'm not speaking about anybody else in the jail. I'm not speaking about everybody's situation is different.
Right. And I'm specifically referring to your situation.
Well, the question was asked in how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Right. I'd like to verify the information that you're providing to me regarding what was reported by you, what tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask her about?
No, I do not understand.
Did you hear what I said just now?
I do not understand.
But did you hear what I said?
Frankly, Your Honor, I think she would probably be the wrong person to be asking because she wasn't present.
You must understand then what I'm saying if you think she's not the person who would
Oh,
provide
no.
that information.
Connie
So,
I
Faustian
didn't consent
trap.
to understanding or agreeing to that. No, I do not understand.
all right.
For God's sake,
I took his
somebody should
statements
explain to her
earlier.
the
I
understanding
realize you
of
don't
this
have
guy.
a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I am directing you to answer the question.
It was brought to my attention shortly before the lunch
Oh, he
hour
should have objected.
that
He
he had
didn't
made
preserve his
statements
objection.
that prompted
Yeah.
the medical department to follow up. As I said before, I have not reviewed the medical record. It is my understanding he was administered a test. He was also offered another test to which he refused.
Oh, really? Was it the rapid
Do you have
test?
any information regarding whether this other test would have been a rapid test?
I believe it to be.
Do you have those tests available in the facility to offer to an individual?
I have one available right now.
Oh no.
Just-
Ask a question, Your Honor.
Nope.
Of me or of the witness?
Jail administration.
He would have the right to cross-examine
Go
her.
ahead, you can ask the question.
Yeah.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested? Why would
Because you
essentially
elected
I
one
would
test over the other.
be asked to take a test, take that test, then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme.
You'd be familiar with those, wouldn't you,
What's the
sir?
question?
I asked the question, why would I not be given the correct test from the get-go instead of having to take 2 tests.
From
If I've
jump,
already taken,
if you
if
know what
I've
I mean.
already
Mr.
taken one
Brooks,
test,
You have to give her an opportunity to answer, and you
I've
gotta
already-
ask one question at a time.
I just asked the question.
Can she answer it
Should
then?
she let her answer?
Do you want her to answer it?
No.
I presume you do since you asked the question, so you need to stop talking so that she can answer it, okay?
Well, limit your abuse, Your Honor.
I'm sorry.
Limit your
I don't
abuse.
appreciate being talked to that way, Your Honor.
Your objection is noted. Go ahead and answer.
Judge, I would prefer not to answer that question. He states the wrong test. I don't know what he's speaking of. I have not reviewed the medical record with what test was administered, so I would prefer not to answer that question.
All right, fair enough.
I did not say the wrong test. I said 2 tests.
You
If it
said the
was-
wrong test explicitly.
Why would I need to take 2 tests
That's not what you asked.
for the same symptom?
Your Honor, I object to relevance and beyond the scope of this witness's knowledge,
He
and
also
it also
just
assumes a
misrepresented
fact,
his own
not an
questions.
evidence.
He completely lied about what he
I'll
just said.
sustain the objection.
Lie's a little strong there, Nick.
Both parties
just
an
trying.
opportunity to ask questions of this witness.
Lies
Since
strong.
it's
It's just
Mr.
an
Brooks's
untruth.
request, I know do you have any other questions for Jail Administrator Wallenhupt on this issue at this time?
I don't think I was clear, or I didn't have clarity on the answer to that question. Essentially, what I'm asking is, why would I need to take 2 tests for the same thing? There shouldn't. If I'm taking a COVID test, why would I need to take another one?
I'm gonna object as to lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Do you have
I'm
another?
assuming that happens a lot.
Yeah, I'm
different
guessing
question?
you're baffled by your mere
Would it be any
existence.
way to verify why I would need to take 2 tests for the same symptoms?
Well, one would be faster than the other
I'm
one.
not sure. I understand the question, sir. I think
I'm referring to the nurse who administered the test.
the nurse isn't here, though. This is Jail Administrator Wallenhupt.
And that's why it's hard for me to wrap my head around why Ms. Wallenhoff would be called to testify when she was not present. I think the wrong person is
Because
testifying.
your question
Do
was
you have any other
because
questions
the
for
reason
her?
why-
I understand what you're
communication
saying.
form was
Do
about
you have
the
any other
protocol.
questions for her, though?
Are you sure you wrapping your head around what I'm saying, Your Honor?
Do you have any other questions for this witness?
To your knowledge,
Okay, here we go.
you just said that you have a rapid test available right now. When did that become available? Because I was told otherwise.
I know there is a rapid test available right now. As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Objection, relevance.
If she knows, she may answer.
I do not know the
Why would
answer
you-
to that. I have
why would you
not
object to
reviewed
that
the
question
medical
anyway?
record, jail contracts with a medical provider.
Thank you. Next question, if you have one.
She just doesn't want to give him an inch, and I get that. She's probably sick
Yeah.
of him.
So there are more than one type of COVID test administered by this jail.
Again, the jail contracts, Judge, I prefer not to answer that. The jail contracts with a medical provider. I do not direct testing for medical conditions. That would be our medical contract.
I believe the record's clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that
I
he did
object to that,
submit.
Your Honor.
He did submit to a test, but this witness is not able to answer whether that was a rapid or not, given her role in the
Call the
Waukesha
fucking
County
nurse in.
Jail
Like,
as the administrator and not in charge of medical.
Yes, I think so,
she
too.
does not need to answer that
if you're
question.
gonna go through the
because
charade,
it's
she
outside her
should just
scope.
actually rule on
And
his
to further answer it.
pseudo motion to adjourn
might
court
be
and say no.
speculative. So
There's no
do you have
reason
another
to
question?
adjourn this
So
court.
would it be fair?
Yeah,
to
but
say-
she's
you just said it would be speculative. So would it be fair to say that it would be speculative that
Like he's following the
second
COVID
test
protocol in the
would be
jail
a
and at
rapid
the
test?
courthouse. The protocol exists so that court doesn't have to be adjourned because of a COVID case
I will make
because they went through 2 years of
a
that.
determination on your motion after all of the evidence and testimony on this issue is received.
is that an
I
answer?
can't
Your Honor?
answer that question at this
Well,
time.
I'm
sir.
asking it of Ms. Wallenhoff. Is it because we just said it would be speculative?
Well, you
So-
were looking at me when you said that,
Well,
so are you, and I'm not gonna answer that question. I'm not a witness in this.
The
I
reason
make
why I
the
was-
determination
reason why I was
ultimately.
looking at Your Honor is because
You pretty.
We have another
You pretty
question.
white girl.
Jail
trying to figure out
Administrator
how-
Wallenhoff.
You got that good hair.
testimony was supposed to be the prosecution and the defense's time to
Sir,
ask
do you
questions.
have another question? Otherwise, I'm gonna ask the state if they have any more for this witness.
I asked the question, would it be fair to say that it's speculative about what the second test actually was?
Mr. Brooks, I don't understand your question.
What isn't to understand about it? If
Yeah,
You
I'm
were,
raised it
if you
as
were
would it
offered
be
a
fair to
test,
say.
Objection, relevance.
no, it's a question.
Hold on.
I'm
You're
getting
asking
some-
a
I'm
hypo-
going somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might not be qualified to answer, but you can go ahead and ask it.
Well, it's not hypothetical. It's very logical. If you were offered a test and you took it, why would you need to essentially take another test that could have been done right from the beginning? If there would be any issues, if there would be
Right, Mr. Brooks, it's not relevant what she would do. So that's essentially an argumentative
Okay, so
question,
why-
and
so
it's
why would I
not
do it?
relevant. So
why would
sit
I do it
down.
then?
But you're not her,
You're done
bro.
asking questions because you've
So
now
is that a
asked.
judicial
Run into a crowd of
determination?
I
children
haven't made a
with an
judicial
SUV.
determination yet.
You're
Go ahead,
practicing
Attorney
law on
Opp.
the bench by being able to ask
Mr.
certain
Brooks?
questions of yourself.
Mr. Brooks, okay, here's your warning.
Bro.
I'm giving Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you
The
interrupt
court
her,
has
you will be
the
removed to the next
ability
courtroom.
to
I don't consent to
investigate
being removed to the
questions
next
of the
courtroom.
court.
I don't consent to even being at these
Of course, has the
proceedings
ability
if
to
I'm
control
not
itself as
able
well.
to put on a proper defense, which is my constitutional right to be able to do so.
Oh,
I haven't
careful
agreed to
saying
any
proper defense,
contracts. I
brother.
haven't consented to any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to
Ms.
an
Wallenhoff,
estoppel.
although Mr.
Not
Brooks is
conducted to-
under a
consented to
COVID
estoppel?
protocol, is he still
I
allowed to
think he's
review
enjoyed your
discovery
territory.
materials in his jail cell?
Yes,
Jay, for relevance.
To your knowledge, are those materials?
Well, he objected.
The objection overruled. Go
I'm
ahead.
sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
yes, ma'am, to the best of my knowledge.
Okay.
Is he still
object to
able?
that, Your Honor?
You don't get to
I'm not
object
allowed
to
to
the
Her
be-
answer.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be
objection
able to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You
Jessica, can I explain what
No.
he's
I am
asking or
turning to
wanting?
Attorney Opper.
He
It
wants
is
to delay the
her
trial.
opportunity,
Yes.
her turn
That's the answer. What he's
Yes.
asking is
to
unintelligible.
ask this
Yes.
witness a question.
For how long? For as long as
It's
it's
my
long
right to be
COVID
able to object,
persists.
just like she objected
And-
when I was asking
Right,
questions.
and when the court rules on an objection, usually the party who
Right
objects
now,
Give
he
him
stays
wants
credit. He's
to-
silent.
trying. I'll
He
give him
wants to
credit.
object
I
to the
rule on the
answer that
objection.
the person gave,
The parties don't
You
debate
sometimes
the
can.
ruling.
but not in
It's
this
noted
case.
for appeal.
Yeah.
It was a
and then
simple
we
fact
move on.
question.
Then I would
Is
like
this
to
here?
put you
She
on
says
notice
yes.
that I will
object.
be appealing
What?
that judicial decision that you are making.
Next question, Attorney Opper.
You put the judge on notice.
Yeah,
Pulling
hold on,
up.
I'll be right back.
Yeah,
While on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also
Conference.
contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've
I object to
indicated
that.
three.
I object to that respectfully, Your Honor.
So
What are
an
you
objection
objecting to?
goes to whether there's lots of rules of evidence that
Yes,
apply.
yes.
But if you're objecting to her answer, that's a different thing. You can argue
I'm
the meaning
objecting
of
to
that
the
later.
question,
Okay,
not
the
the
objection.
answer.
But then you have to say objection before she answers. You
She
objected
didn't
after
answer.
she
She
answered.
didn't answer the last
The
question.
objection is noted. It's overruled. Her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks
Digital.
for him to view in the Waukesha County Jail,
I
correct?
respectfully object to that.
Overruled. She may answer.
Correct.
He
Digital
would
discovery in
view
jail
that
is not
digital
always
discovery
pleasant.
on the
So we know,
computer in the
so we're
conference room in his pod,
I
correct?
respectfully object to that.
Overruled. You may answer.
Correct, ma'am.
And
So you're gonna
the proto-
overrule everything, Your Honor?
Oh,
All right, Mr. Brooks.
Get
You have
removed.
got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has the criminal
I
statutes.
don't see it.
It has the traffic code. It
I
has
don't
the
see
rules
it.
of evidence. Well,
Where?
it's
There's no
on
book.
your
I can't see
table. It's
nothing.
behind the microphone, and it's there. I've provided it to you as a courtesy
No, you
so that
didn't.
you have that
You did
available
not
to
provide
you.
anything to me.
Right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
something
I've
that-
provided ample
I've
opportunity
never-
for Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum.
anything,
and
Your Honor.
civility.
That's a big boy.
Your Honor, I
Woo!
don't
He is-
consent or agree to what you are doing.
Your lack
don't
of
give
consent is
consent.
noted
That's a
for the
whole bowl
I
of
record.
don't
brie
give
cheese,
consent
man.
to an estoppel. I don't.
I'll
give
make a more
consent-
full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
from
Reporter,
being
the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off.
I
if you
move.
want
I
to
move
remain.
for a motion to dismiss. You still haven't even ruled on the claim.
He
There's
moves
no one
for a
that
motion.
has a claim against me here.
He moves for the motion to dismiss. So he's moving to get a motion to dismiss. Wow. Okay. That, that bailiff looks like Hambley's like brother or something. Okay, so what you have witnessed here is the utter catastrophe that is the sovereign citizen approach to courtroom demeanor and decorum. You can say a whole bunch of magic words and phrases. I do not consent to estoppel. This is joinder. I do not recognize any provision. I do not consent or accept any document you have placed before me. I don't recognize that the book on the table, literally one millimeter away from my eyeballs, exists. I don't see the book. In fact, I've never seen a book in my entire life. None of that actually matters. Like, because the record is clear that it's there. It's on video. This is definitely, by the way, one of the reasons that video is critical and should be in every single courtroom in every single case. Video and transparency of the courts is something I'm pretty passionate about. One, because I'm self-interested in making money off of them. Two, because I guess here, I'll take this off the screen for a little bit until we get some more action back from the court. Two, because it protects the people from judicial abuse or abuse by the state. And three, because it protects the citizenry from lies by people about the abuse of the state. The court is being overly deferential to this dummy today and engaging in really frivolity for frivolity's sake, just in an abundance of caution and giving him the opportunity to get his questions out.
Yeah, I'm back. So did he kick her out or what happened?
Yeah, she kicked him out. So while he's being removed, where oh wait, it's a copyrightception. Oh yeah, nailed it. Oh, that makes me unreasonably happy. We're gonna leave
speaking
that
of-
up.
Speaking of those, I didn't know if did you ever see what came through? Hold on, I gotta save this.
You missed it. He did move for a motion to dismiss. He didn't motion
Hey.
to dismiss. He moved
Mhm.
for a motion to dismiss. So that was good.
Yes. Hey, he's trying real hard. I give him credit. It's not complete rambling.
It's not complete rambling,
close.
but it's close. The problem that I have with it is less like the incoherence of it, because
Mhm.
look, oh wow,
You also have the right.
Post-deal hearing, yeah.
they adjourned it, or they killed the video feed.
Oh, they're probably till they come back.
Probably. See if Court TVs is up.
Maybe they got struck by
Coming soon to
That would be hilarious. Oh, here, let me remove that while we do that. Okay, not seeing it. There was another YouTube channel that had it. But shit. It's gonna be way
Yeah.
back in the locals thing. Does anybody have in the locals chat, does anybody have the link to that
There's probably a local affiliate doing this too.
yeah, the local affiliate video? And see, I wanted to see if they're still up.
But no, I shared you something though. Speaking of Court TV, actually, I was down there on the weekend in between the trials for a funeral, and I stopped by and took a picture.
Why do you have a Jack Murphy beard?
Well, I had this up on my community page, and apparently somebody in your Discord worked it over. I thought it was pretty good.
That's amazing.
Oh, I thought it was good.
Oh my god, that makes me happy.
I still like my beard better though.
So the
Now-
okay, go ahead.
Yeah, you were going back to the jury selection thing. If she was this deliberate on the record, then I'm not worried.
Yeah,
If she went through it like this, then okay, you're completely refusing to pick somebody. You're not going to do it. Then we have to assume you're waiving it.
right. Like
But if she wasn't, I mean, even then, the idea, the most likely thing that would happen is he'd probably get a new trial before
Yeah.
the court would cut him loose.
oh yeah, they're not gonna
Yeah.
like rule that his rights were severely impacted in that way.
Yeah.
Let's see. Let me check TMJ4 news.
So, but yes, as
Oh,
long
they
as she
still
did
have
it this
the-
way, it should be good.
They still have it up.
Mhm.
So, all right. So I've got that here waiting from TMJ4 News, and we'll see. We'll see what happens. I can't wait for Long Crime to try and copy strike.
That would be great.
I would love for them to give that a fucking shot. Okay. There's issues here. It's not completely unintelligible. The problem is this entire thing is engineered to achieve the result that he's achieving, sort of.
Oh yeah, without
Delay.
doubt.
He just wants to delay it as much as possible. And so like he is trying, but he's also being intentionally obtuse and retarded, frankly, like for the purpose of doing that. It's an act. It's a show.
Yes.
Like no one thinks this guy looks at a book that's sitting right in front of him saying that book not there. Like, dude, stop. I don't recognize the name Darrell Brooks. Like, I don't recognize my name. Like, he goes by Darrell Brooks everywhere he goes and on every form he ever signs and everything he fills out. But he's a different Darrell Brooks than the Darrell Brooks they're talking about, because that is Joinder or something.
Yes.
He's the corporate
We
representative
continue.
of Darrell Brooks.
The record should reflect that, and at the moment, Mr. Brooks is muted, so I can appropriately make my record here today. I will promise to unmute him when we continue with the hearing after I make my record regarding the removal, assuming he can maintain even the simplest of civility and not interrupt other individuals
Yeah, see, this
in
is
a
the
way
thing. It
that
gives
is
her the opportunity
disruptive
to
and
mute him
disrespectful.
when he's talking over and not listening.
And I
Empty
do want to
chairs and
initially
empty
confirm,
tables.
I know I could hear him until I muted him. I can see him. Can we please get confirmation from the other courtroom that the audio and visual is working?
By the way, guys, check
All
out
right, and we
Sean's
do
channel,
have
Potentially
confirmation
Criminal,
of that as well.
on YouTube. You can do so by
Prior
going
to
to the description right now.
the court
and clicking
ordering
on Potentially
Mr.
Criminal.
Brooks removed
It'll take
from
you right
this
to his-
courtroom to
his,
the
YouTube page.
neighboring courtroom. There were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom.
Here, I'm going to turn it down just a hair.
I have cited repeatedly from Illinois versus Allen, which is the Supreme Court case from
On the
1970,
10th
which
interruption,
provides
Mommy Judge gave to
this
me.
court with the authority to remove Mr. Brooks from the courtroom. Because it is a new day, I think it bears repeating much of the language that is directly on point in this decision. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. This is the Supreme Court stating, "We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least 3 constitutionally permissible ways for a trial judge to handle an obstreperous defendant like Mr. Brooks."
Obstreperous.
In that case,
That's
they
a
were
good word.
talking about the defendant, Mr. Allen. And here are the 3 options, at least that the Supreme Court acknowledged. But I would note, as they just said in this prior quote, there are at least 3. 1, bind and gag, thereby keeping the defendant present. 2, cite the defendant for contempt.
Bind and
3,
gag's a little
take him
hot.
out of the courtroom until he promises to conduct
Chat, would you want
himself
Mommy Judge to bind
properly.
and gag you?
Yes, just a little
This
bit.
court has repeatedly utilized the neighboring courtroom because I believe that provides Mr. Brooks with an opportunity to meaningfully participate in these proceedings while this court maintains decorum, dignity, and respect. It is an elementary standard of proper conduct to not interrupt. Mr. Brooks repeatedly interrupts. I gave him 9 warnings before
Objection.
I removed him to the other courtroom.
Oh.
As the court did in Allen, this court decided that under the circumstances to remove Mr. Brooks from the courtroom and to continue the trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom, that this is the proper response to his conduct. As noted in the Allen decision, the court stated, "We find nothing unconstitutional about this procedure." This is now the 3rd day of the trial. We struggled at times through jury selection with multiple
I need to screen grab him holding up that
interruptions,
sign because you
what
can
I
take
would
out
describe
objection and
as
say anything.
disruptions. So it's with that history
Yes, you could.
came into court today. Mr. Brooks persists in his unruly conduct. I would note, just as the court
Just declare him incompetent.
it's not pleasant to
Seriously,
hold or to
do it.
find that Mr. Brooks
I don't want
be
her to,
banished from this
but she should.
And this is what the Supreme Court went on to say, but our courts, palladiums of liberty as they are, cannot be treated disrespectfully with impunity, nor can the accused be permitted by his disruptive conduct indefinitely to avoid being tried on the charges brought against him. It would degrade our country and our judicial system to permit our courts to be
she's in, like,
bullied,
inspirational
insulted,
voice. I love
and
this.
humiliated, and their orderly progress thwarted and obstructed by defendants brought before them charged with crimes. As guardians of the public welfare, our state and federal judicial systems strive to administer equal justice to the rich and the poor, the good and the bad, the native and foreign born of every race, nationality, and religion. Went on to state, but if our courts are to remain what the founders intended, the citadels of justice, their proceedings cannot and must not be infected with the sort of scurrilous, abusive language and conduct demonstrated by not only Allen
I've never heard
in that case, but by Mr.
before.
Brooks in this case. I've also cited repeatedly to SCR Chapter 62, which contains the standards of courtesy and decorum for the courts of Wisconsin. I've advised Mr. Brooks repeatedly. I've had, just as I am holding a copy of Chapter 62 on yellow paper laminated, I have it myself. I provided it to the state. I provided it to Mr. Brooks. And those standards govern what I do, what the attorneys do, what lawyers, clerks, court personnel, even witnesses, defendants, jurors, and others appearing in the court. Two of the subdivisions specifically talk about the expectation that within the courthouse, that those involved in the proceedings refrain from creating disorder and disruption. Another subdivision of that section discusses the expectation that those within the courts conduct themselves in a manner which demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. Once again, it did not take Mr. Brooks very long to begin interrupting. It is 2:39 now as I go through this decision-making and put my findings on the record, but his behavior started very early on. I gave him ample opportunity to abide by the rules of decorum. I gave him ample warning before he was removed. This court, frankly, has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings. With that, I will turn back to Attorney Opper. I am going to unmute Mr. Brooks, but also advise him that if he interrupts Attorney Opper or others as they are providing testimony here today, I understand he can object. However, my expectation for that objection process would be that he say, I object. He provide a basis. I oftentimes give parties, give me one word. Is it hearsay? Is it, calls for speculation? Is it irrelevant? Whatever it may be, a very either 1-2 word objection or a very short summary statement of the basis for his objection. After he does that, I will rule on the objection, and I expect him to honor the ruling that I have made. If he can't do any of that, he will remain muted, and the process will then be, we've given him a sign. He's holding it up right now, demonstrating for us. He has the objection sign. He will be required to write down his objections on a piece of paper that will be provided to the bailiff. The bailiff will provide it to me, and then I can rule on those even if it's striking testimony later on. I do expect
Ooh,
his
that's
objections to
interesting.
be based in law. I note, was provided with the copy of, it's a selected statutes, including the rules of evidence. All right, go ahead, Attorney Opper, for the record. The mute has been undone.
Thank you. So Ms. Wollenhaupt, I was asking you about the digital discovery materials. You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask
Pad?
for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold on a
about,
second. Mr. Brooks, the basis for your objection at this time?
That is irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize conference room for a tablet.
Your objection is noted. It's overruled. Her answers may stand. Next, you may continue, Attorney Opper, with your next question.
the nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer.
Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would
gonna object to
restrict his
every
ability
question.
to come to court each day?
Objection.
Overruled.
Correct, ma'am.
You have to provide a basis for your
And
objection
when he
still.
comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that
These are
correct?
leading questions.
Objection.
I don't know if this is
Overruled.
technically cross.
Correct, ma'am.
Sean,
And
any idea?
In fact,
Like,
there's a card available for him.
It's no leading, but these aren't going to the fact of any matter. So
Overruled.
this is merely,
That is
Judicial
correct, ma'am.
efficiency.
Correctional officer.
yes.
Transport.
And this doesn't,
are available.
no
Sure.
bearing towards his guilt or innocence.
yeah, I've got long. or I've
Mr.
got
Brooks
sword
had
and
told
scales,
this court earlier that he started
picture.
feeling
shorten
not
it
well, I believe were his words, over the weekend. And is there any notice to any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second.
This is
Was that an
hypothetical.
objection
That should be an
or just
objection.
a comment under your breath?
She shut down his hypothetical.
Yeah.
Your objection's noted. It's overruled.
What? Ah, man, bro, get better. She's about to ask a
if
hypothetical
he were
question.
to complain of illness to a correctional officer or a lieutenant, would
Objection
they
speculative.
document that in any way?
They would give him a medical request form to fill out, which would go to the medical department where he could have contact to medical staff, or it could be documented in the jail management system.
To your knowledge, was that done by Mr. Brooks last weekend, the weekend of September 30th and October 1st?
Not to my knowledge.
And are you aware of the fact that last weekend, on or about Saturday, he requested a shower and a shave?
Ooh.
Yes,
No shit.
That provided to him.
yes.
Wait, on Saturday? That's the last time you had a shower and a shave?
If
Bruh.
you weren't on a protocol, would he still do
Oh,
it?
man.
Or does it
No, the
depend?
jury
It would
is not
depend
present
what type
today,
of
Lewis.
protocol.
Okay, thank you.
God help them if they were.
Those were all
I
my
don't think
questions.
so.
Thank you, Ms. Wollenhaupt.
All right, Mr. Brooks, do you have any follow-up questions for Ms. Wollenhaupt?
I do. You stated that it would depend on what type of protocol I was on, would dictate if I'm able to shower, correct?
That was not completely what I stated.
Well, that's what you just stated on the record.
Well, different management protocols, it would be in accordance with jail operations. And my preference, Judge, would not to be to speak to all of the jail operations.
Right, I'm not going to require her to speak to all the jail operations. If you wanted to ask her, for example, whether your current protocol would prohibit that, I think that would be a
The
fair
reason
question.
she's not having her answer this is because safety and security of the
That would be
jail,
question then, would
Mhm.
revealing all of the
Well, no,
operations and
let
different
me ask
protocols
this.
could put
What
inmates and officers in
specific
danger.
protocols would prohibit
Yes.
being able to shower?
Objection, irrelevant.
I'm not going to, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols, given the operations of the jail, but you may ask her if there's something specific as to you.
Well, because of my situation being a little bit unique, with any protocol that I am on currently prohibit me from being able to shower and or shave
There you go.
Do you speak moving forward?
as of right now.
Answer the question.
You would be allowed to shower on the protocol you're currently on.
Would I be able to shave?
You would be able to shave.
Would you shave me?
Would that be with the clippers or a razor?
Objection, relevance.
Overruled, she may answer.
Mr. Brooks, we would monitor behavior and other factors in that and make a determination. There's procedures operationally in the jail that you can request those items. And
So
you
that would be independent of the COVID protocols.
correct, ma'am.
So to your knowledge, are you aware that we are only permitted, and I'm saying myself as well, being housed in the jail, that we are only permitted razors once a week and clippers only once a month?
Judge, I would prefer not to answer questions in regards to jail operations.
Right. I'll honor the request of the jail administrator. It goes beyond the scope of this hearing. She need not answer general questions about the general procedures and protocols within the Waukesha County Jail. We're a little far field. I gave you a little bit of leeway, but we had started this off about COVID protocols and your current situation. So
But I want to know about my next shower, Judge.
From my perspective,
Too long.
Small pass is bad.
discovery materials and all of that were relevant because you claimed you weren't being allowed out to a conference room.
It's still unclean movie.
That to me implicated your ability to prepare for your defense in this trial. So that's why I allowed those questions. Whether you shower or shave would, in my humble opinion, not be relevant to the issue of whether you can assist in your own defense.
Was she wearing glasses earlier? Or is that new?
Yes.
Brought
Oh, she's been wearing glasses.
Okay.
It was brought up about the whole issue of being able, me requesting to be able to shower and shave, so that's why I brought it up in my question.
I understand it. I'm under my authority under 906.11. I'm going to advise
She say
both
9 and
parties
11 in the
that
same sentence?
anything regarding those types of things are not relevant, and I won't allow questions from either side regarding that any further, at least today on this particular issue.
Thank you, Your Honor. I would want to make one correction for the record. I never claimed not to be able to have access to certain things. I merely claimed that I am on a protocol which limits me even more than I'm already limited. I made no reference to anything in specific, just the fact that I'm on a protocol which restricts me to my cell until the test can come back.
I appreciate that clarification, sir. Thank you. Do you have any other questions for Ms. Wollenhup?
Yeah, a couple more.
Okay, go ahead.
Oh my goodness. About what?
Would you care to share with the court on record?
What if she just says, no, I wouldn't
types
care?
Of protocols that I am currently on outside of the COVID protocol?
Objection, irrelevance. Goes to jail operations.
Sustained. Next question.
I think the jail lady's gonna have to answer
Does my
that.
specific
She should
protocol
make that objection.
change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm going to have her not answer that as it goes to.
Well, that directly goes to that because as we know, I'm only on a protocol where I'm only allowed out of my cell a few hours a day as it is.
You don't need to be out of your cell to have access to the
my cell because of
materials.
the COVID protocol.
Yeah.
The question I'm asking is, does that restrict even the time that I can be able to be out to utilize the things that I need? Because
that's not a question for the court right now.
Essentially, I'm only limited. I'm already limited.
Can I ask?
There's times.
I want to make sure I follow you, Mr. Brooks. So I'm sorry for the interruption. If I hear what you're saying correctly, you may have a belief that your access to certain things that would impact your ability to prepare for this case is impacted by the COVID protocols. Is that a fair assessment of what you're trying to convey?
I would say that would be accurate in a sense.
And so if we ask the jail administrator that specifically, is there anything about the COVID protocol that would interfere with your ability to have access to materials or a room? Is that a question you would want answered?
That would be good.
All right. Do you understand what he's trying to
So what
ask?
I'm understanding is, obviously, Mr. Brooks is allowed to keep legal material in his cell. He will remain in his current housing location. Access to the conference room, it will not change that, which is outside of his housing unit. And access to the phone could be granted upon request in the day room area.
All right.
So I do not believe the protocol limits his access to legal material.
Thank you. Do you have any other questions?
Yes, I do. As far as she just referenced the telephone. To the best of your knowledge, are you aware that there is a certain time that the phone will be available? You have other inmates that.
Let's not talk about other inmates, but are again, I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking.
Okay, let me ask it another way.
Okay, go ahead.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have regularly, would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask?
I guess I'm unclear as to the manner you speak of. What are you referring to?
This is a clever way to get to talk to jail administration, though. It's normally not this easy.
Are you trying to ask her?
Are you aware?
I've never seen this happen like this.
I know you are.
This man is playing.
Man
is playing regicide.
This is him floating kites in court, basically. Why can't I use the phone?
Utilize the phone at certain times of the day. With the COVID protocol, prohibit that any further.
Mr. Brooks, are you trying to ask whether the COVID protocol impacts your phone privileges?
That's what I just said. No, not in the sense, because I think it's more accurate with the way that I asked it.
But your question assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what.
Is it really outside the scope of this proceeding? I don't think so.
Your ability to prepare for this case.
You let him open the door here, Judge.
You're questioning in that way.
Well, can we at least make a clarification on the record that the reason why we're having this didn't have anything to do with limiting my preparation?
So
that wasn't the real issue.
I think it's related to the.
I just wanted that clear.
I understand.
That's all.
I understand what you're saying. I respectfully disagree. That's why I've allowed some of the questioning. I believe it's relevant to the motion that's before me for this court to know how the COVID protocol specifically impacts you and your ability to prepare for this case. I understand you might not be claiming the latter to be an issue, but nonetheless, I think it's appropriate for the court to consider those things. I heard the jail administrator indicate that the phone privileges would still be available upon request. And I guess to the extent that that's different, if at all, from the standard protocols that you're under, I would accept that as an offer of proof from you.
Well, I didn't agree to that, but the reason why I brought it up was because I've been on outside of the COVID protocol. The protocol that I've been on for a very, very long time. So
you've been on the protocol for like a day.
It's limited to certain hours of the day, which works out.
All right, Mr. Brooks, we're getting a little far field. I need to make a determination on your request. So I'll ask you one last.
You haven't let me finish what I will.
Mr. Brooks, I will ask you one last time. Do you have any other questions for the jail administrator? Because right now you're talking more about things you would provide. So if you have a question that's relevant, please ask it.
I didn't say anything I would provide. Where did I say that?
When you provide information through just a statement about things, that's not evidence, right? The witness on the stand is providing us testimony. Testimony is evidence. Not that I wouldn't accept certain statements from you, but also understanding the state has the ability to challenge those by asking questions of the jail administrator or other individuals so that I can make a determination today on your motion. With that, Mr. Brooks, do you have any other questions for the jail administrator?
Well, everything you just said still speaks to not understanding that I have, Your Honor.
Mr. Brooks, one last time, do you have any additional questions for the jail administrator?
Your Honor, what you're doing right now is you're not
This is-
right now.
All right, Mr. Brooks has not answered.
This is
He's in-
so,
Mr.
like,
Brooks, I need to
outside
make
of
a
the
ruling
scope
right now.
of
Please
any
stop.
of this.
He's not answered my repeated question as to whether he has any additional questions for the jail administrator. Unless there's any further questioning from the state based upon the additional questions that were asked, then I'm going to have her step down.
I just want to ask of the court if
What?
you're intending to take up his inmate communication form that was dated September 28, 2022
Oh yeah,
as
she mentioned
well.
this earlier. That's right.
While Ms. Woolen
Yeah.
on the stand, I just have a few questions related to that, Your Honor.
I object to that. What does it have to do with what she's testifying to right now today?
Judicial economy, dude.
They're two separate issues.
You're not going to call the witness back up to the stand on the next
Yeah.
issue.
I do have the document number
Yeah,
258.
that's done. Nice try. It didn't work, Darrell.
Hold on, Mr. Brooks. I need to find the document in my
Let me
record.
try and read a super chat or
258, you
two.
said?
Yes.
True non-shop at Bad Pressure Bad Calf Care says, glad you enjoyed the meme my hubby sent me. You definitely have my permission to share. Thanks, Rackets. You're welcome. Might share it later. It's a great meme. I died laughing looking at it. So
I'm just going to print that off for ease of
Afro Fry Cook says, I was slightly
my
tempted to
reference. I am going to allow the jail administrator to be questioned regarding document 258. I don't know if Mr. Brooks has a copy of that in front of him or not, so I will print it off in that courtroom so that he has that.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today.
This issue was raised today
How
also.
these are two separate issues.
The court recognizes that they're two separate issues, but I also have the authority when considering judicial administration and economies of scale, shall we say. We
Not
have the
economies
jail
of scale,
administrator
just
here.
judicial
It's an
economy,
important
please.
housekeeping issue as we go forward. And so I'm going to
economy of scale
address
here
it
is the
after I
scale of
address
one court.
the motion to adjourn that you filed, but since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Your statements noted of record. All right, go ahead, Attorney Opper.
All right, Ms. Wollenhop, I don't believe you have the document in front of you, but thank you,
The
Judge.
record to reflect, I'm handing her a copy of what is in the record as document 258.
Thank you, Judge. I'm sorry.
That's okay, I'll print off another copy for myself.
Okay.
Afro Fry Cook says, I was slightly tempted to file one myself. Complaint.
Can someone confirm whether
Ethics
that
complaint.
document was given to Mr. Brooks as well?
As
I
an
did
obvious
print it to the
joke.
printer over there. I have that ability.
Like he shouldn't practice because his nose is too big and he'll
It
literally
was. All right,
inhale
thank you.
clients.
The record to reflect.
Decided
she has
not
also
to,
been
but it would have been
provided
funny.
with a copy of docket number 258.
That would
Funny.
have been funny. That would have
That
been
would
good.
be good.
I'm not acknowledging
Don't do that,
document,
please.
Your Honor.
Don't
They'd have
waste
to
your time.
investigate that.
I don't consent to
That'd
it.
come
All
down
right,
to measure
because
phrenology on your skull.
Mr.
They'd find it would
Brooks,
be
it's
true.
a document you
Yes.
filed. So,
That would be horrible.
and it's a document that was filed through the inmate communication form process. It was scanned in on October 3rd, but it's dated 9/29, and it's directed to either clerk of court / Judge Doro. So go ahead.
Thank you. Ms. Wollenhop, you've seen a copy of this document previous to today, correct?
Yes, ma'am.
And you're aware that it's dated September 28, 2022,
nice.
correct?
Correct.
And purports to have been written by Mr. Brooks himself, correct?
Correct.
Stay classy.
And
The
in
jury's in
this,
tomorrow at 8:30 a.m.
Communication to the court, Mr. Brooks indicates that he is on a quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form, near the bottom, the last two sentences, he indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Correct. That's what he states.
Okay. Is that a
Calm
truthful
down,
statement?
Please.
Well,
It
let
is.
me ask a different. That's a bad question.
Oh my God,
Let's
chill
break
out.
that
Sue.
Did Mr. Brooks have access to his legal materials during the time that he was under a keep separate order?
Yes, ma'am.
They've already ruled on
Again,
this
that would
issue.
be the
The issue is that
banker
he had
boxes of written
adequate
discovery
time
in his
to
own jail
review his
cell?
discovery. This was ruled on days ago.
Correct. Anything that was in
Why are
his
we
jail
back on
cell,
this
he would
issue?
have access to.
Okay.
And he would also have access to the conference room and a tablet
And the
in his
tablet.
cell.
Okay. And that's the legal materials that are provided to him are on that tablet and on the computer in the conference room.
Correct.
And nothing about that keep separate order affected his ability to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail administrator?
Yes, I do.
Shocker.
You just stated on record that I had access to all materials for trial prep during the time of this keep separate, correct?
It doesn't specifically say what you don't have access to. So yes,
No, I
what was
said,
in your
did
cell.
you just say in open court on the record that I in fact had
For the
access
record.
at the time of this keep separate?
In open court.
2 items in your cell, and you could have access to the conference room to view electronic legal materials.
So am I correct in saying that when you brought over these discovery materials to the pod, that I was in fact in one of those conference rooms and I talked to you face to face, is that correct?
You were in a conference room and we spoke.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
I specifically told you that I was on a keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about.
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you that I was going to keep separate and that was going to hinder me being able to prepare. Is that correct?
I do not recall that.
Doesn't matter if you said that though.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So is there a way to verify when the keep separate went into effect?
Objection relevance. Well, hold on. Mr. Brooks, as I read this inmate communication form, and perhaps it's just a simple question, when you wrote it, did you have access to the banker's box of materials yet?
No, I did not. Ms. Wallenhoff just testified the last time that she gave testimony that she brought the discovery materials over on Thursday, the 29th. She did say that in open court on the record.
Yeah, she said that previously.
This inmate request was written on September the 28th. At that time, I was already on the keep separate protocol, which does not allow me to come out of my cell.
But is the issue the keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
The keep separate protocol in itself, Your Honor, restricts the two people that have to keep separate from being able to come out of their cell until one of them is moved. Whether that be to another unit in the pod or a different pod, that part I can't speak to, but neither of the parties are able to come out of their cell until someone is moved. And the reason why I wrote, initially why I wrote it was because that stops me from being able to shower in the unit, because officers would have to
Showering has nothing to do with your access to discovery materials.
Part of the jail sometimes.
That's him just complaining.
Your shower is what they call it, which is downstairs.
Sir, I'm just going to stop you because I honestly, the whether you have a shower or not is not relevant to the issue of whether you had access to the materials you need to prepare for your case. So I read this inmate communication form, especially that very last sentence. I am respectfully asking and requesting that my trial be slightly delayed as I have no access to the materials needed to prepare for trial. Thank you. So my question to you is, and I think you've already answered it, but I want to make sure, at the time you wrote this inmate communication form, the materials had not yet been delivered to you. Is that your testimony?
The boxes that were brought over had not yet been delivered. I had already had maybe 10% of the discovery materials that was provided to me by my former attorneys on this matter.
Right.
That in itself was very, very voluminous.
Voluminous.
We had a prior hearing related to the access provided to you and when the materials were provided. You may recall that Attorney Perry even testified over Zoom audio about that. The jail administrator testified as well. To me, that record is very clear that the materials that were provided by your defense attorneys following their discharge on your case were received by you on September 29th of 2022. That has been established. No one is disputing that. So that's the record that I have before me. I understand what you're saying about the keep separate, but also at that hearing, it was made very clear to everyone that the jail administrator gave some specific directives as it relates to you and access to certain things.
I do recall that, Your Honor. And one of the questions, if you recall, one of the questions I had about what you just said was, did all the officers know about that specific order? I guess it would be called. I don't know what it was exactly, but the information that was to be passed down from Ms. Wallahouse to the officers.
Right, and I'm not going to revisit that because you were given ample opportunity when we first addressed that to ask questions and to provide other information, meaning statements from yourself. And the clear record from that is that the information was put into the jail management system. It was documented, and that the jail administrator had no information to suggest her employees did not have that information and honor that information. There was no testimony from anyone else to suggest that that wasn't followed. So
this is such an irrelevant issue.
I would like to say something for the record now.
Oh my God.
Oh no.
To speak to what you
What
just
now?
said on that, it's possible that all officers were not aware of that.
But it doesn't
I
matter.
even
Did you
talked
have
about this
access
with
to
an
the
officer
material?
Yeah.
Last
What-
night that wasn't even aware. And his answer was that he had been off for a few days. So to his knowledge, he wasn't aware of that. And that issue came up because I specifically asked to utilize a tablet.
Got an axe.
So in my mind, that would say to me that I'm not trying to argue if the order went out to the officers. That's not what I'm disputing. I'm just disputing the fact that every officer that works in my pod is aware of that.
all right, thank you. Any questions at this point for the jail administrator? Again, not related to the shower, but related to access to materials.
Oh my God.
Does a keep separate protocol, Ms. Wallahouse, does a keep separate
What the
protocol
fuck, bro? Come on.
restrict inmate movement in any way?
Objection relevance.
Sustained, overly broad,
You already, it was already
Next question.
sustained. You didn't need
or
another.
rephrase.
Or did the judge say that?
Does being on a keep separate protocol,
I don't know who said that.
or rather, should I refer to myself? If I am on a keep separate protocol, with that in effect, limit me to only being in my cell and being able to only utilize what I would.
The question is
essentially
not
have in
would
my
it.
cell.
The question was, were you?
That's
Were
a
you
compound
limited?
question, so you have to break it down one at
My
a time.
God.
So rephrase.
Why are you letting him ask a hypothetical about what would happen? It only matters if he had access to the discovery. You've already ruled that he did.
Arrangements can be made.
And this does not affect the record. She needs to stop it and move on from here.
Judge, I would prefer not to answer that. It's due to jail operations. We would look at each individual in each situation. I think it's overly broad.
Mr. Brooks, I'm
Why?
going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this protocol limits you, specifically as it relates to access to materials needed to prepare for trial. Not generally whether you're on any kind of restriction, whether, but how, the focus is how this impacts your ability, if at all, to access materials needed to prepare for trial. Other than we've established that you didn't have the materials from your attorneys that were provided after they were discharged by the court until September 29th. I mean, we've established there was a gap, right? I granted the motion and allowed you to represent yourself on the 28th. That was a Wednesday. And then the materials,
Seriously.
even though they were turned over to the jail, it sounded like in the evening on the 28th, there was protocols in place to go through that. And then those were provided to you on the 29th. That is well established on the record. So I understand that.
So move on, Judge.
Yes,
we've
you're
addressed that
not
in part
protecting your record now,
previously.
Judge. This is
I know the
asinine
state wants me
now.
to address this, and I think I know the reason why. But if there's any question you want to
Answer any question
ask
if
the
you have an idea.
administrator about what was going on the 28th or 29th, or even going forward, that would impact your ability to have access to these materials, that's the type of questions you need to ask, okay?
Well, I asked the question and I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was going to keep separate protocol at that time?
It doesn't matter.
That's been answered.
Sustained. The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir. Next
I
question,
don't
please.
recall.
That's why we say fuck off.
That's
Yeah.
a specific question.
Next question, please.
Hey.
Can you provide for me where she answered that specific question?
Mr. Brooks, do you have another question for the jail administrator?
Is it going to be answered? Is it going to be
It
honored?
was answered on the
The
record.
record speaks for itself, sir.
You'll be provided with the
Well, if the
answer.
record speaks for itself,
Request a copy of the transcript. You'll get it in 2 weeks.
then that question should be able to be answered. Were you aware, Ms. Wallahoff, that at that time, I was on a keep separate protocol, that it was already in the system that I was on that protocol?
What date are you referring to, sir?
The
date
29th.
That you brought over the discovery materials. Were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recall the discussion you were informing me.
But that's not the question now, though.
I was aware.
The question is the day that you brought over the discovery material. Were you aware?
Let's go down the
at
logic
that
chain.
time
If the answer is
that
yes,
I was on a
so
keep
what?
separate
If
protocol?
the answer is no, so
I
what?
can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what date that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
So
I
again-
seen no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he has
Mr.
had
Brooks, we're
access to.
far afield from the issue at hand. So I'm going to ask you one last time. Do you have any additional questions for
The
the
issue is,
jail
do you have
administrator?
access to discovery
Wait.
materials? When you're delivering my discovery
Wait.
materials, are you aware?
What are you allowed and not allowed to do on a keep separate protocol?
It doesn't
Relevance.
matter.
Sustained. All right, then I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
Mr. Brooks, I'll give you one more opportunity then. They need to be relevant. They need to be within the bounds that I've already
If he's got a complaint
discussed.
against the jail, it's
That
a
was in the
1983
bounds.
claim.
No,
Go
Yeah.
for it.
The
Yeah, it's
issue
gotta go to
is
federal
limited
court.
to the impact of the keep separate on your ability to have access to materials needed to
Yeah,
prepare
but-
for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or she was directed not to answer that.
Mr. Brooks?
So how can-
They weren't
how-
relevant.
the
Mr.
question
Brooks,
that
you
I-
indicated you had
Well,
other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another
Well,
question?
would I be allowed out of my cell on a keep separate protocol?
It's vague, Your Honor. The question is, was he allowed out of his cell to access his legal materials?
That's
Yeah.
not what I asked.
That's
Right, the
not what I
question you
asked.
asked, the objection is sustained. If you'd like to ask the question
Take the-
suggested by Attorney Opera, that would be permissible by the court.
Throwing a bone to
So
him.
I would want to ask my own questions. Thank you.
Oh God.
Oh, just don't you fuck off.
Was I able to come out of my cell on the Keep-Separate protocol?
Objection, relevant.
Judge, I would prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not
Fresh air to read your
answer
discovery.
that question.
Can you give me the basis why you're on?
It's beyond the
Beyond the
scope.
scope. That was the basis. She should just say
What
irrelevant.
does that mean? I do not
Means it's
understand.
not relevant.
Yes.
Mr. Brooks, do you have any other questions?
Rule 801 or
I do not
801.
understand what
Yes.
beyond the scope means. That was a direct.
One last time, sir. Do you have any other questions? All
That was a
No, it's like
direct-
403.
right, I'm gonna mute him because he's now
Yeah,
Not
403.
being
801 's
responsive to
hearsay.
the question
Yeah.
that I ask, and that
My
is,
bad.
does he have any questions to ask the
Gotcha.
jail administrator within the scope that I've
TV lawyer,
previously
man.
outlined? Um,
I'm rusty.
Any follow-up from the state?
No.
All right,
Oh, thank
you.
God. At
You
least
may-
the state had the common sense to stop asking questions
Yes.
that don't matter.
Okay, and if I had tried this or Nick had tried this, we would have well been held in contempt a long time ago.
Yeah.
All right, does the state have any other witness or evidence you want me to consider related to either of these issues, the motion to adjourn, or the inmate communication form dated
the
September
judge is not
28
going to
of
adjourn the
2022?
trial, so say no.
Nothing else from the state, Your
Yeah.
Honor.
Why?
Mr. Brooks,
Walter Mellon.
do you
Nick and
have
potentially criminal.
anything
Nice.
else
You can use
related
some
to
Laura
the
Chili
inmate
to delete
communication
laws.
form dated September 28 of 2022? Since we I obviously included that after we took up the other issue.
Yeah, I'm still, I don't understand how,
We know. You just stop it. I
any
don't
questions I
understand.
was
You
asked,
already said she can't understand though, so don't act like.
I'm not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony, or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022?
Yeah, I would like to, is there a way that we can verify the standards of the Keep Separate protocol?
Mr. Brooks?
To be able to show. the
Mr.
court-
Brooks,
I hope he gets
Please
COVID
listen
for real
very
at this
carefully.
point. I'm not lying.
there's a question I'm asking you is, do you have any
I don't-
other
I don't
evidence,
consent to being asked the question
document? All right,
when
then
you
I'll,
can't even answer the
all right,
question
I'm going
without
to mute
asking
him
me.
once again. He is not answering very clear questions. I asked him if he had any
I
information,
think if this
evidence,
judge
testimony,
doesn't
documents he wanted to
appoint
present.
counsel,
Instead, he asked me
at
if
some
I could
point,
verify
if it goes on like
that
this,
is
that he's got
not
a mistrial.
within
He
my
has to.
role. This is an adversarial system of justice here in the United States and in Wisconsin. I preside over that, but it's up to the parties to present information, evidence, testimony to the court so that the court can address the requests and make decisions. I would refer Mr. Brooks back to
what's the next matter for the court to address?
Yeah.
the
If you guys were asking if he's schizophrenic, we don't know because he
waiver of
never got
attorney
evaluated.
form that was discussed last week.
He refused it and withdrew it.
He's objecting to nothing. He's objecting to nothing happening. Someone says who would competently Spartacus says who would competently raise the mistrial motion though. He won't.
It is
but
document
on appeal
number
The state
244
yeah,
state's smart. They may have to bring it up.
on the 28th day of September 2022, wherein
They have
Mr.
every
Brooks
right to.
was advised
the public
that the
defender's
judge cannot
appeals
be his
office will raise
attorney,
it too.
cannot give him any legal
Yeah, but-
advice. The district attorney cannot be his attorney, cannot give legal advice. The judge, district attorney, and court personnel are not required to explain court procedures or the law, among other things. and that he is required to follow all legal rules and procedures that an attorney would have to follow in court. He's also advised, and this is just one part of that form, that it may be difficult for him to present evidence. It may be difficult for him to do a good job as his own attorney. We discussed at length the advantages to having an attorney, the disadvantages to representing oneself. And what he is asking this court to do is to explain the law, and could also be described as a request for legal advice. All right, with that then, I'll certainly take up any arguments from the parties as it relates to both of these issues. I'll start first, though, with the motion to adjourn. Mr. Brooks is holding up the objection. That we're not taking testimony at this time, so the court does not feel compelled to acknowledge that any further, other than to say the fact that he's objecting is noted for the record. Mr. Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings, and as such, I will give you the first opportunity to talk about the evidence that I've heard here today by way of testimony, and to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion. All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
Well, I'm not arguing. I've stated pretty clear why it should be an adjournment. I don't think I need to argue anything.
Smartest thing you could say. Now shut up.
I need to provide anything more. If it's clear.
He's going to say, I'm not arguing, I'm traveling.
I traveled to the courtroom today.
She said that she was not present for the said COVID test.
It doesn't matter.
So there's, to her knowledge, no way to say for sure why I wasn't provided with the test that I should have been provided with, if that becomes an issue. Honestly, Your Honor, I'm powering my way through this hearing. I feel like total crap, to be honest with you. I don't feel good at all. My reason for raising this issue, like I said, was strictly a health and safety thing. It didn't have anything to do with trial prep. It didn't have anything to do with access to anything. It was strictly because, like I stated before on record, I've never had this issue come up for me. Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease. Frankly, I'm terrified because I have yet to even get the results back to say whether I'm positive or negative. I am fully vaccinated. I've never tested positive for COVID.
So he's a Redditor and a sovereign citizen.
And frankly, to even be told that it's a possibility that I could have COVID, it makes me very afraid. Which is one of the reasons why I was so concerned about the actual protocol, because once they informed me that I would have to be essentially quarantined and isolated, the first thing I was thinking about was how would I be able to use the phone that day, be able to tell my family what's going on? How would I be able to reach out to my kids and things like that to let them know, hey,
you just use the phone
going on in here,
and then they wipe it off with a bleach
that I'm
wipe.
worried about. That was my concern. And my intention was to at least be able to get the results back so that I know, okay, I'm good to go. Let's keep the ball rolling. That was my intention. Like I said, I just came to the knowledge this morning when they called me over to do the test. I had no idea that was what they were going to do. like I said, I didn't understand the protocol until it was explained to me. So I was just coming into this knowledge as well. I'm still trying to wrap my head around it. With that, Your Honor, that's pretty much all I have to say. Is the intent of it was strictly that. And, you know, not wanting to, if I am positive, not wanting to infect anyone else or put anyone else in jeopardy. And also doing the things that I may need to do if I'm found to be positive, doing the things that I need to do to be healthy. That was my concern, and that's why I raised the issue, Your Honor.
Okay.
Okay.
Accepted his closing
Thank
statement.
you, Mr. Brooks. I'm going to turn to the state then
Thank
next.
you. Now just mute him.
As a reminder, don't interrupt them.
Just
Thank
mute
you.
him. Preemptive mutery.
Yeah.
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still respond to his needs properly. So if it's merely a health and safety issue, I believe we've easily overcome that, Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls just this morning alone. So his statement to the court that he was worried about being able to call his family, I think, really is questionable. I also would like the court just to acknowledge that document 258, and perhaps
What if he had
that's a
18
moot
kids?
issue at this point, but I still think a record should be made that no matter what circumstances have arisen with Mr. Brooks specifically in the confines of the Waukesha County Jail, he has always had access to his legal materials, the discovery in his cell, and the necessary tablet and computer so that he can prepare for his case.
That's
So
a kind
I
of
would
bullshit
ask you to
prosecutor
deny
would
the
say.
motion to adjourn because of the COVID protocol, and to the extent that there was a prior motion to adjourn because of a keep separate order, that also is inappropriate at this time. Thank you.
Prosecutors lie, everybody.
Welcome to Steve Gosney. How's it going, man?
Pretty good. Pretty good. Can you hear me?
Hi, Steve.
Yeah, we gotcha.
I'm just pulling up a couple
just
of
for the
documents so
new
that I
people
can
in the
review
chat
them
may
electronically
not be
as I make
familiar,
a decision here
Steve
today.
is a public defender down in Florida who, thanks to a hurricane, is able to grace us with his presence this week.
You may briefly respond. Go ahead.
Nice to meet you, Steve.
Nice to meet you.
All parties and will recall one of the detectives that is sitting right behind the prosecutor's desk right now, Detective Casey, just went through something similar with COVID and was not present for a couple of hearings. I don't know how long his protocol was. I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk.
Yeah, he doesn't want to put anybody at risk.
There's any difference in my
So altruistic of him.
also very
So
reasonable.
nice.
He finds
Correct.
bioterrorism reprehensible, but
I
direct
was
physical
able to
violence
make
is
a
fine.
phone call.
Yes.
This were phone call attempts because they were attempts. This morning, after I came from getting the test,
He was just making sure everybody was vaccinated in that parade.
Since I know that I'm going on this protocol and I'm already out of my cell, can I take this opportunity to try to notify my family of what's going on? That's why there were so many attempts, because I wasn't able to reach my mother, who pretty much has access to my kids. If I need to get some information to my children, she's the one that is in charge of all that. I just wanted to state that for the record.
Thank you,
Okay.
Mr. Brooks.
Thank you. We're the record is so noted.
Heard from Mr. Brooks. The court has heard from the jail administrator.
I hope she
The
adjourns the
DA has
court. I
provided
hope
some
he
additional
wins,
information
actually,
as officer
after all this
of the
stupidity.
court. Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication
No one needs to
denies.
advise Sean King on trial again. Oh no! Come
earlier
on.
See, this
today,
judge is weak. She's
raising
being denied. The motion's
this
denied.
issue.
Move on.
Yes,
he
especially for this
is
stuff.
on a protocol. He is not tested positive. He provided information today that he is fully vaccinated, that he'd been telling officers for days that he had not been feeling well. We do not have the test results today.
We spent 2 hours of court
was
time on this
offered a
issue.
rapid
This
test
bogus
and
motion.
refused. He reports symptoms of fatigue and that he can't taste. He also indicated
What if he dies of
Um,
COVID tomorrow?
it was a few days ago over the weekend that he started
Whoops-a-doodle.
experiencing these symptoms. Now, during his time here today, Mr. Brooks, despite the disruptions, has been very clear, coherent. He has asked questions. He's made objections. I know he might not like the word argument, but that's a word that we use in the adversarial system when the court asks the parties for their positions on certain issues. We call it legal arguments, or arguments for short. Doesn't mean or have any connotation that it's unruly or disruptive or a disagreement. It's just the word that we use in the legal system. He was able to articulate his positions to the court. He at times appeared animated. He appeared, again, to understand what the court's either questions that the court was posing to him or information the court was providing to him.
This is going to
clearly
be
was
a
able
robust
to
record.
This record does not need to
Don't
be
interrupt me or I will mute you.
Yes,
He was able to follow
this
the
is superfluous.
questioning and answering process with the one witness who is here today. I appreciate that he clarified
you're in this
that
transcript,
he
Steve.
was not making
No,
this
I don't want
request
this.
due to trial prep or access to material issues, but it is really related to his health and safety concerns. At this point, there's insufficient information on the record to find that his concerns are anything more than speculative. And
They don't-
given my observations here in
This is
court
such a waste
today,
of time.
he
Even if
is
he has COVID, you have
very
a protocol
ably,
for doing. You put
or
him in a
very
separate
able
room,
to
far
assist
away from everybody.
You should subpoena
his-
Dr.
in
Fauci.
his own defense. He's able to present arguments, et cetera, I've already noted. We are able to accommodate the health and safety concerns in this courtroom. We confirmed that where he sits at the table, if he's in this courtroom, there is no one around him who would be within 6 feet.
I object to being alone, Your Honor.
That is an important consideration that has been one of the topics of guidance from the CDC, certainly
She's treating him as
one
if
of
he's
the-
actually listening.
or part of the guidance we have received from the county.
He's just waiting for an
The
opportunity
most
to ask when he'll get a
recent
shower
county
again.
protocol talks about isolation for 5 days. Clearly, if he had the onset of symptoms over the weekend, which is what he reported, and he has not had any escalation in those symptoms, as has been demonstrated by his ability to participate in this hearing. The court will find that there are no present health and safety concerns other than what I've noted with the 6 feet and social distancing. I'm not going to adjourn this trial. I'd also put on the
Shocking.
record that he has not been denied access to materials. He has full access, even with this protocol. He has had access even to the phone.
I object to the
There's
ruling.
been what's been referenced by both the state and Mr. Brooks about attempted phone calls. I'm not so concerned about whether phone calls go through. It's the fact that he's been given access. Whether he connects with someone is not the issue. I'm also concerned about the fact that he would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately. And he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19, and that any health and safety concerns he has for his own safety can again, be met. The jail's able to get him here. The jail, of course, is responsible for his medical care.
Could you imagine having to listen to that person?
6 feet away from any other person.
Like the ride
Obviously,
over?
if he's removed to the
Right.
courtroom, that provides a
Please,
greater
no
buffer
more.
as
Give
well.
I object to your
And
speed. I
For
object to
all
the
of
turn
those
signal.
reasons, I'll deny the request to adjourn. As to the issue that was raised in the inmate communication, obviously this was a form that was sent by Mr. Brooks on Wednesday, September 28th of 2022. That was the day on which this court granted his request to represent himself. We know from the record, not only from today, but previously, that on September 28th of 2022, what he would have had in his cell would have been materials previously provided to him by his attorneys. His attorneys, through Attorney Perry, dropped off 3 bankers' boxes worth of materials and a flash drive to the jail later that date. And the jail followed whatever protocols they have with regard to those materials and reviewing them, and that those materials were provided to Mr. Brooks on September 29 of 2022.
Oh my God.
He's confirmed through
This is terrible.
the recent
This is
request to
so
adjourn that
overwrought.
he
This judge is
wasn't
so
even
out of
making that
control.
request
Who's
based on
controlling
any
this
type
courtroom?
of access limitation to materials or things of that nature. Although not a specific statement by him, this court would take that to mean he has been able to continue with his preparations. I'd also put on the record that there's no doubt that being in trial can be
No
exhausting.
doubt.
We,
Yeah.
of course, had 2 afternoons of hearings last week. Of course, he was provided with a lot of material. From my
Sounds brutally
perspective, he
exhausting.
clearly understood the perils of self-representation and the volumes of material that he would need to review perhaps a second time because he had some of them, or for the first time. Those were things that were clearly, he was clearly advised of before I granted that request. And then, of course, we had 2 very, very long days of jury selection yesterday and the day before. Given the way this jury selection progressed, we did not start with court until today at 1:30. Frankly, part of that was done not just to provide access to the media pool and the cameras and other things that needed to be installed, but honestly, to provide a little bit of a break for myself, and I would hope for the other parties as well. Of course, everyone continued on with their preparation, but I actually understood this request. I may not have referenced it previously, but that really factored into my decision to start later today as well, and to not bring the jurors in until tomorrow. So I am satisfied that Mr. Brooks has access to his materials that he needs to prepare for trial. As I indicated earlier, I have also provided to him the Wisconsin Criminal Code and selected
objection.
traffic statutes, including the Wisconsin Rules of Evidence.
You gotta do what you
It's
gotta
from
do. That's all I got.
2018. While there might be some slight modifications to some of the substantive statutes, this would give Mr. Brooks a very good reading as it relates to the rules of evidence and the statutes that
There's a very
relate
important
to
poll
the
up in the
charges
chat,
he
by the
is
way, chat.
facing. I'll provide a copy of that, a photocopy of the cover, so that it's docketed in the case as well. While this court is under no obligation to do that, since I was able to locate that, I am putting that on loan to Mr. Brooks. What he also needs to understand, though, that at this point it is for use in the courtroom. I would entertain a request that it go back with him to his room on a couple of conditions. One, it would be that he agrees to bring it to court each day.
Hold on a second.
Two, that it be maintained in its
staple it to your
current
head, dude.
condition. And then three, that it's returned at the conclusion of the trial.
I've got to go real
that will
quick.
be
I'm
for
sorry.
him
All right.
I'll be back tomorrow if you'd have that.
Decide
Absolutely. We'll
how
have
he
you on.
wants to do that.
Have a
Good
good
day.
He
day.
has been raising the sign objection at all times during my oral
At all
decision.
times.
I would note the use of an objection is when the trial is in an evidentiary phase or a motion where we're talking and
Oh, he
addressing
can object to your ruling.
the
Yeah, he can
testimony
object to
and
whatever he
evidence.
wants.
It's a
Yeah.
mechanism under the law by which
And
a
since you can't
party
hear him, he has to make sure you
objects
notice
to
him.
the state either a 1 or 2 word basis. Sometimes it might be a short sentence or
See,
two.
she's talking too much because she said
Sometimes the
earlier
other
that
party's given
there
an
are two
opportunity
types
to
of
respond
objections:
if it's
evidentiary
self-evident
objections
to the
and
court
objections
as
to
to
process.
either what the objection is or the
And you
basis
can
for
object
granting
to
or denial.
anything
The
in
court
court.
rules on it,
Yeah.
and then the parties move on. Those are the
So rule on his
not only
objection to your
expected
ruling.
procedures for
Yes.
this case. It also comports with just the basic tenets of civility and respect, that you don't interrupt. Again, an objection is a legal basis to interrupt, but it's done in a way that's respectful.
Just to know what you can do.
Holding up a sign that says
He's-
objection is not,
He is interrupting and
That's
he's
the
doing
only
it
way
without
he
interrupting.
can
does not
object to
comport
you.
with those
Yes, you muzzled him.
or procedures.
Why would you say something
All right, so I've
stupid?
addressed those two issues.
Thank God this isn't
I
a
have
trial
a
because these
list.
are massive
I
errors of
told
law.
the parties what's on my list, and then you can add to that as well. I do know the state filed a motion for
Probably a harmless
reconsideration,
error, but
so that's
still,
on my
like-
Yeah,
list
still,
as
it's an error.
well.
And the court would say, like,
I
come on,
wanted to
sister, you
touch
gotta get
base
this
on the
right.
request for an
She's
interpreter.
just not going to
Again, the
rule on his
motion for
objection to her
reconsideration.
ruling.
I've already addressed the
Just say,
subpoenas.
we've heard his objection. It's
Madam Clerk,
overruled.
can
The
you
court will
just
move on.
confirm for me that they were signed by the clerk's office and then the 10 copies were provided to Mr. Brooks
Correct, while he was sitting here.
while he was seated in the
And
courtroom?
This morning at 11:18.
At 11:18 this morning, he was also provided with copies of subpoenas. Do you know how many copies were provided?
21 this morning.
21 this morning, an additional 10, I believe, this afternoon. So he has those available for his use. I've already addressed the statute book, so I can cross that off my list.
Objection, we're not at a museum. I don't need this.
And then, of course, preliminary jury instructions. Now, I know Mr. Brooks, I think, did not bring his with. I wanted to make a change to those before I printed off a copy for him. It's not a huge change. It's really just an addition. And it has to do with some of the language
object to the
that
addition.
I have been stating to
Please sell
the
laminated
jurors
blue
if
objection
there have been
signs.
disruptions. Not every time, but I do feel it's important to put some language.
Can I get that as a as like a
after jury instructions 70. I'll
memorabilia?
get to that. We'll probably do those last.
I wonder if I can sell laminated
Attorney
papers
Oppert,
somewhere.
anything you would add to the list that I have?
Yes, Your Honor, I just wanted to understand some of the logistics
Oh, your tea
as far as objections and cross-examination and exhibits. And I also have the state's witness list prepared and filed. I filed it at the start of this hearing. I'm sorry, did I say witness list? Exhibit list. 8 pages right now with 140 items. I was going to make that available. So I guess I have a question about that, and I don't know if you want to take that up right now or not.
I have one other, give me your whole list though, too. And then
Okay.
I have one other thing I need to add as well.
And then criminal records for state's witnesses. That was it for my list. Then the rest overlap with your list, Your Honor.
I know Mr. Brooks appears to be talking to someone and hand gesturing. Unless he writes a note that he has a topic he wants to address for me at this moment, I'm going to assume he's just directing his commentary to the bailiff that's in there. I
Poor
will
bailiff.
unmute him momentarily to ask him a question,
My
and
God.
that question is whether there are any housekeeping issues on his list. All right, Mr. Brooks, are there any additional issues that you believe need to be addressed? Mr. Brooks, can you hear me? Mr. Brooks,
He doesn't recognize.
do you have any
that he's wearing
additional issues
headphones.
to what I've already set forth and the state's
That's all
added
you're
to the
good.
list of what I will call generally housekeeping issues, other than perhaps the motion for reconsideration? That's not housekeeping, but
I was, having a side conversation with the bailiff about something, so I didn't hear the last part of what you said.
it's my understanding that the bailiffs would not be having a conversation back with you or at you during court proceedings. I'll have to confirm or deny that with them. Becky, if you could talk to the bailiff, please.
Let me read super chats, I guess, because those need to happen. And he's slowed me down on this.
He was asking.
Doge Ricada's Booty Goons says, Judge,
So it's
I hereby
my understanding
sentence
you
you
were
to death by
asking the
booty goons.
Deputy how
Bailiff,
to pronounce
get
a
that butt.
word. Did he provide a response back to you, Mr. Brooks?
A kind of a response.
What do you mean by that?
It was kind of a response.
Did he provide a response verbally?
I'd rather not say that.
You'd rather not say?
I'll have to get clarification from the bailiff later on. He's coming in here. Okay, thank you. Did
By
you
the way,
provide a response to Mr. Brooks?
I just told him I didn't understand the word he was asking me. He asked me to pronounce what the pronunciation of a word was, and he spelled it to me. I said, I don't know what that is.
Okay, thank you. Mr. Brooks, I'll ask you one last time. Do you have any topics that you believe should be on the list of housekeeping items to address today, other than the ones I've provided to you?
I did not hear the ones that you are referring to.
All right, listen to me now because I'm going to go through the list. Some of them we've already
Sword and
discussed,
Scale
so
says this is the best
I'm going to give you
trial
my
I've
whole
ever
list and
seen.
I'll say
It's gonna
whether
get
we need to
worse.
address them or not. We have
Gonna get a
to
lot
address
worse.
preliminary jury instructions, the state's request for an interpreter, the state's motion for reconsideration.
Consideration of what?
I'll get to that momentarily. I've already addressed the subpoena request from you. I made a record of that. I already addressed the fact that I provided you with selected statutes. If you didn't hear, I'll state this part again. The book that I provided to you that was on your table when you got into court today, and that I believe is on the table, or at least was taken over when you were removed to that courtroom, is the Wisconsin Criminal Code and Selected
right back.
Traffic Statutes, including the Rules of Evidence 2018. It's a State Bar of Wisconsin Pinnacle publication. It's probably about 2 inches thick or so. It has a reddish or maroon in color cover and binding. That's been provided as a courtesy to you. It's been provided to you to use in the courtroom. I would entertain a request from you if you want to take it back to your cell as you prepare on the following conditions. 1, you agree to bring it to court each day. 2, you maintain it in its condition presently. And 3, you return it at the conclusion of trial. I'm not asking you to make a request at this time. It will stay in the courtroom unless you at some point make a request. The other issues, hold on, sir, let me get through my list. The other issues are logistics regarding objections and cross-examination, the state's exhibit list, which was filed earlier, criminal records for state's witnesses, and then I have an added topic related to court TV exhibits and FCC rules, and just some things that may be impacted during the broadcasting of the proceedings because of the FCC rules, which I will claim I'm not an expert on, but I felt compelled to at least tell the parties. I'll start with that so I don't forget, and that is I have been advised that there are FCC rules that may require graphic images or videos to not be broadcast. And I know the state at one point had made a request, and we had talked a little bit about individuals who are victims appearing in a remote location and watching the live stream and seeing those exhibits. And originally, I had planned to utilize Zoom, and there's a share screen option. I'm not going to be utilizing the Zoom because of now the new mechanics for the live stream and the pool feed that Court TV has taken over and is providing to all of the other media that wants access to it. So I just wanted to make you aware of that.
Thank you, Judge. And I believe there was a workaround that was accomplished with the cooperation of Court TV and the county IT, so that the victims will be able to view whatever is being shown in the courtroom, notwithstanding what's broadcast to the general public under FCC rules.
Excellent. I'm glad to hear that.
Yeah, and I would like to know
Really
for the
not that
record
hard
that
of a
the Court
workaround.
TV was very accommodating and very helpful in that regard.
You're so helpful, Sue.
And as a reminder, so you'll see there are some cameras that have been installed in this courtroom, and some microphones. Like I have an additional microphone next to me. There's a camera down in front of the court reporter. There's a camera in the back, and
Ron, you
there's a
need to go?
camera
I need to
over
hit the road.
to my
No.
left
All right, brother. I'll
in
send
the
you
clerk
invites throughout
station
the
work
week.
area. I've also
Thanks, yeah, I'll pop in when I can.
now we may
Yeah,
have
whenever.
to use the
Catch you later,
adjoining
buddy.
courtroom.
Yep,
We're
thanks.
in
See
the
everybody.
process of getting some equipment so that there's a camera in there as well. I know that needs to be worked through with the county facilities because of the cabling and all of that. So I just wanted the parties to be aware. I have approved of all of that. That brings me to a related topic, and that's the use of the courtroom microphones are still an audio backup, but we have really good microphones in this courtroom. The state noted it yesterday, or
Actually
maybe
do
it was the
sound
day
pretty
before.
good.
At
I
one
gotta give you
point,
credit.
Mr. Brooks appeared to be muting the microphone in front of him, but because there's microphones elsewhere, we were still able to see the audio. I'd advise the state of the same thing. You have microphones behind you through the court system that just because you mute the one in front of you, you may still be picked up. And that just whispering still comes through on the microphones, whether they're the courts or otherwise. So,
Could I ask a question about that, please?
sure.
During recesses, is it possible to mute all microphones so we can confer?
Absolutely.
Okay.
Remind me,
Sure.
right? We need the clerk to do that. But I think if
They
we
do
all
have a low bar
cooperate
to beat for
together,
mic usage.
we will get that done.
Thank you.
Man,
All right. Any questions about the broadcast, Mr. Brooks?
I didn't really understand the whole gist of it. So, I'll go with the part that
you didn't understand. You
I
got it.
don't think that if you are not in the courtroom, that you should be privileged to see anything. I think the word you used was graphic.
Oh, now you care
I
about them.
am not responsible for Court TV's compliance with FCC regulations, but it's my understanding that they will meticulously follow whatever the regulations are. But what's in the courtroom is clearly going to be what's in the courtroom, and anyone in the courtroom will be able to see fully based upon the monitors, including the jury, including the court, and including you, whether you're in this courtroom or the next courtroom.
Yeah, that would be the preference. If you're not
don't
in
have a
court,
choice.
you shouldn't be able to see everything in court.
All right, moving on to the next topic
Like the
then.
sovereign citizen wants,
There's a
wants the court to
state's
impose
request
rules.
for an interpreter. I wanted to address that because the form that you used, and thank you so much for doing that, requires that I sign an order. But it's my understanding that that request may be modified.
Yes, Your Honor, as to the timing, certainly it will be modified, because I think I indicated October 6th or 7th. I no longer anticipate that being necessary. It would likely be one day next week. If you give me just a second.
Definitely not.
here, I
Brandon
can
says, I'm talking about
maybe
safety.
give you a better
I had my
idea. I'm
seatbelt on
wondering,
when the car went on autopilot and targeted the dancing grannies
if
in
the
that
court,
children's band.
I hate
Who
for the
fuck
court
is
to
this
pay for
guy?
an interpreter that we don't use. So I don't know how much notice you need to give to the interpreter or how far in advance you have to reserve them before you have to pay them no matter what. I don't know if they have rules like that or not.
They do.
Okay.
It depends.
Okay.
So thankfully, we have one local interpreter who is incredibly reasonable and I know is kind of on notice, but it really depends on his schedule. And what we may have to do as the courts, because
We
you
need an
are
interpreter 'cause
correct, it's the
one of
court's
the witnesses
responsibility
or
to
more
do
of the
this, to pay
witnesses don't
for
speak
it.
English very well.
I will not make arrangements just yet unless, just based on the request that was made, because you said it's no longer a date that you would target for that interpreter.
Voice? Of course I can.
I'll decline the proposed order. And then just if you want to resubmit, of course, we have someone in the clerk's office who is parties work with regularity to obtain interpreters. And so the state can simply continue to work directly with that person to facilitate and hopefully keep the costs down. And we'll deal with whatever the fallout financially. Typically, we need 2 business days to cancel them. So if you can make arrangements, for example, say next Thursday or Friday for those witnesses to appear, and then you decide you don't need those witnesses, and we should be able to cancel them by Tuesday or Wednesday, depending on the day that we've selected.
Sure. I understand. That's very helpful. And we will definitely be diligent to keep the court informed. I understand. I agree. It's appropriate
we
for the
got
court
it.
to deny my request today, and I will renew it as needed.
You know, as I think about that, I think what I'll do is I'll approve it, but I should be able to add some language about
You think you're a judge? You could just make it up.
this date may be modified through direct communication between the DA and the clerk's, the person in the clerk's office responsible. I don't need you to file again and again if it's really the same
Lancelot
request. It's just
652
the
says
date
this woman is going to
changing,
empty
and
the
you're
local
doing that in
store of
order
liquor
to,
after this trial.
frankly, save money for the county.
Yes, that's exactly our intention, Your Honor. Thank you.
Ristercrap says he has fatigue from getting railed. He is
On
HIV
that,
positive, not COVID. Damn.
Let's go to the motion next, at least preliminarily.
God.
Did you serve that motion on Mr. Brooks?
I hope so.
I don't think I did. To be
You
fair.
didn't serve the motion on
I
him?
had it
Why?
in
He's
my office,
in
and I was gonna
jail.
ask Detective Bregman to take it over there, but I don't believe I ever.
Actually did that.
All right, I will ask that you have that served upon him right now. And that will obviously impact the timing of when I can address it. But we'll save that near the end. But I'd ask that you, Detective Ragland, go do that right now, and I will just pause momentarily if, so that that can be done.
While we're pausing momentarily, guys, I got to tell you about a sponsor for the channel.
And I'm going to take a short comfort break as well. So we'll be in
Just a
recess.
second.
It's 4:06. Let's take about a 10-minute break.
Wait, are you saying you can't hear me? I don't think that's true. Okay. Probably with the judge at the same time you couldn't. So this is a good opportunity, by the way, to talk about this show is sponsored today by Birch Gold, the Birch Gold Group. Birch Gold allows you to use retirement funds to hold physical assets like gold and silver. If you want, you can go check out their website, birchgold.com/knows. And you can request a free information kit. You click here or here, and they just send you some info. That's it. That's all you got to do. But the reality is, of course, there's all sorts of issues plaguing the world right now. And one of the most stable hedges against some of those issues, like inflation, like market volatility and uncertainty, of course, has been physical assets, which tend to hold their value a little bit more stable. This is not a call to invest for all of the elite gains of golds and silver that are definitely going to rise to $5,000 an ounce just next month. It's just going to happen. This is not that, because that's not true, most likely. And if it is true, we probably have other problems. Gold and silver are not always the best, most lucrative investment vehicles, but they are stable hedges as part of a well-rounded portfolio. But don't listen to me. Listen to other people who are smarter about it, who have all of the information. This company's been around forever. They have an A+ rating on the Better Business Bureau, bunch of reviews. Give them a check if that's something that you're interested in. Most importantly, why I accepted the sponsorship, which I don't often do. Is they approached me and they said, "Hey, we know who you are. We want to work with you." And the first thing I said was, of course, okay, what can't I say? What joke can't I make? Who can't I make fun of? And they said, just be you. We don't want to tell you what to say. We don't want to tell you what to do. We know who you are, and we want to work with you. I was like, that's it? Yeah. Oh, well, okay. There you go. I mean, for me, that's a pretty big statement. I love companies that are willing to support people who support free speech, who also engage in jokes and very dangerous ideas and all of those things. So, if they're willing to take a chance on me like that, then I'm also willing to take a chance on them. I mean, plus it's a well-established company. You can actually, if you listen to other commentators in the dangerous speech space, guys like, I guess, Ben Shapiro or whatever, I think they sponsor him as well. So they've been around a while. Also, the product is something that I think is valuable for people. You have a retirement account, you can hold some assets that aren't just paper, and you can you can see if that's right for your portfolio. But check them out again, birchgold.com/knows. It's in the description of the video, and they're sponsoring all of the live streams that I'm doing this entire month, which is pretty cool in my humble opinion. So I didn't know I'd be doing this trial when I signed it either. So they're getting a bonus. Damn. Lucky gold grifters. You bastards. Just kidding. Guys, go check them out. Speaking of the actual sponsors of every stream, though, we've got super chats to read. I will, of course, bring Judge Mommy back as soon as the court is back in session. Right now it's in recess. Also, one other thing, like, if you don't have a retirement account, but you're interested in buying gold and silver, like, you can actually buy gold and silver from them as well. I believe they only deal in like coins and, like official rated whatever, you know what I'm talking about. Like you buy specific coins, like they're not like, hey man, I got this vial of gold that you need, man. You know, you put this in your veins, man. Like they're not that kind of guy. They do sell just straight up gold and silver. If you want to buy that, like you can. You don't have to be retiring or whatever. Just for people who might be interested in that as well. Okay. Next, back to super chats. Sport Nugget says, if you were a fraction of the villain they're making you out to be, not only would they have known you'd make the complaints public, but they know you have no better nature to appeal to. Blatant lies from bad bullies. Oh yeah. These are the nasty people of the world. These are the nasty people. People who want people canceled and ruined and stomped into the ground. And eventually, I mean, frankly, they want them broke. They want them unable to buy food or water and to just die away from society. And they want them kicked off of all social media so they can't tell people what's going on and they can't ask for help. They're disgusting. Not possibly Lesko Brandon says, I would like to point out the hypocrisy of the situation as well as the COVID-19 thing in general. That mask isn't on properly. He's touching it, touching everything around, blah, blah. If they delay proceedings over this FML, they weren't going to unless the judge was crazy. I don't think she really should have entertained it as far as she did, but they're trying to be thorough because they know what's coming, right? This guy's gonna raise a stink about mistrials like crazy. Floppy X Turtle says, thanks for the constant entertainment while I'm working. You've also helped me realize the importance of things like the First Amendment. Thanks again from someone who is across the pond from you in North Dakota. Hey, how's it going, neighbor? My pleasure. Ristocrat. If I believe anyone who is claiming sovereign citizenship should lose all rights as an American citizen. If you don't want to be a real citizen, you shouldn't get treated as one. Well, you know what? It's an interesting idea. And I have a mild pushback, which actually annoys the hell out of me. There is almost no constitutional benefit to citizenship. Like the rights of an American citizen are conferred to anybody under the jurisdiction of the United States, whether that's on U.S. soil or whether that's in some place the U.S. is policing. Like a foreign country where the U.S. is policing, and sometimes just in foreign countries where we aren't policing. They're all afforded the exact same constitutional rights and protections of an American citizen. And I frankly think there might be some things that shouldn't be afforded to people who are not citizens. I think citizenship should have a benefit. And I think the lack of benefit of American citizenship for such a long time has eroded its value to Americans personally. So that's my little take on it. But you know, that's kind of the way it is. Doug Murray, Rackets, can this prosecutor make it a motion to get the judge remanded because she's turned this trial into a circus? I mean, you could, but that would increase the circusness of it. Sword and Scale says, I don't think you get it, Ricada. He's a sovereign citizen. Your laws are out of jurisdiction or some shit. I know. And joinder of parties is impossible because he doesn't recognize the corporate entity of Darrell Brooks. Eric the Red says, what are you more passionate about? Cameras in court, American Beauty, or Jamaican sex toys? I won't lie, that I can't deny. I did it all for the nookie. Come on, the nookie. So you can take that cookie. Okay, what do we got next? We've got, and by the way, to the new people in chat, if you're here for the first time because you're watching this trial, great, welcome. I love you. You may not love me. I'm brash and offensive, and I tell jokes, and sometimes I talk over the trial. I try not to too much, but I promise you a more entertaining stream than any of the other channels that might broadcast any of this stuff. But you also will likely be offended by something I say at some point, and that is good. That is good. Be offended and be harmed. Get harmed. I'm wishing offensive harm upon you. I don't pull my punches or police my language for other people. So if you have an issue, you can take it up with the management by emailing it to me or whatever, and I'll probably say, "Lol, you're gay" or something right back to you. It's just how it goes. That's the reality. But if you like this style of YouTubery that I do, commentary and hopefully a little comedy, check out my locals page, ricadalaw.locals.com, where you can find all kinds of fun degeneracy. And most importantly, the new thing right here, here it is, the locals chat that I have going on. It's a dedicated chat. Whoops, I probably should take that off. I saw it was on there. Good job, guys. There's a dedicated chat for local subscribers for every live stream now. And it's a whole different place. You can post pictures, you can post memes or whatever. And there's like a community in there and stuff that you can hang out with if that's what you're into. ricadalaw.locals.com. Also, there's other stuff that happens on locals, but what happens on locals stays on locals. Okay. Arno09. She's possibly pulling teeth now as evidence that he was granted every opportunity in an attempt to ensure he can't weasel out of the noose on a technicality later. Shame about it being excruciating. That's what she's doing, but she's doing it too much. And I think, in my opinion, she's actually risking overdoing it. And like today, I mean, she misstated the law about objections in court, like for no reason. She didn't have to say anything about the different objections. She did earlier. She clarified earlier the two, different types of objections, objection to evidentiary issues. But to pretend that you can't object to something, a ruling of the court, you can't object to a statement made by a judge or whatever, you absolutely can.
The record appearances are as they were before.
So that was just, it's an
Mr.
unforced
Brooks,
error.
I wanted to invite you back into this. Oh, never mind. I do this all the time. I need my court reporter. Kind of a small thing.
Casey says this guy is exhausting.
Welcome, Michelle.
Do you think when the jury is in, the judge
No,
will
that's
be
my
different
fault.
or
I should've
continue
looked
issues
over there.
today?
In my defense, in my other courtroom, it's on the other side, and
No, I
gotta get
think
used to
she'll be
that.
pretty similar.
All right, we are back on the record. Then appearances are as they were before. Mr. Brooks, I'd like to invite you back into the courtroom if you so choose. You have been respectfully participating from the other courtroom. Of course, if you do come back in, you, of course, would be expected to abide by the rules of decorum and courtesy. Would you like to come back to this courtroom, sir?
Just say no and stay there.
I never stated that I wanted to be removed in the first place.
That's not the
My
question.
question to you, sir, is would you like to come back over to this courtroom?
I respectfully never consented to being removed.
I will ask one last time before I
leave him
consider his
there.
answer to be non-responsive. Would you like to come back over to this courtroom, sir?
That is not a non-responsive answer.
So the answers provided were not responsive to the question that I asked, and therefore
Just
he'll
leave him there.
remain in the other courtroom.
Don't waste anybody else's time. 11 Bravo Crunchy says, oh my God, this.
Not respond. I responded. You just wasn't accepted.
The record speaks for itself, sir.
Your Honor, I'm very tired, so.
Mr. Brooks, we're going to keep, Mr. Brooks, we're going to keep going. So please don't interrupt so that we can
If he
do this
dies,
as quickly
he
as possible
dies.
so you can go back to your cell.
I was just merely trying to make the record, which you haven't denied me to do. As I stated at the beginning of the hearing, I would like to make an offer for my appeal. I've stated that on the record numerous of times yesterday and today as well, and I haven't been awarded that right to do so.
Mr. Brooks, I'm not going to respond to that simply because if you want to file an appeal, then you should take the necessary steps to do that. All of my decisions are on the record. You can request a transcript if you want to have a written copy of what was said in court. I can't provide legal advice on how to pursue an appeal, but I would not grant an appeal. That is not within my authority. That is a reviewing court would decide that, whether that be the Court of Appeals, the Supreme Court, or otherwise. So that's why I'm non-responsive to that, is because there's nothing for me to do as it relates to that based upon the request that you have made. So with that, Mr. Brooks, Mr. Brooks, I'm going to mute you, okay? Mr. Brooks, you've now earned the mute button once again.
Kind of sounds like a
despite
Karen
you
when she
saying
says
that
you've
you're
earned a
tired,
mute
you
button.
had no difficulty making objections, objecting, and once again asking for an appeal. So I need to get going on this hearing, and that's what we're going to do. I would like the state to confirm on the record whether you've had an opportunity to have the motion served on Mr. Brooks.
Yes, Detective Regland personally served it on him about 10 or 12 minutes ago, Your Honor. Also at the same time served him with a copy of the state's exhibit list, which I believe we will be addressing at later this hearing.
Right. As to the motion, I would like to give him an opportunity to review that. It is a motion for reconsideration. And so I'm not going to address that today. I'll have to address that tomorrow morning.
Understood.
Thank you.
Yes, if a lawyer acted like he does, they would be in contempt. 11 Bravo Crunchy says, oh my God, this guy is insufferable. Is it too early to place an order with him for some custom license plates? Stephen Cooper, Borowski would have run him over with his escape.
Why don't we start with one of the latter things that you indicated, and that's the criminal records for state's witnesses. How many witnesses would this issue relate to?
One.
All right. And would you have a copy of that record, or I don't know how do you provide that to the defendant? How would you like to provide that to him, at least the information?
Well, I'm prepared to make an oral statement today, and then I have a CCAP entry that I would choose to provide to Mr. Brooks to verify what I'm saying.
Okay, go ahead.
Your Honor, this relates to one of the state's potential witnesses who's identified as the father of victims KKK and victim LLL.
He killed the KKK?
Who's expected to testify. He has one prior misdemeanor conviction from 2005 for a crime of entry into a locked building. I would note that it's the request of the state that although he does have this one prior on his record, the court make a finding that it's not relevant or probative, in that he was 21 years of age at the time it occurred. It occurred 17 years ago, and there's been no further events or criminal wrongdoing in the meantime. I don't think it is probative of his truthfulness. It was not a
entry into a building isn't a crime of dishonesty anyway.
And we would ask that, although that record does exist, that he cannot be asked about it when he testifies. He is the only citizen witness that has any appropriate criminal record to discuss.
How old, again, you said it was 17 years ago, but how old was this individual at the time?
21 years of age.
It's not a crime of it's not a crime of dishonesty. Austin Olson says, catching the stream for a bit before I go to bed, having a bit of a hard time being 12,000 miles from the wife and kiddo for 4 months with another 7 months to go thanks to military. Ooh, good luck, brother.
609, Your Honor.
I don't know how you guys do that.
So I'm going to take this request under advisement. I'm going to advise Mr. Brooks that the relevant statute is 906.09, impeachment by evidence of conviction of crime or adjudication of delinquency. I have provided him with that selected statutes book so he can review this if he so chooses. And then at the appropriate time, I can
Hot
readdress
take.
this.
He's not going to review it in the book.
I'll
He's
remind
going
you
to
before this
ignore
person testifies,
judge's
Your Honor,
ruling.
if not before, but
Right. I think that would be the best way to do this. Just maybe give us, if you can, a day or two notice so that he can, meaning Mr. Brooks, can look at the statute again if he so chooses. So what I'm telling you, Mr. Brooks, is that I'm not going to address this request today. The state's put this information on the record. I'll require them to provide the CCAP information that they have regarding this individual. That individual would be on the witness list. Is this person indicated in any way on the witness list as the father of so-and-so, or would it be?
no, but when he gets the CCAP entry, he'll see the name.
That's true.
Yes.
All right, thank you. So that's how you'll get that information,
racist
and then
to
I'll
assume that their
address
names will be
whether
the same.
that impeachment evidence is relevant and probative at a later point in time, but at least you're put on notice of the request. And again, I'm not going to address the motion for reconsideration because you were just served with a copy of that. I will take that up tomorrow morning.
If the defendant should testify, we would want to discuss his prior convictions as well. We don't have to do that right now, but I at least wanted to discuss about the state's witnesses, Your Honor.
Sure. If you wanted to
CCAP is
provide a little
probably
bit of
like a
information, again,
criminal
he's been given the
report.
statute. He could review
It's probably
that.
a Wisconsin acronym.
Do you have a total number
Based
of
on the
convictions
context of
for
what they're
Mr.
calling
Brooks, and the number that you would ask be the number he answered the question to? Should he testify, have you been convicted of a crime, and if so, how many?
Yes, Your Honor, we believe the answer would be 12, with the first 3 coming from the state of Nevada, and then the remaining convictions all in the state of Wisconsin, mostly from Milwaukee County, but also 1 conviction from Wood County and 1 conviction from Manitowoc County. And we would certainly provide Mr. Brooks with either a criminal history or
It's the,
CCAP
it's the
printouts,
court-
whichever
the
he
court
would like,
access, criminal
to
court
support these
access
convictions.
program or something. There you go.
except for
Thanks.
the Nevada. That would be on his criminal history. We can provide him a CIBR.
All right, so state's putting you on notice that if you elect to testify in this case, they will be seeking a ruling on whether you may be asked, have you been convicted of a crime? And then the follow-up, if that answer is yes, is how many times? And that number is really up to judicial determination under the statute and relevant case law. Again, not going to take it up here today, but you're put on notice, and the
Really,
state
most of
will
the
provide some
relevance
information
is,
to you to substantiate
It's going to be
the
related to
convictions.
honesty.
I'm going to
or
unmute.
crimes.
Do you
of
have any
dishonesty.
question about
theft.
the use of criminal records for witnesses and impeachment, at least the mechanism for which to address those as I've outlined here today?
I think once I'm able to review things, I will have a better understanding. At this point, I don't.
That's okay.
understand. So,
Understood.
I do want to just say one thing, and not to that. I just wanted to state one thing on the record, that I did inform the bailiffs that I did not wish to accept the paperwork that was brought off by the detective. I don't know his name, so I don't want to be disrespectful. And
The information I have is Detective Ragland did personally serve you with that. He'll file the appropriate
I'm hearing my
service if
mic's
need
really
be.
low, which is
Whether
weird,
you
'cause-
take that paperwork with you or not back
mean,
to
I
your
can
cell
raise it.
is your decision, sir.
well, I just wanted to
It's just at
put
the
that on
level I
record
normally
that
keep it.
I'm not accepting the paperwork.
Your objection to the paperwork is noted. All right, that might be a good point to talk about objections during trial. It's a good segue. We talked a little bit about that during the testimony today of the jail administrator.
The judge is
Sir,
really loud,
Once again, I direct you to the rules of evidence.
but he's quiet. So
I
I've got it
actually have a
boosted.
large binder that I utilize as judge on the rules of evidence. There are many rules as it relates to the admissibility of evidence, foundation, authenticity, etc., and other things. Typically during a trial, because I'd like to minimize the information that's before a jury, is I ask parties to, if they have an objection, objections, generally speaking, go to testimony or evidence. So for example, if a question is asked that you think calls for inadmissible evidence, you'll let the attorney asking the question fully ask it. You say objection. If it's a relevance objection, I'd like you to say relevance. If it's a hearsay objection, say hearsay.
It's going to be a disaster.
I don't mind a sentence or two. Try to avoid is a full legal discussion in front of the jury. If I feel it's appropriate once the objection is made, I'll either sustain it, overrule it, or I might say to the other party, so if you're making the objection, I would say to the state, any response? They might say something like, let's say you make a hearsay objection. Your Honor, it's not hearsay, it's not being offered for the truth of the matter asserted. That triggers to me, I understand what I need to decide at that moment. And I might say sustained, or I might say overruled. The witness may answer. The jury's instructed that the information or the testimony being provided is not being offered for the truth of the matter asserted, something like that. However, if it's a more complicated issue, sometimes the state will tell me and ask me, Judge, may we have a sidebar? We don't really have sidebars in a situation like this where you're in custody. But using that phrase is still acceptable because then it prompts me to have the jury excused, so then I can have a more full discussion with the parties, hear their legal arguments and reasoning. Sometimes it requires an offer of proof. And so what I'm advising you, sir, is because the state bears the burden of proof, they're going to go first. They're going to present witnesses. If during testimony you believe certain testimony is not admissible under the rules of evidence, you can certainly object. I'll rule on that objection. I ask that you wait till I rule on it. But once I've made my ruling, it's either going to be the witness will be allowed to testify or the witness will not. So whether you're the one making the objection or the state's making the objection for something your witness might say, I expect that you will honor the ruling and then either move on to the next question as the case may be, or, for example, if I've overruled an objection of yours, to allow the witness to answer. And the record will reflect that an objection was made, and that will be there for appellate purposes later on. If we get to a point in time in the proceedings where you have been removed and you are appearing from the other room and you are not able to follow this procedure, I will warn you now that I may mute and probably will mute in those circumstances. You have been given the objection sign. You can raise it.
Objection, erection.
I will unmute
What's
and say the
your
basis for the
question?
objection, sir. You'll state it. I'll mute you
my
again.
God.
I'll rule on it, and then we'll go on. If at any time, though, that even that secondary process is very disruptive, then I will require you to write down all of your objections. And then let me rephrase that. I'll require you to write them down.
I'm going to live
If that means I
moderate
have to
her
wait
volume.
for the sheet of paper to come over, I will. But at some point, sir,
I
I'm going
fader.
to keep this trial and the testimony going. I would direct your attention to 906.11. So 906.11, which concerns the order and mode of interrogation. The judge maintains the ultimate control over that. And if you intend, or if at any point in time you just simply object to every question, that is not going to be acceptable.
Well, what? No,
Because
sometimes you
also
can
under
object to every
906.11,
question.
you can't harass a witness that
Objections
way.
are not
So I
harassment
want to make
unless
that
they're
clear.
frivolous.
Attorney Opper, is that a procedure? Does that answer your questions about the procedures for objecting?
You can raise an objection to every question. You have a right to do so.
Yes,
as
that
long as you
answers
have a
the,
basis for it.
our question as to objections. I did
Even
have
if you
another
lose them
question about, in the event Mr. Brooks has forfeited his right to be present in the courtroom and has been removed, how will cross-examination proceed?
Well, I've reviewed the case law, and one of the possibilities is that he forfeit his right to
Represent himself.
cross-examine.
Oh, what?
He's not
Wait,
in
what?
this courtroom. It's can be challenging to facilitate cross-exam. And if he's able to abide by the rules of
Why
decorum and
Would
civility,
you try and fuck
and
this case over?
whether it be even objections, right, or cross-exam, I mean, that can be shut down, for lack of a better way of saying it.
I understand that, and I know this court
Why
has
wouldn't
been
you
more
just
than patient.
appoint
We would just
competent counsel?
ask the court for its continued patience. We want Mr. Brooks to be able to confront and cross-examine his accusers. He has demonstrated on the 2 occasions so far that we've had testimony, he's quite efficient at asking questions. And
I don't know if efficient is
and
what I
so
would use.
if he is calm and cooperating and not rude and disrespectful, we believe he should be given the opportunity after every
It's not
witness
the first
to
time white women have been
cross-examine.
used to control
Even if he's
black
in the
men.
other courtroom, we should at least make that inquiry, unless it becomes absolutely not an option because of his conduct.
I would agree.
Okay, thank you.
I want to send Darrell Brooks the ballad of Matthew Harris.
I don't. How can I forfeit my right to actively and effectively participate in a trial
That's a really good question for this judge.
if I have
She
to
should not answer
constantly
it
be
because
put
she
in
shouldn't
a
have said it.
separate location? How will I be able to see everything that is going on in the courtroom?
No, that's not
How
the
will I
question.
be
And he
able
lost the question.
to effectively put on a proper defense?
More important is how can I lose my right to cross-examine?
Mr. Brooks, I direct your attention to Illinois versus Allen. That's the case that I've been relying upon regarding your removal. That's found at 90 Supreme Court 1057 from 1970.
Just so I understand, the Supreme Court, the federal court,
That is the Supreme Court of the United States of America.
is that federal?
That is the Supreme Court of the United States of America, sir.
I'm just really seeking to understand, Your Honor.
Sir, that
I
is
don't
the Supreme.
understand, so
Sir, I've answered the question.
you have, but I'm.
He's going to argue that he's not under federal jurisdiction, he's under state jurisdiction, which is wrong.
Sir, I'm not going to explain the law to you. I cannot do that.
I'm not asking you to. I'm asking, is that a federal court?
All right, I'm going to move on to the next topic. You related
question
to
of whether the
objections would
Supreme
also
Court
be
is a
to the
federal
admission
court
of
is
evidence.
A
Of
complicated
course,
answer,
my
actually.
standard
It
practice
is,
when
also holds
a
authority
party
over state
offers an
courts on
exhibit
constitutional issues.
is to say any objection. And so if there is an objection, of course, there needs to be a legal basis. And then once I rule on that objection, then I expect that decision to be respected and honored, and the testimony and presentation of evidence continue forward.
So, Your Honor, I still don't understand. How am I expected to do everything in a legal basis, in a legal manner and everything when I keep informing you, Your Honor, on record in open court that I did not understand, that I still have yet to understand the
Rule
true
him
nature and cause of the charges against me, which I don't understand. There's so many things that I do not understand.
Rule him
that I keep
incompetent.
explaining to you, Your Honor, that
Mr. Brooks, I'm going to refer you back to document number 244, which is the waiver of right to attorney form that you willingly, knowingly, intelligently,
Not intelligently,
from my
sweetheart.
perspective, understandingly filled out. Let me make my ruling, sir. Do not interrupt, or you will be muted. All right?
just mute me, Your Honor.
So from my perspective, sir, we clearly went through not only this form, but really the topics that are referenced in this form, the advantages of having an attorney represent you, the disadvantages of representing yourself. I discussed with you and advised you regarding all of the charges that you face, the penalties that you face, the exposure that you face. I advised you regarding what an attorney would do. I further advised you about the disadvantages of representing yourself. I asked you such questions about whether anyone, forced you or coerced you to waive your right to an attorney. I asked you if anyone had made any promises to you to waive your right to an attorney. I made a finding, sir, that you freely, voluntarily, intelligently made a deliberate decision to waive your right to counsel and to represent yourself. I refer you to that document, sir, because once again, I cannot give you legal advice. I cannot explain court procedures or the law.
Done it several times now.
And you represent yourself at your own peril. I honored your request to represent yourself.
Revoke it.
And it's a bit disingenuous to now say you don't understand what you did.
But he doesn't.
So we're going to keep going. I need to go through some other topics.
He clearly has no idea.
You are not muted, but there's nothing for us to discuss at the moment.
I'm not trying to discuss anything. I was just letting you make the record, which I haven't been afforded the opportunity to make the record when I offered for my appeal. Again, I do not understand, and Your Honor, I think it's very unfair for you to say that you're finding that I understand. How can you tell me what I understand and what I don't understand? I've clearly made that very, very clear that I don't understand. And the same document that you referred to that I filled out specifically crossed out the word understand. Why did I do it like that? Because I do
All right,
not
Mr. Brooks,
understand.
I'm going to mute you because we're off topic. We've gone over this time and time again. I understand the objection that you're raising. You once again are claiming that you do not understand. I make findings in this courtroom based upon the available information, the law, and my decision is all in the record for which you can appeal at a later point in time. But we are going to continue whether you claim to not understand. All right, so I need to add
He also
one
kinda
instruction
demonstrates it,
to the
though.
preliminary jury instructions. Have we provided Mr. Brooks with his another copy yet?
Not another copy, just the one from last night.
So the one from last night, my understanding is he left in his cell.
Of preliminary jury instructions? Not that I'm aware of, no.
So you can print off what we have thus far for him,
By the
Madam
way, the
Clerk.
court's found him competent,
Um,
and that I don't think they're going to get a mistrial
And
on
I'm
him being
going to
incompetent.
just make a
but she might get
modification and
mistrial
print
if she
off a
takes away his right to
separate
cross-examine
instruction that I have crafted
witnesses.
regarding
That's the problem that she's going to run into. It's the other
decorum and
issues that
courtesy
come
in the
along
courtroom.
with his incompetence.
I gave her a copy to give to him.
Oh, our bailiff has,
Witness lists.
that was with the witness list?
No, I did that earlier, but I was printing a bunch of things.
That's the competence
So
issue.
put on the
He's-
record, Madam Clerk,
he's
what you believe you provided to
competent,
Mr. Brooks
But if he's
already.
so disruptive that you're gonna take
All
away
right, so
all
he
of
was
his
provided
rights,
with the packet
trial.
of preliminary jury instructions.
just rule him
So let me
incompetent.
I just need to add a line in here. I'll print this here for the state and I'll print it in the other courtroom. There's a printer over there as soon as I do that.
You mean just this one?
Just this one, yeah.
Okay.
She can assign him a lawyer against his wishes. Yes, she can do that. She can decide that he is incompetent. The court can make a finding. He can object to that if he wants, and then they can appeal that issue. But they can she can make the ruling if she wants to, and appoint counsel back to him. Yes. Romo Drummer says, "Sniper judge, hubba hubba." Stephen Goldstein says, "Did someone just threaten the life of the judge in this chat?" I have no idea. I doubt it. Stephen Goldstein also says, "It is a federal law and state law to threaten a court or their employees. It is a very serious matter. And because it's done here, it's a federal offense." Yeah, calm down, because true threats are true threats. And words on the internet often are not true threats. So if I say, "I'm going to kill the judge," that's not a true threat. There's no intent to convey the threat. There's no understanding that the judge might hear that threat. So actual threats are very different from someone just saying something.
Right.
But thank you for
A copy of this should be
contributing. Evil Bunny
on
says,
the
"Here's
printer
20, a grifter."
in the
Oh,
courtroom.
and Bunny. Hey, thank you.
And then I'm providing a copy to give to the state.
Did you email that to me?
I sure can.
Let me find out where we were. My window keeps resetting. Mary M. Hi, maybe I missed it, but did the court mention his haircut and why he was changing his appearance? This is such a disservice to the victims. I mean, you can do your hair however you want.
All right, I'm going to unmute Mr. Brooks for now.
Like, changing your appearance for court is very common.
I was not looking at the monitor because I was sending the email to my clerk with that document, but I just like to get confirmation at least it was put in front of him on the table. Whether he accepts it or not, I understand, but Mr. Brooks, was that piece of paper placed in front of you?
I don't accept or consent to any paperwork.
Judge, I did see on the monitor the bailiff set some paperwork on the table in front of Mr. Brooks.
Stop
and he
being a
took it
witness.
off the table and set it on the floor next to him. it
Stop being a
appeared.
witness. You're
All
an
right, thank
attorney.
you, for making that.
Accept or consent to that. I will
Mr.
not
Brooks.
accept any more paperwork.
All right,
period.
Mr. Brooks, you've made clear you're not going to accept paperwork, but we have an obligation, whether you make that statement or not, to provide you with copies of everything the court is addressing with the parties. So what you do with them is up to you. So your objection is noted.
You may be aware that certain things are not going to be awarded, especially when it comes to fairness.
Mr. Brooks, I need to move on to the jury instructions. Are you willing to participate in this process right now?
No, I am not. And I don't give consent without me being present in the courtroom, like I said before I was brought over here.
Would you like to come back over?
So why would you ask me that? Why would you ask me that?
Mr. Brooks, you were put over in that courtroom because of your disruptive behavior. If you can agree to abide by the rules of decorum and courtesy,
I'm not gonna
then
agree to
I will
anything.
bring you back over here at any point in time.
I won't agree to
Did you
anything.
Did you hear me
Won't do
advise you
anything
of that,
ever.
sir?
No, I did not.
You're advised, sir, that if you want to come back to this courtroom, you may make a request at any point in time. If you come back, the court
I'm trying to
expects you
adjust their
to follow the
volumes,
rules of
by the
decorum
way,
and courtesy
as
that
they
you've
exchange,
previously
'cause
been
he's so low and she's
advised
so loud.
about.
So,
But I don't have two
this is
separate
how
channels
it's gonna
for
be
it.
the whole trial every time I seek to understand
Mr. Brooks, I'm
something.
offering you the opportunity to come back to this courtroom to participate here.
I don't wanna go over there and then essentially have to come back right over here because when I ask something that I don't understand, it's being looked at as me intentionally trying to disrupt the court.
Mr. Brooks, I'm asking you a question. Please
I'm asking
answer.
you a question.
Would
I asked you
you-
a question as well, Your Honor.
Would you like to
I
come
asked
back
you a
to
question
the
as well.
main courtroom right now? Yes or no?
I asked you a question too, Your Honor. I asked.
All right,
is
I'm
this
going to
gonna be
mute
how it's
him.
gonna go?
I'm going to make a finding that his decision to not answer the court with a yes or no is non-responsive. I repeatedly asked him if he would like to come back to this courtroom. He did not answer yes. Instead, he wants to debate with me about his understanding or lack thereof, and rather than discuss the topics at hand. I find that behavior to be rude, to be disrespectful. I find it to interfere with the orderly administration of justice. I want to continue with the preliminary jury instructions. Of course, it is always my preference to have Mr. Brooks in this courtroom, but as he has been advised repeatedly, in order for him to maintain his appearance in this courtroom, he needs to abide by even the most simplest of rules.
The most
and that is
simplest?
to not interrupt. I will not tolerate
ruffled.
disruptive conduct that, from my perspective, is simply an attempt to avoid being tried on the charges brought before this court. All right, so I have a packet of jury instructions, and if I didn't state it,
God.
obviously
Mary
the
M
record should
says, "Hi,
reflect
maybe
I
I
have
missed
muted
it."
Mr. Brooks.
Oh, wait,
He'll
yeah, the
remain
haircut
that
thing.
way until he sends me a
ML
note
Jeff.
indicating he'd like to be unmuted and that he will comply with the rules of civility and decorum.
I'm a
All
soy
right,
boy
so
in
I've
dire need
provided
of a
the
workout
parties with
motivation.
a
Don't hold
packet
back.
of
I'll be
instructions. There are
listening to it before
68
every workout.
pages.
I'll do it when it's quiet.
Attorney Opper, will you or Attorney Basie be addressing the preliminary jury instructions?
I will, Your Honor.
All right, do you acknowledge receipt of those?
Yes.
All right, I will put on the record that the 68 pages were also provided to Mr. Brooks earlier today, I believe, at the start of the hearing. And then he was also provided with the single-page proposed instruction regarding decorum and civility that the court has drafted. Has the state seen that as well?
We have.
The only thing I'm noting at the moment on page 1, Madam Clerk, is a footnote that needs to be taken out. Then, does the state have any corrections, edits, or suggestions at this time?
Your Honor, we do not. We did have a typo with regard to the name of one of the victims. I did email your clerk. I believe it has been corrected, but if not, it would be regarding, it was on page 28 of 69, specifically count 65. And the first name of the victim was, there was an S that needed to be removed.
Did you say count 65?
There's an
Correct.
S. The S needs to go.
There's an S in the first name that needs to be removed?
Correct.
All right, I must have the old copy, but I'll make a note of that.
I had to do a save as.
Okay.
RZEQ says, after a year making it happen,
Anything
I finally
else?
got my Raver meeting group going. If you're ever in Austin, join us. Let's just say you won't be
My
the only person
thought
having a magical
on
experience.
the
You won't be the oldest there either.
instruction
Ooh,
that
sounds
I've
fun.
provided to the parties, there is instruction 70, which I have an old copy, so I'm gonna can you email me the most recent copy, Teresa, so I'm on the same page, literally
Or I could share
and
it.
figuratively with
Or
everyone?
would you rather I shared it?
Sure. Mr. Brooks is raising his objection sign. If he has an objection, he needs to write that out and provide that to the bailiff so that I can then take it up. So, no, it would be a far ahead. 70 should be right after 59, police reports.
Why would 70 be after 59?
It's all the way up, 70. All right, so as
I
the
don't think they math well.
parties can see on the monitor, 70 is the instruction that is entitled in the drafts that are provided by the standard or pattern jury instructions. Preliminary instruction, defendant proceeding pro se. Now, I would note, none of these headings are read during the advisement to the jurors. It's really so we can keep an orderly list of the instructions. My practice is to simply read, starting with the substantive. So that is the pattern instruction. It's been modified to make sure it says himself versus herself and the name of, actually it just says defendant. There is no name.
Meister Cross
And
says, how would
my
he testify and be his
suggestion and
lawyer?
what I intend to do is to
Court may make it,
right
may allow him to make a
after
statement on
where
the
it
record.
says in any
can't
manner
ask
is to
himself
start a new
questions.
paragraph. So just underneath that, whether it has a heading or not, I don't think is relevant at this point in time, but to read the following. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that Mr. Brooks's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance, are expected to conduct themselves appropriately and avoid creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. I would not read the SCR unless there's a request to do so. That is there just for reference. That's where I pulled that from. There's a second part to the proposal that if at the time the court reads the preliminary jury instructions, Mr. Brooks is not in the courtroom, then to add the second where it says to be read only, that says at the moment Mr. Brooks is appearing from another courtroom, this must not influence your verdict in any manner. I understand Mr. Brooks is objecting. I'll give him an opportunity to make any statements regarding that on the record. I'll ask the state first whether there's any objection to inserting this in that location.
No objection to it. Inserting that, I would just note that in all of the jury instructions, I don't think we've ever mentioned Mr. Brooks by name. I think it's always been the defendant. I don't know if the court wants to be consistent. That was my only comment.
I think it would be good to be consistent. If I read this at all at other points in time, I will use his name that I have listed on this proposed. All right, Mr. Brooks, I'm going to unmute you so that you can put the basis for your objection on the record.
Basis, I'm an idiot.
Yeah, first of all, I'd like to state for the record that I'm pro per, not pro se.
It's the same thing.
What you just said about keeping it consistent, then it's been in this form ever since it was brought up. So why start to change the language and logistics of it now at this point to constitute me being in a separate location? If it's going to be consistent, then it should be consistently as it was constructed. Nothing should be changed.
Sir, do you have, want to make any statement related to the jury instructions that I've provided to you, whether you object, consent, agree, or otherwise?
No, I don't consent. I do not.
All right, your lack of, sorry, go
I
ahead.
just stated the reasons why.
Is that to
You
the
just
whole?
said so yourself. You just said so yourself. They need to be consistent. So why does anything need to be changed at this point?
As to the entire packet that was provided to you, noting I've made this change, I will,
didn't
hold
accept
on,
anything
hold
that
on,
was.
hold on. I will advise you that as to the added paragraph, I will make it consistent with the verbiage and the pattern instructions and refer to him as the defendant. However, if I have to read this instruction at other points in time, I will be reading it with the verbiage of Mr. Brooks. I do that, frankly, out of respect for him. But the pattern jury instructions are constructed in such a way that I'm going to follow that pattern when reading instructions, with the exception that I've just noted, and that is if I am in a position where I feel it important to advise the jury, whether it's just simply that he's in another location or another courtroom, this must not influence your verdict in any way, or if I feel it important to read the entire thing. I'll take out the reference to SCR 62.02 sub 1 sub F and H. That was really just so the parties understood where I obtained that language from.
Was being changed, or is it? I don't understand.
I changed where it said Mr. Brooks to the defendant. And that, I think, was in
No.
two.
Still saying it. It still says.
Is it in the court is
That name.
ensuring that part?
Yes, so right there. We're in the process of changing it, sir. My clerk is typing as we go along.
Thank you. And I also want to make
Small B.
state this on the record. You just referenced wanting to protect my rights, correct?
Oh God.
You have the language in front of you, sir.
Well, you just said on record that you would want to preserve my rights.
Mr. Brooks, you have the language of the jury instruction immediately on the screen in front of you. Do you have a question or a position on whether that's included?
I was getting to that. You did not let me finish. So it's not a question. Like I said, I was stating for the record. Part of protecting my rights would be the ability for me to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
Do you have a jury instruction that you would like me to read that would state that? Have you drafted anything, sir?
I wouldn't need to draft anything if it's already in the Constitution. I should be able to be afforded for those rights to be protected under the First and Sixth Amendment.
I'm sorry, I mistook what you were saying. I thought you wanted me to add a jury instruction, a written jury instruction, so that I would read something to the jurors. Am I mistaken on that?
I'm not gonna consent to any questioning about that. I think it was very clear what I was asking, because I'm referring to you saying that you would like to preserve my rights. And part of my rights being preserved is to be able to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
So, as I understand what you're saying, sir, I think what you're asking this court is to add an instruction, because the jurors get informed. Hold on, let me finish. The jurors are informed of the law through jury instructions. These are the pattern jury instructions, with the exception of what I've just added to number 70, which I feel is appropriate in this case. If there's something additional, then tell me what it is, and do you have a draft to provide to the court for consideration?
Well, how about this? Since it's clear that you're not grasping quite what I mean by what I'm saying. How about I draft something up and get it to you as soon as possible? Would that be sufficient for your honor?
If you draft something and submit it, and we have it by tomorrow morning, I can address that on the record, and whether it will be included or not. So yes, that's acceptable.
For the record, also may I state,
Hear that
it's
sigh?
going back to the language that says pro se. Can that be changed to pro per?
That's not read to the jury. It's just part of the labeling.
Just say yes. It doesn't
But it is my
matter.
pattern, but it is the pattern jury instruction. That is a phrase that has meaning in Wisconsin law. It is accurate, and so your request to change it to pro per is denied.
Okay, how is it accurate?
That's my ruling, sir.
I don't understand, so I'm just seeking.
Mr. Brooks, that's my ruling. I need to finalize these, Mr. Brooks, I need to finalize these instructions. So my question to you is, oops, you can take that up.
I did have one suggestion.
Okay.
On the second.
Hold on, just,
Sorry.
Mr. Brooks, what I want to tell you is, I'm going to finalize these. The state has a suggestion for verbiage within an instruction that's already in there that I'm going to address. I'm then going to ask you whether you have any other edits or requests as it relates to them, and then ultimately ask you whether you approve of these or not. I just want you to be advised
Spoiler
of that.
alert, he's
So
not
go
going to
ahead,
approve.
Attorney Basie.
Thank you. On the additional language that the court is adding to jury instruction 70, I would just state on that second sentence, my job includes making sure the defendant's rights are protected. So I think that should be the.
Right there.
Yep.
Riveting.
Or I could just read, sure, the defendant's rights, whatever.
He's objecting for changing that to the, which is a.
Since nobody's saying anything, part of my rights being protected would be to be able to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys. That's another right that's not being protected.
If you're requesting that language be included, the request is denied.
And is that a judicial determination that I won't have?
I do not believe that accurately states.
Right preserved.
I do not believe that statement accurately reflects the law. All right, so we'll make Mr. Brooks, I'm moving on.
Can you show me by?
Mr. Brooks, I'm going to mute you. I'm not required to show you verification of law. Again, I direct you to the waiver of right to attorney form, a copy of which has previously been provided to you about what this court can and cannot do. That's a very good summary. If you have any other questions about what the court can and cannot do, I also direct your attention to the Supreme Court rules. My understanding is you have access to legal materials, and there are a number of rules that apply. The Code of Judicial Conduct is SCR Chapter 60. All right, we've made that change. With that change, does the state approve of the jury instructions?
Yes.
All right, Mr. Brooks, I'm going to ask you that question. Actually, two, do you have any, and you're raising the objection. Hold on, you're raising the objection sign. It's noted for the record.
I'm going to continue doing it. That's the only way I can.
No, I know, and I'm making a record of it, sir. But we're at the point in time, do you have any requests for edits? Let me finish the question, sir. You're interrupting. All right, I'm gonna have to mute him again so that I can get my question out. Mr. Brooks, my question to you Do you have any other requests as it relates to edits, other instructions, or corrections of the 69-page instructions that you were provided with?
69
And the
or whatever.
added instruction that you were able to see on the screen. Go ahead, you are unmuted.
I wasn't looking at anything on the screen, and I already made clear on the record, and you just confirmed on the record that I would be able to draft something up and get it to you. So why can't I address anything in that draft?
Sir, I am addressing what we have now. So I will ask you now at this point, since you've not answered my question, I understand that you're going to draft something. Other than that, do you have any other edits, corrections, or requests for inclusion at this time related to these jury instructions?
Yeah, you still haven't answered if I'll be able to inform the jury of the truth, their rights, and their duties.
Sir,
They have.
I have provided an answer to that.
He
All right,
wants to
I'm going to
make a
object.
jury
I'm going to
nullification
not object. I'm going to
argument.
mute him again.
Can't
I
make that
have
in court.
told you you will have the opportunity to draft a proposed jury instruction for inclusion with this packet. At this point, he hasn't answered my question directly, and by his responses, I will make a finding that he's not responding. It's a non-response type of answer. Because I've advised him as to what I intend to do, I am going to approve the jury instruction packet that has been provided to the parties and modified on the record.
He wants to make a jury
Yeah, I do have
instruction
one other
or
change I
for
just noticed.
jury
ahead.
nullification.
It's with regards to the bail jumping jury instruction. I know we had talked about this verbiage before about the theory of that charge. The theory of that charge is that the defendant committed a crime. It was our belief that they did not have to be unanimous on the crime that was committed. As I look at the jury instruction and it's talking about the third element, it says the state must prove by evidence, and I'm on page, 66 of 69. Your paging may be a little different because I think you have the added verbiage. Elements of the crime that the state must prove.
And guys, on the volume issue, it's on the back end. I can't do anything about it. So I'm just trying to kind of be quiet.
That one?
No, it'd be if you go down to the third one and the paragraphs that follow.
Right.
Number 3. So the last paragraph before deciding about intent and knowledge, it indicates the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, and battery. The crimes, and then it lists those same crimes have been defined for you and should apply the same definitions here. I would just indicate, I believe it should read hit and run resulting in death or battery. I believe that they do not need to be unanimous on the crime that they select, but they do have to be unanimous that he committed a crime.
Any case law or other support for that position?
No, Your Honor, I know that the court had addressed the hit and run, that they don't have to agree on which ones they violated, and that would be the analogy I would make. I know we had talked about that previously. I mean, what we could have done is to Mr. Brooks's benefit, that we did it this way because it's only 2 counts of bail jumping versus doing 1 count of bail jumping for each crime that he is alleged to have committed. We put them together, I guess, to the benefits, and he may not see it that way, but to his benefit.
Mr. Brooks, the state is specifically asking that I change the word "and" to "or" under the third element of bail jumping based upon their theory of this case and the bail jumpings and their belief that the jurors do not need to be unanimous as it relates to which crime was committed. And they're asking that I insert the word "or" as indicated. Do you have any position as to that?
Yes, I do. And I'm gonna base my position off of what you just said, that there is no case law to support why it should be changed. I believe that it should be whatever it is right now, that the word "or" whatever should not be omitted. It should be how it is right now, as apparently it was intended to be
Good
that way
argument.
all the way up until this point. So why change it now? Let's just leave it alone and leave it where it is.
Well, actually, sir, the pattern jury instruction was modified because of the charges in this case based upon the state's proposed jury instructions that were previously filed. The pattern jury instruction basically deals with a single criminal law violation. That's not the theory of the case for the state here in this case as it relates to the bail jumping counts. So I just want to be made clear that it's not a change that they're asking to the pattern instruction in terms of what would have been there previously, because it already was modified based upon their theory in this case. To say it another way, the pattern jury instruction didn't contemplate, and they're just that, they're pattern jury instructions. Oftentimes the courts have to modify based upon the particular nature of a case. My question to the state, and then will be to Mr. Brooks, is if I adopt the request from the state, do I need to put in a similar statement like what is in the hit and run about you don't need to be unanimous as to which crime he committed, but you need to be unanimous that he committed a crime?
I think that would be helpful to them. I think the paragraph before the one I just recited says the defendant is charged with violating a condition of bond that required that he not commit any crime. So I think that verbiage would be consistent with that first sentence.
Any position on that, Mr. Brooks? Or sorry, go ahead. Any position on that?
Yeah, I don't agree with why should it matter about a unanimous or not being unanimous. If that was always the case from the beginning, then it should have been changed at the beginning, not at this point where everything is so close to being decided.
He literally has no idea now what he's
I don't
talking about.
understand why it needs to be changed in any way, why it needs to be altered in any way. I think if it was going to be that they have to be unanimous, then let it be unanimous. Let it be unanimous.
It will be unanimous.
Right, I agree with the state's position. I think that's the most appropriate under the law, given the violation of bail jumping. It can be a variety of different ways, but in this particular case, the state's relying upon that statutory subsection for violating any crime. So in element number 3, it needs to say The state must prove by evidence the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree reckless endangering safety, use of a dangerous weapon, hit and run resulting in death or battery. And so that I actually took out where it says crimes, I changed that. I took out the S as well. I think that you would need to do that, or I would need to do that in order to be consistent with the or. So I'll make that change. And then
I mean, that's the right language.
I'll make the suggestion that at least, that at the minimum, it would say alleged crime, as I have not been convicted of anything.
I understand what you're saying, but these are the jury instructions that tell the jury what the elements of the offense are. It's very clear when you look at the jury instructions in their totality that these are the elements, that the state bears the burden of proof. There's other parts of these that talk about an information, that these are, that can't be used against you. I believe your concern is adequately addressed when you read the jury instructions as a whole.
May I ask Your Honor, if there's anything that I can look up myself that would help me better understand this?
Yeah, the jury instructions that are on the screen right in front of you.
I can't answer that for you, sir. I can't explain the law to you. I know at times I've provided you with resources. I mean, what I have available, but I have no idea if you would have access to, because it's through a publication, I believe through the state bar, are the jury instructions. I'm not even sure if what I have, to be honest, I know I get them through the Director of State Courts office. I have them available electronically, and the Jury Instruction Committee, which is, let me take that back. It's through the law school because of the Jury Instruction Committee. And it's a publication. I'll be honest, I don't even know how the public gets access to them because of how I get my access. It's just something that the Director of State Courts office provides to me through my judicial dashboard. And so, but what I wanted to say is those jury instructions come with comments. There's also special materials. I don't know how you access those outside of the way I do. It's been over 10 and a half years since I've practiced law, and the whole electronic access to these types of things have changed. So I'm just not able to answer that, sir.
And Your Honor, I think I can provide some clarification. I believe that they are accessible through Wistlaw, and the defendant would have access to that on his tablet.
Oh, thank you.
I'm sorry, on the computer in the conference room.
All right. You'll want to probably check the computer out to see if that's true, but the state has information to suggest that you would have access through Wistlaw to the jury instructions. The packet that I'm giving
The
you
Wisconsin State
has
Library
all of
Law
the
Library
numbers
online
on them, so
has
that
all
should
of the
help
jury
you in
instructions.
your research of them.
If you want to look at
I
them,
think what
go
the
into
most glaring part to me of my misunderstanding is the unanimous thing. I think that's what I'm really attempting to wrap my head around at this point.
Right. I'm trying to find the language in the hit and run about
if you
the
want to look
duty
at it, go to Google,
that might
type in Wisconsin
that I would point you
crim
to.
jig.
Is that acceptable to you, Your Honor? That's wrong.
Your Honor.
61 of 69 under number 3.
Oh, right, I found it. So I'm just going to point you to, under the jury instruction for duty upon striking a person, which is instruction 2670, under element 3, there's a portion of that that says, the state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the two duties, but you are not required to agree as to which duty was violated. The proposed language that I would have is that the state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree as to which crime was committed. And I would put that, we're talking about the bail jumping jury instruction. It's also element 3. Right after where we says all of these crimes have been defined for you, and you should apply the definitions here. I think it would make sense at that point to say the language I just proffered, which is the state is required to satisfy you beyond a reasonable. Actually, let me take that back. I'm looking further up where we're closer to the number 3. So it's my page 65. I don't know if it's 65 or 66 or 64 in yours, but where it starts with the defendant is charged with violating a condition of bond that required that he not commit any crime.
What's up?
This is.
What have I missed? Jury
And then it
instructions?
has a paragraph, and then there's another paragraph that starts, the state must prove by evidence which satisfy you beyond a reasonable doubt. It's before I say the crimes of have been defined, that's where I think it should be inserted. And so, Madam Clerk, where we made the change where it says or battery,
Yes.
then we'll include the following language. The state,
Before or after the period?
after, it'll be its own sentence.
Okay.
The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree as to which crime was committed. Mr. Brooks, when we get done here today, I think it's fair, since we've been here quite long. I don't intend to have a very lengthy discussion tomorrow, but I'll print all of these off for you so you can review them tonight. That'll also give you an opportunity to look at some of these topics, as well as if you want to draft your own instruction on some law. And then first thing tomorrow morning, we'll have a very brief discussion. It's only on these added the language, not the whole packet. The other parts of the packet have been approved by this court, but that'll give you an opportunity to further look at it. And Madam Clerk's going to read it back to me to make sure it says what I want it to say. So go ahead.
So after hit and run resulting in death or battery, the state is required to satisfy beyond a reasonable doubt that the defendant committed a crime.
Hold on, you're going to need to slow down a little bit.
Sorry.
No,
and I think
speed
there's already a word missing. Let me just get to that.
He wants to explain to the jury their First and Sixth Amendment obligations.
It's only not too bad.
Okay, go ahead and start over.
Wait, I was just informed they couldn't hear me in the other room, so I'll speak up a little bit. After resulting in death or battery, the state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you do not need to agree on which one.
But you are not required to agree as to which crime was committed. And then the language will continue. The crimes of, all of them will be listed, have been defined for you. The remaining part of the instruction remains. Again, I'll give this to the parties. It's been another long afternoon. It can be a little hard to follow these things, even when they're in front of you. As you can see, there are 68 pages of instructions. I think it's reasonable to have these all printed off and give Mr. Brooks and the state one more opportunity to review them for final consideration first thing in the morning.
Just so I understand for the record, the jury instructions that you have are the ones that we're going to use. I can't make a few of my own.
You can still, if you want to draft something, you have to submit it so that we can consider it, but it has to be in writing. And keep in mind, sir, jury instructions are read by the court, and they're statements of the law that I give to the jury so that they better understand their functions as a juror and the law that applies to this case. But you have until tomorrow morning to bring that to court in written form. If it's accepted by the court, my clerk will type it up and we'll insert it in the appropriate spot. If it's not accepted, then it won't be included. But as to what we specifically have before us today, not including the language that I just changed, so everything but the bail jumping, element 3, do you have any objection?
All of it. He's going to object to all of it.
I heard one or two things he should object to.
Okay? You have to give me a legal reason, sir, or are you just stating an objection that you don't consent, which I'll note for the record if that's the case.
That issue about the not unanimous on the bail jumping, it should be unanimous which offense, I think.
What I said before,
Okay.
at this point, I don't see why. I guess essentially what I'm saying is if the issue was never raised before and there's been ample time, at least for the prosecution, to review the questionnaires, or not the questionnaires, I'm sorry, the jury instructions. What prompted the change now all of a sudden?
Because this is the time in the proceedings for the court to finalize those and to address any modifications. That's standard protocol.
Yeah, that is 100% standard.
Yeah, I think he's actually on the cusp of asking
All
the
right,
right
your
question, but
objection
he
is
doesn't know
noted,
why.
sir.
Yeah.
I am approving everything that's in there. The parties will still have an opportunity to look at the change to the jury instruction on bail jumping. Mr. Brooks will still have an opportunity to submit any additional proposed instructions tomorrow morning, but at least we have this packet that's been approved, again, with the one exception on the bail jumping charge under element 3.
It has to be in writing, just so I understand, everything's in writing.
It does have to be in writing, sir. That is a requirement.
So would that be in a form of a motion or just a simple writing? I don't understand.
Sir, you can simply submit proposed jury instruction, okay? But it does need to be in writing because that's how I will need to review it.
Yeah, I follow that part. I'm just, like I said, I'm just trying to understand what it needs to be written up as a motion or just a simple writing.
It can be a simple writing. You don't have to put a motion. I'm allowing you to submit a proposed jury instruction or instructions, I guess, if that's your choice. I don't know what you have in mind, but you can submit those tomorrow.
Well, you know what I got in mind.
Yeah, I have it. I just wanted simple clarification. That was all.
I appreciate
don't
you seeking that.
understand, so.
All right. As to my list, other than the motion for reconsideration, did I overlook anything?
I don't know if you want to discuss exhibits, Your Honor, and
Your Honor.
I did want to say for the record, we did file what we have currently is 8 pages of exhibits, numbered 1 through 140. It's a combination of videos, photographs, and documents. I did have that 8-page list hand-delivered to Mr. Brooks earlier by Detective Reglin. That's one of the documents that he's stated he will decline to accept. However, it's an important document and one that he would be well served to read. In addition to that, Your Honor, we've had all 140 of our exhibits saved to a thumb drive, and
That's
Detective Reglin hand-delivered that to Jail Administrator Wollenhoff this afternoon, so that if Mr. Brooks wants to look at our exhibits tonight, he can do so. He just has to ask the correctional officers for that thumb drive with the exhibits on it. And he can see all 140 exhibits that we've prepared so far, and have a very good indication of some of the evidence that will be presented against him during the trial. I do have a question, Your Honor. I
That's not that many
understand the
exhibits,
court's
really.
order about you want digital exhibits. We have some physical evidence, not a lot. We have some physical evidence that we're going to, and it's later in the trial, so we
they're
don't
gonna show some
necessarily
bloody
have to talk
clothes
about
and
it
shit,
tonight.
I guarantee
I
it.
want to put the court on notice.
Run over instruments.
Our standard routine
Dead
of
kids.
presenting it to the witness on the witness stand. We
It's
have
not
to
exhibit.
work around that.
That's what they're gonna put.
Well,
Pictures of
that's
dead
about to
we
kids.
bring it
have
out like the actual
some
kid. Like
large poster boards that we
Please
have
zoom them
prepared that,
Like the
we,
monster
hilarious.
or something?
yes, maps. And we had those
Maps.
prepared, weeks
Like
ago
the map of the
before
road he
we
drove.
got the court's order.
On the wall.
yeah, Keffels. is
Frankly,
making
and I
that
know
turn.
the court's aware of this, but it's going to challenge the prosecutors greatly by our inability to move around the courtroom. And I understand the reason, but I just want to put that on the record. We are wondering, as far as the exhibits, our paralegals prepared to present them all from our table, but specifically for like photographs and documents, should we print out a copy and have that marked and received so that if the jury wants it during their deliberations, they have a printed copy? I understand with videos that won't work, but photographs and documents that may work.
I've had that done in other
Unless someone
trials
marks on the
where
exhibit.
even though it's been presented electronically, the attorney has also submitted that paper for photographs, exhibit, things of that nature, so that it's available if needed for the jury. And
See if this helps.
I think that's fine. I certainly would approve of that. We also have the ability, when the jury is deliberating, to present any electronic evidence directly to the jury room. We would all see it in this courtroom. So if it's videos that are playing, if they request a video, that's how that would be done. But even if it's a succession of photographs, that can be done, or even other exhibits, like paper exhibits, things of that nature. I personally prefer that there are the photographic copies and paper exhibits as well that have the numbers, and those are the actual exhibits, but what you're displaying is obviously a replicate of that.
Okay, so we will do that for photographs and documents. Obviously, the videos we can't. Can we burn all of our exhibits onto one thumb drive then and have that essentially entered into the court record?
I don't have any objection to that.
Okay.
CCAP might have another position on that, but that's okay.
And then as to opening statements, I understand the court's order. You want us at our tables. Would the court reconsider that in the event Mr. Brooks is not present in this courtroom for the state's presentation of opening?
At this time, I would not reconsider because, as you know, I oftentimes invite him back in or require him to come back in, and I don't want to be in a situation where now I've let you do that, but I can't let him do that for what I think are obvious reasons to
Oh, I
everyone.
see. Okay.
So,
But we can stand up at our table during
You
openings.
can stand up, yes.
And he can too.
He can stand up as well.
You
Okay.
can stand up and walk around. He did earlier.
Yeah.
Podiums. I can address poster boards and physical evidence. I will make an exception to approaching witnesses for those types of things because it's a limited exception to my rule, and I wouldn't, how else would you be able to do that, right? I mean, the poster boards, you might have those electronically in some other format that you could use. You might want to use the annotation. Just for the record, Mr. Brooks is handing up the objection sign. We're just talking generally about procedure. There's no exhibit or to specifically object to. I'm not sure if you're objecting to procedure, but I'll get to that in a moment. Certainly physical evidence, you need to make certain, there needs to be certain foundational testimony. They're going to need to see those pieces of physical evidence. I understand that.
Okay.
Anything else?
Please
No.
finish.
Thank you.
Mr. Brooks, you raised an objection or?
Well, yeah, because I didn't want to have to try to write something and then have to send it over there. I really was raising it so you would know I wanted to say something, but still not interrupt. Just so I don't understand, what the prosecution is saying by burning the exhibits onto the flash drive and then admitting them into the record. Is that then essentially when things will be admitted into evidence? Because I had that issue yesterday when I asked that question. Because I have exhibits too, and I have some things that I would like to offer into evidence as well.
So I'm not talking about like admitting things with specificity at this moment. I'm talking about some procedures. I'm trying to frankly be mindful that you're in custody, sir, and that even though when you appear before the jury, you're dressed in civilian clothing, like the suit that you wore the other day, but I am taking steps to ensure they don't see the restraints that are on your ankles. And because you have that physical limitation, I now am adding or have added a limitation to the state on, for the most part, physical movement within this courtroom. That's why there's no podium. They're not going to make opening statements or closing arguments from a podium. It's really to, in my words, level the playing field, if you will, and to ensure that as the parties appear before the jury, it's on as level of a playing field as I can provide. So if you have documents, we have a thing called a document camera, and so it will be in use. It may require the assistance of the bailiff because my understanding is, and we can talk internally to find out if I need to have court staff, whatever. My understanding is it has to be on the state's table. I'm not sure where it went. It's usually been there. And so it's possible, we'll find it. It's possible. Okay, it's been moved. We'll put it back, but it has to go on the state's table. So if you have a document, sir, it might require you to pass it to someone who then puts it under the document camera, and assuming the witness, it's appropriate, meets the rules of evidence, it can be authenticated, there's a proper foundation, etc. And if I receive it, once you hear the phrase, the exhibit's received by the court, that's when it becomes an exhibit that the jury then can use. Does that answer your question?
Not really. I think, I'm sorry, Your Honor.
That's okay.
I think what I was referring to more as, for things to be able to be offered into evidence. So was that answering that? If it was, I apologize.
Do you have the exhibits? Are they paper? Are they electronic? Are they something else?
They're unbreaded.
Well, I'm sure the majority of them would be paper.
So sometimes there's something in the discovery that's electronic that a defendant wants to use at trial. And I have typically asked the state for assistance because they have all of that. At least that would be my understanding. If there's something specific, though, and they have it, you should let them know. I don't need to be involved in that conversation per se, but you could write out for them what it is. And then I'm sure they can make arrangements to display it. And so it's presented to a witness if appropriate.
So
go ahead.
Would I write that out? Would that be like an in-court thing? Because that's obviously the only time.
Carve it into your chest with a knife.
Well, sure. You would write it while you're in your cell, when you're in the conference room reviewing things, and just make some notes on what it is. And then tomorrow morning or whatever day of trial, if you think you're going to want something and it's not on their exhibit list, you just make a note and we'll see if they cannot make arrangements during the trial to display that. I'm not speaking on whether anything's admissible at this point or not. I'm just talking procedure.
Okay. I'm not sure about that. Well, the statement, the sentence before the last one with the exhibits, they have to be separate exhibits. The prosecution has their own exhibits and I have my own, so that way we're not using each other's exhibits. At least that's what I took from
Yes, but if you're gonna use an exhibit that the state's,
That it's not one that they're not.
right, if they have something on an exhibit list that you wanna use, it's pretty standard that we only use one copy of whatever it is. And then you're able to use that once during your case because it's already been admitted. Hopefully that helps answer your question.
Oh, just in the proceeding.
Anything else?
No, we did want to indicate that certainly we're willing to share exhibits with Mr. Brooks. If there's anything he wants displayed and it's admitted by the court, we can pull it up and be of assistance to the court and Mr. Brooks. We also want to renew our earlier offer if he needs assistance in serving subpoenas, as long as it's a relevant witness and it's a reasonable request that is limited to southeastern Wisconsin. We will give any assistance we can. We want Mr. Brooks to have a fair trial.
What if he needs
We
to
want him to
subpoena
have his
Zelensky?
relevant witnesses and evidence ready for the court. If there's something he wants, even if it's a document, we don't have the document camera, we have the entire file scanned, or he can give it to us and we can scan it in 1 minute and have it up on the screen. So we are more than willing to do that so that we can all be efficient in our presentation.
Thank you. Did you hear that, Mr. Brooks?
Yes.
All right. So if there are things that
I would
you,
like to say too, I'm sorry.
no, go ahead.
I was going to suggest that at some point, I didn't know if I'd be able to get to it today, but now it came up. That's one thing about the subpoenas.
I'll show
So the
you one thing
sooner
about
you
my
can fill
subpoenas.
those out and get them to, I can copy them for you so that the state has them and give you a copy. We'll facilitate that, right? I know you're gonna wanna keep a copy of whatever it is, but the sooner you can bring that information to court, that would be the easiest and most efficient way to get that information to the state, meaning you gotta fill out your subpoena forms and then give them to the state, who will then look at them and they'll be able to tell you yes, no, and we'll go from there, okay?
So I'm not asking for legal advice, but it would greatly benefit me if I'm able to know that I'm filling out the subpoenas correctly.
Sorry. You're muted.
I'm able to review for completeness, so if you bring them
That's
to
legal
court,
advice, bro.
I can at least do that.
Okay, because the last thing I want to do is write all these subpoenas up and then bring them in and they're incorrect.
Man, that'd be a damn shame if you did that.
Yeah. God, it's only like had guys who like do
I
this
can
shit for a
review
living.
for completeness, and we can go from there.
I will say the prosecutor willing to help him is a woman who does not want to retry this case.
Yep.
Before I had indicated that the jury instructions would be available on the computer in the conference room. That is not correct. They would be available in Lexis, which I believe is on his tablet.
Do you have Lexis
Who's
on the
got
tablet?
Lexus? What? I don't even have Lexus.
I'm sure I can find it. I want to just say too, it's not my tablet here.
You're gonna give just some rube Lexus? Like Lexus isn't that easy to use.
No, it's not, but still.
Understood. Lexis
Very,
is a
very
legal
pinky.
research, legal material platform.
Are you a Westlaw or Lexus guy?
It's actually what I use,
Westlaw.
so it's,
Oh,
I know
come
it to
on,
be
bro.
very thorough.
Yeah,
But
ride
you
or
have
die
to
with the
search
red
for
team.
things, but I'm told that the jury instructions are available through Lexis, through the tablet.
Yeah, I don't know exactly what the program is called itself. It just.
Lexis Nexus is a it's
Okay.
a legal research tool. They
All right.
also have Lexis
there anything
for
else, Mr.
journalists
Brooks?
and everything.
Okay, then that leaves tomorrow morning just the finalization of the jury instructions.
Lexis
and the motion for
Lexus, not US.
reconsideration.
The US would be the car.
Yes. Okay, all right. Thank you, everyone. We are in recess for tonight. We'll see everyone tomorrow at 8:30 a.m.
Oh, thank God.
It's done? I object, Your Honor. We need to
The
keep going.
bailiffs need to make sure they don't let.
I don't understand.
We need to print
being
off
done, Your
material for
Honor.
him. It's coming.
We need a 24-hour court
Thank you.
stream.
We're in recess.
There it is.
Ooh,
Oh, thank God. Oh, okay.
wow.
Welcome back, buddy.
Thank
You
you.
missed
Thank you.
some severe pain.
You know, jury instructions are the one point I wish I could go out, sit outside the courtroom and drink a coffee and play on my phone till they're done. It's the worst part of a trial.
Yeah. It's so bad. And they're gonna have to read. So I had forgotten to
Mhm.
prepare the chat for this. So tomorrow this thing resumes at 8:30 in the morning. They'll have there's a motion. I think the motion might be to deem him incompetent.
I'm betting the
'Cause he
public
should-
defender's office will probably they'll probably call in something to close down the courthouse because I doubt they want to do it right now.
yeah,
They're sitting there just in their office thinking, "Oh my God, we're gonna have to do this," and they've already put everything away and they're just staring at that box in the corner.
the motion that the state had not served it on him, despite the fact that he's in jail and easy to find. So they served it on him today, so which is why they didn't do anything about it. But the motion is a motion for reconsideration that needs to be done pre-trial, apparently.
So we don't even know what it is.
We
right
don't know
now?
what it is,
Oh,
but
yeah, it probably is that.
I have a suspicion that it's to appoint counsel.
Yeah, I'm
to-
sure the
to
public
deem him
defender shows up
incompetent.
tomorrow.
But that would, I mean, again, I think it's the right move.
Yeah.
I don't want them to though, because I want to laugh at how ridiculous the trial really gets when he gets going. But it's probably the right move for him to be appointed counsel. He is clearly not competent. He said on the record like 500 times, I do not understand. I do not understand. I don't understand.
You know why he says that though, right?
Yeah. I mean, he's just being obtuse.
Well, no. Well, it's the for some sovereign citizens, they view that as when you're not understanding. That literally means I'm standing under you as though you're like superior to me. Like they truly try to break down the words that way, and that's clearly not what understanding means, even in its root words. Or I don't know if it's French or Latin or whatever. That's what he means by understanding. Like, no, I
Oh
am
my
not
God.
under you. So that's. I wish the judge would know that because that would take away some of this. I informed you, and you heard what I just told you, and he would say yes. It's simple as that because then he
Yeah.
wouldn't say I don't understand.
He's
Mhm.
he's frustrating, a frustrating person
Yes.
to deal with. Again, remembering that most of this is predicated on him not recognizing his own name, not knowing the name of the judge, and not understanding the charges the judge has against him. She's like, I don't have charges against you. It's not what I'm doing.
Yeah.
So, yeah, it's a big mess. But what I should prepare the chat for is, so this starts 8:30 a.m. Central tomorrow with those issues. But the issue is jury instructions. There are 77 charges against him. That whole like intro phase before opening statements is going to be 2 hours. I don't know. It's going to be crazy amount of time before those statements start.
And those witnesses who were truly injured and the ones who lost family members, they're not just going to get these people up, zip them in, zip them out. It's going to be like Rittenhouse. It's going to be tough.
I think the trial is slated for a month.
Yeah, they said I think at least 4 weeks.
Yeah. So it's so he has the maybe it's 72. I don't know, it doesn't matter.
It's like 70 something.
It's in the 70s. The 6 are the intentional homicides. Those are the big news items, but he injured a lot of people. He broke a ton of other laws too. So he's got a whole bunch of charges against him. And that's why this case is going to take so long. I was very surprised, as you seem to be. 140 exhibits is
That's
not many.
No. Yeah, I mean that's for 6 people being murdered, although they were all murdered in the same place with the same thing. I mean,
They're in a crowd of like hundreds of
Yeah.
people. You've got several police officers who are involved in chasing the car, like shooting at the car.
Yeah.
You've got people around who would have been witness to people getting hit. You're going to have parents of kids. You're going to have spouses of the adults. Everybody who's injured and still alive is a potential witness. This is going to be a long trial for that.
Yeah.
His side of the trial is probably not going to be all that long because
it's going to be very short.
Because he won't have a case strategy.
Your Honor, we'd like to call William Ford the Fourth to the stand. Sir, your cars did this, didn't they?
Yes. It's going to be a mess.
Yeah.
That's the long and short of it. But
Yeah.
we're
Anyways.
here for it.
Yeah. Hey, Nick, I got to run again. I got dinner waiting. So,
All right, buddy. Good luck.
I'll see you.
Talk to you.
Night, everybody.
Talk to you soon. Peace.
Yep. Bye.
Yeah, she did say so far 140 exhibits. There could be more, of course, but that's probably going to be the bulk of their strategy. They don't need to do too much to convict this guy, but we'll see. All right, I'm going to go through super chats now, as best I can and as fast as I can to get them, and I'll try to answer your questions. Thank you. If you leave during this segment, thank you for joining me. I hope you'll consider joining me for the rest of this trial. I'll be streaming it basically every day that it's available. I might have to make some minor modifications due to some schedule stuff, but we'll make it happen here. So here we go. Wolfen73 says the I'm going to behave like a petulant child approach sure is serving him well. Will his encore be a full-fledged flailing tantrum to clinch his obvious victory? Lancelot 652, this guy needs an attorney, but I don't want him to have one because he's so hilarious without one. Yep. It's going to be a mess. Aiken says, looks like he was prepared to be muted. Bojangles Poonan says, but they freed Rittenhouse. He didn't do nothing. Mauricio Valente says, it's a misconception that all maps should be pinned to walls. Some are divided into pieces and buried, and others are so dangerous to keep around, they should just be burned to ashes. Not possibly. Let's go. Brandon says, take a shot or I'll lose what's left of my mind. I got you, brother. Hold on. ML Jeff. Yes, I need to do your workout motivation. That's right. Thank you for reminding me. Because I had forgotten. I thought it was going to be some quiet time a lot sooner there. Let's go, Brandon. Oh, it's going to be a painful time. Where was that? GL? ML Jeff. So I'm a soy boy in dire need of workout motivation. Don't hold back. I'll be listening to it before every workout. ML Jeff, what motivation do you need? That you're a piddly little piece of garbage? That you can't pick yourself up? You need someone else to come pick you up? That's how weak your arms and legs are, is that you come here to have someone else pick up your ego? A weightless thing is too heavy for your flaccid little muscles? Go to the gym. I don't even know if that's going to help you. I don't know if that's the first step. I think the first step is maybe, I don't know, try standing. Have you thought of that? Have you stood? Can you lift a piece of paper to write down your goals? Will the pencil break your pathetic little fingers? Get your hands on some fucking dumbbells and start curling them. What is wrong with you? Don't skip arm day or leg day or any day ever again. Go to the gym and get better because you're not good enough the way you are. There you go. Okay. Next. Let's see. Reformed Convict says he should get objection jail tat on his forehead. Rob Price to Nick, possibly getting his Twitter back since Elon has confirmed he has Twitter. Also, physics is worse than kettles. Okay. It would be funny if I got my Twitter back. I would laugh so hard. Reformed Convict says, I was in prison with a man who had F you mother effer horribly written on his entire forehead. YouTube is censoring me from the actual misspelling of the actual words he tattooed. He would cover it with a Band-Aid for court. It was epic. Ryan Wright says, I wish we could see how Judge Borowski would act. JJ says, if he gets the death penalty, he won't. Wisconsin does not have the death penalty. So he will get his life in prison with no opportunity for parole. Does the bailiff run him over? I'm not familiar with Wisconsin law. BYW, the judge looks pretty today. Yeah, she's not a bad looking lady. Not possibly Lesko. Brandon says, to be fair, at the time of the incident, if this map had a child with a map, we would only be down 1 juvenile. Low Watermark says, what an awful crap show. He'll do crazy stuff every day. Yet that is likely. Low Watermark also says, for not explaining the law, she is sure explaining the law too much. Can some superior judge tell her she's an A? I mean, there's no judge who's going to, on their own, reprimand her in any way. I mean, I guess somebody could file for a mandamus, but with pro se or pro per litigants, which means the exact same thing, by the way. Pro se and pro per mean the exact same thing. There is no legal difference. There's no functional difference. The only difference is that pro per, I guess, has stronger ties to a Latin origin than pro se. And that's probably why sovereign citizens demand its use, because they're weird. But yeah. Lagging says, night show your defense strategy if it was you. Bring the SUV back to the courtroom. That's what you got to do. That's the only way. G-Soap over on Odyssey says, sorry to upset you. Rackets with discussions of twincest. Yet another reason why people should chat on Odyssey instead of YouTube. Steve C says, nice stream today. Locals live chat is great. Yes, I think people are really liking the Locals live chat sort of added value. I'm glad I started doing it. People seem to really enjoy it. And plus, it's more fun. You get to add pictures and stuff. The T-Man says, thank you for the help of getting me stabilized. Use code DINDONUFFIN at thedragonstreasure.com for 10% off your order of tea. Nick, can you shame me for being such a shit entrepreneur who needed to e-beg to get out of trouble? Yeah, I can. T-Man, that was really basic and pathetic of you. You should feel bad about it, and you should consider closing your business forever. Have you thought about that one? Borvox is not sure if this went through the first time. It did. I was just about to read it. But Viz Media has been announcing a bunch of returning voice actors for the English dub of the upcoming Bleach 1000-Year Blood War anime. So anyone who wants to see Vic Mignogna also return to his role as the voice of Ikaku Madarm, please join me in leaving as many positive, supportive comments as you can to their posts on Facebook, YouTube, Twitter, etc., to let them know you want Vic back. The Consultant says, I can't wait for the porn parody when it comes out. Maybe I wasn't about to read yours. You guys had just had the same avatar. USA Now says, did you review on stream or personally the Rumble TOS done by Viva Fry and Robert Barnes? No, I have not. Ginger Ninja says, no, he wasn't driving a Lexus. It was a Ford Explorer. The Aussie Mozzie says, don't read this one out. Thank you. I did read it, what you wrote. Which other ones are there here? Royal Plague sent Dr. Fauci's Yelp review. I think it's a picture of Fair and Balanced, maybe. And then that is that over on Locals. Okay. I tried to get the Rumble ones as they came in. I hope I didn't miss any. On YouTube, we've got the remaining chats. And if you're new here, again, I do these trial streams and people enjoy those. I do a nighttime show as well every weeknight at 11 p.m. Central. Basically, I mean, sometimes you miss them, like because of scheduling or because of fatigue. But basically, every weeknight at 11 p.m. Central, I do a nighttime show, including tonight. If you like the trial streams, you're probably not going to like the night show. But I love the night show. And the night show is what I love doing. That is where we tell jokes, we engage in fun stories, we get very irreverent and sometimes really drunk and tell we say very offensive words that hurt people's feelings. And so if you like to go and remember what it's like to have joy in your life and to laugh at things, that's what the night show is for. If you're a joyless person and you just want to watch trial streams all day, don't ever watch the night show. It's okay. You don't ever have to. But if you do, I promise you, I will try as hard as I can to make you leave. that's my goal. Squizgar says, like Johnny Cochran says, if the binger's late, he ain't straight. Artie Jinri says, Leighton Gay opinion on PayPal, $2,500 fines. Yeah, I've only barely seen them. They seem horrifically unreasonable. So I don't know. Like, I haven't read about this. I've only like heard people mention it. I got to look into it. Let's see. Heather Whitaker, when are you coming to stand? Wait, I read that one. Stephanie Tam, there's a point no one can argue with. Nick can talk. JC Cujo, legit question for you. Do you know a dependable and portable bandsaw brand? I have a couple of 150 millimeter tank rounds I want to cut open. Danger is a non-issue. No, I don't know. I don't know much about bandsaws, but I wish you good luck in whatever probably illegal endeavor that is. Big Raj sent a big thumbs up. Haramburger says, check your thread, page 734 for the faces already. We'll probably talk about some of that at night on the nighttime show. But thank you. Yori Bori says, love the stream. Watch it all the time. Shameless shout out to CBC Anon on YouTube and Cold Beer Confessional on Twitch. He debunks grifters and QAnon and is on his 6th YouTube channel from YouTube censorship. Toast and shout out to him, please. Okay. Sounds good. Wait, he debunks grifters? Why hasn't he debunked me yet? Is he afraid? Some kind of coward. All right. Here we go. To Cold Beer Confessionals on Twitch and CBC Anon on YouTube. A man tackling grifters left and right, forcing them down, spreading their arms apart, and tickling their underarms mercilessly until their secrets are exposed to the world. Someone who appears to make enough people mad to get banned repeatedly, but operates on without fear. Cheers to him. May we all do the same. Not tickling people, but operating without fear. Make sure we get that right. Joe T says, sociology means you have a PhD in taking Facebook surveys. Very true. Casbiness. Nick, just want to point out that troon literally means the nose. Look it up on Wikipedia or any etymology site. You were destined for this fight. Wait, really? Oh, that's amazing. I'm going to definitely look that up. Joseph says, how is this for the prosecution? More like a paid day off at work or just pain in their butt? All hail the Pope. Oh, no, it's a pain. The state is going to do this one time. And they're going to never want to do it again. That's why the judge and the state have to get this right, because they'll hate it. Herschel Shmuel Yehua says, hang the gamer word. Soleil 333 bets on him claiming racism at some point during this trial. I'm sure he already has. The Vodka Haze. Remember, ageusia, loss of taste, equals can't defend. Asp, a sovereign citizen taking the jabs. Isn't that a bit ironic? It doesn't make any sense. Boomer Wow. The jab must have made him crazy. What a shame. Kakalo Tuzaru says, Nick, a while ago I sent an inspirational chat to folks, but now I need shaming. Since I stopped jogging and diet, I gained 8 kilos, 17 pounds. Don't diet. Dieting isn't the way. Dieting means you like modify what you eat, like, and you don't like it. And it's like this thing that you do. Just stop eating. Try that. Like, just don't. Like, oh, you know what? I'm going to go eat X. And then you go, oh, wait, but I'm fat. And then don't. And then you run from your problems, run from the food, run from your hunger, and maybe you'll get skinny again. Oh my goodness. I can't believe you need help with this. Mr. Bentham says, this is so aggravating to watch. F this dude. Oh, also we fat shame people on the channel, by the way. But you have to understand, again, for the new people, the fat shaming is only for people who want it or deserve it. And 2, you're only fat if you have a fat mind. Because there are lots of fat people who are fine with how fat they are, and that's cool. Go be fat. But if you have a fat mind and it bothers you that you're fat, maybe you should be skinny. Think about it. Think about it. Doug Murray says the only reason big tech censored Q is because it exposed a system enslaving humanity. Good Hunter. Between Darrell and the judge, we don't need a COVID protocol. We need a short bus protocol. Mauricio Valente read that one. Christ says, objection, I do not consent to this super chat. Yes, you do. Or I'll force it on you. K-Rab says he was a Dovsit. He doesn't recognize Wisconsin law. He wants the jury to be presented with the Constitution, not the applicable Wisconsin law. Pinochet's helicopter tours. I'm kind of curious to see the judge's Elvira cosplay. You better stop. You better stop. And then keep going. Captain Spire says, I am conjectifying to the repository to this decision-making process upon the judicial processutorial proceedings thereof, to which I objectify. Wyatt says, what legal logic prevents someone from making a nullification argument? It's a rule, but is that rule valid? Because juries have a duty to judge a case on facts and law. Ostensibly. So the legal argument would be instructing them that they have a jury nullification duty, obligation, or responsibility in any way would run contrary to the facts and law argument necessarily. I think the rationale is they have to independently come to that conclusion. I don't know if that's correct, but I think that's the rationale. All right. I'll try and find out, Wyatt, but I don't know that there's like a solid legal foundation. And personally, I think everybody should be able to argue jury nullification to a jury. Hey, you have an opportunity as a jury to decide when a law is unjust or unjustly applied. And if you choose to do that today, this person walks free. If you think that's the right decision, then that is your power as a juror to do so. Like, to me, that makes sense. I don't see why. Like, I know why courts are scared of that argument because a lot of people would do it. But I don't know if there's a specific legal basis for it. Colin, does his recalcitrant behavior pose a risk that the judge or prosecution will make a mistake, increasing the likelihood of a mistrial or appeal? That's probably his goal, in all honesty. I punch puppies. Brooks may be a poor lawyer, but he made a hell of an argument for segregation. Also, mommy judge can hold me in contempt. Just please hold me. Jacoby Davis says, out of pure curiosity, is there any chance he could potentially cause a default judgment by all these interruptions? No, you can't default in a criminal trial. There's no like well, I guess. I think only for petty misdemeanors like speeding tickets, civil infractions, stuff like that, can you actually default. But yeah, for criminal, you have to be found guilty beyond a reasonable doubt. It's your constitutional right to due process. There's no like, well, we skip that whole jury thing and you go to default. Not on criminal acts. Okay. Not possibly. Let's go. Brandon says, someone start tanking shots. I can't handle this. Christian Anderson. This is actually really instructive for future / would-be pro se defendants who are a little more competent. If you want to be a pro se defendant, sure. Please do it on like a misdemeanor or lower. Please don't. But if that's where you're going to do it there. When you have 77 charges of varying levels of assault and homicide, just be represented by a lawyer. Just do it. Like get a lawyer. If you're in felony territory and you're facing prison time, like actual legit time, get a lawyer for your own fucking sake, please. Pinochet's helicopter tour. Remember, lawyers, silent leges enim inter arma. Flux says, what, if any, obligations do they have? Corvus Delecti, quick rackets. Get this man the entire book of the Matt Harris. He can submit it as jury instructions, and hopefully we can hear it read in court. God, that'd be so funny. Alien Baby says, anyone have a link to the judge's OnlyFans page? Not even her husband. Tin Man says, anyone else notice during the first 2 days he made a huge deal about using the word understand, but today is no problem with it? Mark Gee says, will Brooks' defense better, worse, or more existent than Halderson's defense team? It will be more self-interested than Halderson's defense team was in representing Halderson, but I think it'll be less competent somehow. Let's see. Corn Pop says, nope. Okay. Low watermark, read that one. Pinochet's helicopter tours again says, I'm definitely warming up to mommy Judge Lewinsky. Oh, she does kind of look like Monica Lewinsky, minus like 30 pounds. Europa Chronicles. Nick, I've been arguing with sovereign citizens for a decade. It would be amusing and interesting for you to do a stream dismantling all of their insane arguments, e.g. name in all caps. Well, I mean, the hard part about sovereign citizen arguments is like the proof is in the pudding. Like, if my name's in all caps, the court can't arrest me. It's like the last guy got arrested and is in prison right now. It didn't work for him, but they have selective criteria for the evidence that they'll accept. Like someone said the magic words and goes to prison 100 times, and they go, that's not real. And then one guy says the magic words and gets off because the charge is probably bogus in the first place. And he's like, oh, this is how all cases will go. And they all lose over and over. Let's see. Here we go. Next. Fire Pixie says, first chat. My whole family is watching. SCCAFL. Can you shout out to Aaron? Yes, Aaron. Fire Pixie sent this a long time ago. Sorry, I have a policy of reading $20 super chats and higher first. I'm sorry your first experience was a little lacking. Normally, I'm not so bad at it, but this never happens. But a big shout out to you guys and a big shout out to Aaron. Thank you for hanging out. I hope you'll watch more. We have a lot of fun on this channel. Let's see. Jovi's mom says, Nick, I'm in need of a full shame. Managing weight, cleaning, daily life tasks. Feels like I'm drowning in chronic fatigue, but I can't find productivity motivation. But I do find time for your nightly show, though. Priorities. No, look, you're doing it right. Don't ever let anybody tell you you're wrong, girl. Make sure you always come to the night show. No, look, Jovi's mom. Mom is in your name. I'm guessing there's a kid involved. Dude, we're all there. Here's the thing, in my opinion, with management of a household full of children or even one child, plus schedules, especially at this time of year, fall is the worst. Everybody sucks at it. Everybody's bad at it. Everybody's just as stressed as you are. And the people who put on the veneer of success with it are in the insides. They're just slashing their wrists over and over. They didn't remember where they put the razor, so they can't actually do it. So you're not alone there. Managing weight, that's critical, because in all honesty, and this isn't even a meme, managing the weight should be your priority 100%, because managing schedules, cleaning the house, all of that stuff starts with you being healthy enough to do it. And if you devote the time to yourself, you'll start to realize the value of devoting time to tasks. If you just devote times for tasks, neglect yourself, and hate every second of every day, you'll wonder why you even bother doing anything. So work on you. That's the most important thing in your life, is you. Because you, even if you have a husband, a wife, kids, whatever, if you're not functioning, then you're not adequately serving them in the way that you want to do in whatever role that you might have. So work on you. Make the time. Don't let anybody stop you from making the time. Most importantly, don't let your dumbass stop yourself from making the time. You have to do it, even when you don't want to, because you'll feel better afterwards, and you'll feel more prepared to take on those tasks, and you will find the time once you realize you've got more energy and you feel better about yourself and less time going, oh, God, I just want to sit around on a couch. So do it. Do it. I believe in you. Believe in the ball, Jake, and throw yourself. Stormtrooper Julian Caesar says this man needs representation. Where is Ronnie? Ronnie O'Neill this man would already be out of prison. Jane Doe, if he says he didn't know, he'd be muted/removed, so he wants a public defender to skillfully advocate what he still doesn't understand legally. Would that increase the odds he gets a public? Oh, if he wants a public defender, he can probably invoke his Sixth Amendment right to counsel. Like, he waived it, but I'm sure he could re-invoke it. Say, Judge, I was completely wrong. Please, because the judge would be inclined to make that happen so long as it didn't delay proceedings. Because bringing on an attorney would probably smooth out the entire process. So, Scanner Daffley, what are you talking about? Yesterday I said today about what? If it's posting documents, that'll be done when I get done here. I wasn't at my computer yet. Not possibly. Let's go. Brandon says Nick personally asked me to solicit super chats that he will have to read for the next 5 hours. Factual says, hey, Nick, is there any possibility of a mistrial on the basis of Brooks having undeveloped smooth gray matter? Lol. And what happens if he is eventually ruled incompetent? The judge can rule him incompetent. She can reconsider her ruling, rule him incompetent, and appoint counsel. It's probably the right move. I don't want her to do it because it'll be funnier if she doesn't. But it's probably legally the right move to do. I think he is actually incompetent to stand trial. Not necessarily because he has no ability to understand, but he's a general unwillingness to understand and follow the rules of court. And it's better that he be represented by a disinterested advocate than to delay the court's time and to intentionally represent himself poorly. But I think the possibility of a mistrial comes with her when she said he could waive his right to cross-examination. Things like that give me a big because that's a Sixth Amendment issue. You have the right to confront your accusers. And if you can't confront your accusers because a judge determined you waived that right, that's a mistrial issue right there. I mean, it's theoretically possible, but I don't know that he's anywhere at that point. And him disturbing the court by just not following the procedure they laid out is probably not sufficient to overcome a Sixth Amendment right like that. So that's my opinion. I'm not familiar with the case law, but the better option than you can't cross-examine witnesses is you are disruptive to the court. You're incapable of acting in your own self-interest, and we will rule you incompetent and appoint counsel who will cross-examine these witnesses. That's the easier solution than saying you waived your Sixth Amendment right to cross-examine. Oh, Scanner Daffley. Okay, I gotcha. Sam P., how likely is it this case will be appealed? Extremely likely. There's probably a group of public defenders who just handle all murder cases. They submit appeals on all of them. Also, any tips for my contracts midterm tomorrow? Yeah, consideration. Everything is consideration. Consideration. Offer, acceptance, consideration. Like, you have to, where's the offer? Who accepted it? A counter offer nullifies the original offer. You can't renew it. Every offer is the start. Every acceptance is the finish, and every contract requires consideration. Start there. Foundational, basic. Make sure you nail that in every one of your questions on the midterm. You get those basic elements of contract down because they're the most critical parts. They're going to get you the most points on the exam. Everything else is an issue you can deal with later, but deal with those fundamentals. Worry about the fringes after the fundamentals. Low Watermark says FTCK. 200 Watt Studio says, hey, Judge, I would like to make my poinus into a subpenis, if you know what I mean. Pinochet's helicopter tours. Can someone file an amicus brief to appoint counsel? No. Well, I mean, yes, the court doesn't have to accept it, though. Jane Doe says, will he be free or get a second trial if the appeal wins? If the appeal wins, he would probably be granted a mistrial and the state would have the opportunity to prosecute him again. Spider Jerusalem says Judge looks more concerned with her lip injections and inevitable OnlyFans career than moving this forward. She had some big lips, though. Really did. John Diaz, why can't he stand up straight? Don't know. Medic Pack, Judge Milf sure does like asking unnecessary COVID questions. It's because he raised the COVID issue and she just took it way too far. Reformed convict, he should have said he fell in jail and the other inmates hollered, get that butt, and went with monkeypox. He would have had more of a chance. Crazy Cat Queen, is duct tape allowed in the courtroom? No, but gags, there is case law on actually gagging someone and preserving them in the courtroom. That exists. It's happened. I know an attorney who was so disrespectful to a judge that they had to be handcuffed to a chair to complete their closing argument. So they brought the chair, they put the attorney there, put the microphone in front of her, cuffed her down, and said, "You do not get to grandstand or anything. Finish your fucking argument." A bear in the woods, I respectfully object, Your Honor. I didn't run those kids over to sit here and have this lady call me out for stalling. Sully 333. I got COVID the same time he reports he did, and I'm good as of midnight. So the lady is correct, and he's just stalling. 200 Watt Studio. I would love for Judge Mommy 2.0 to admonish me. Oh, I know you would. Kelly Joyner. Nick, since he considers himself sovereign, doesn't that exclude him from the rights afforded to the rest of us? Why have a trial? No. No, that's not how rights work. Again, your rights are recognized as inherent things by our Constitution. They're not granted to you by the Constitution or by citizenship or by government. Your rights are recognized, and that is a good thing. They are recognized as existing. So, that's the way they go. I don't know what else to say. John Diaz, the Matt Harris needs Brooks to defend him. Cheese is crisp. Can we just enter this guy in a demolition derby on foot and be done with it? Hamdrew Ryan, tell the guy he has to join a stream with you to not publish his ethics report. Lamau, high quality content. Look, I don't want to contact him at all because people will, he extorted me. He demanded something in exchange for not harming me or whatever. I'm not harming anybody. You gave me your information. You were informed that you would be giving me your information. I told you I will read it out publicly. And yeah. I don't know what the confusion is here, but it's going to happen. You made your choice. Like, I don't know what you want me to do. There's no redemption arc for me. There was no mercy or consideration given to me. And I'm not trying to destroy your job, but you're trying to destroy mine. So sorry. And the best part is, most likely, absolutely nothing will happen to any of you. Someone will laugh at you and you'll feel bad about it. And that's it. That's what happens. Welcome to the internet. Get laughed at. Fantastic, Mr. Knox. Watching this from Australia. Man, this is both depressing and hilarious because we have to watch a buffoon defend himself in court and he has no idea how to respond in court while pathetically stalling. Bob Johnson. Darrell Brooks graduated summa cum laude of the B. Ivory School of Law. Deep Surface Jail Admin Wallenhop. What a perfect name. Ashton. He has 5150 been ruled out yet for this guy. Also, it's great to see you doing live streams again. Look, I've been doing live streams every night, except when I get banned from YouTube. I've had 3 weeks of suspension in the past 2 months, which is a lot of time. But yeah, I do them every night at 11 p.m. The daytime streams and the trial streams I have not been able to do. I've just been way too busy. Believe me, I've wanted to. 5150 is a 72-hour psychiatric hold. I don't know that you could 5150 someone in jail. Like, they may implement psychiatric issues, but the guy's not crazy at the moment. And he's not in danger of self-harm. So no, we can't 5150 him. Curly Leg Hair says fan mailers go to the wall beside the pedos and troons. Mufti Teg says, I believe he is baffled by his own reflection. Very possible. 200-watt studio, Mr. Brooks. I don't know what you're driving at. Come on now. Stop that. Ruin Leon. Didn't he try to plead insanity? I don't know that he did. 11 Bravo Crunchy. The jail admin looks like she's about to run Mr. Brooks over with his own car. Steve, this is great. It's been too long since we had some courtroom coverage. Again, I've been wanting to. I just have not had the ability. TJ Mars, he talks like he was dropped on his head as a kid. G33K, on today's episode of Preschool Law, ... Vinny the D, Your Holiness, I'm going to ask you a logical question. Do you know what it is to nout the thing? To do nout the thing. Yes. Lieutenant Rimu, if he takes a stand, who will direct/cross for his defense? I have to look into this, but I think the court may allow a pro se litigant to offer a brief statement of their own. You can't really ask yourself questions, but you may be able to offer a brief statement on your own behalf into the record. And then you get cross-examined by the other party. So that's likely how that would work. But I have to kind of look into it. I don't personally deal with people who represent themselves that much. We'll ask Steve Gosney tomorrow how that works. Rocket Insano, why is he standing like that? But seriously, he just accidentally delayed the trial with his stupidity. He should have been dismissed immediately. Exactly. Captain Tromo says, I vote that we send this judge a nice bottle of scotch for having to deal with this absolute clown. Crazy Cat Queen, she was painfully meticulous at every step. She friggin' asked each question like 3 different ways. Fabian Cartouche says, on display, it's how whamanism has been deployed to make a dark triad dumpster fire, both contemporary parenting and race relations. Hold on, I have to make sure. I have a feeling. Okay. Seagoody, check Discord off air later, please. Not for the show. Will do. Crazy Cat Queen. Once the jury is present, what happens if the jury starts snickering at this clown? Jury is not allowed to make emotional reactions, and if they are, the judge will dismiss them briefly until they collect themselves. Seagoody says, oh, wait, 200-watt studio. I would like to petition the court to shower with your honor. Judge DiMartino. She has to reverse her decision that he is competent to represent himself, or this trial is going to last 10 years. Split says Russian hacktivist group said they are doing a USA online campaign for the next 72 hours. Oh, okay. Michelle Cavarnos sent nothing. Thank you. Split says USA offline, not online. Okay, I don't know what a USA offline campaign is, but I believe you. Martial Arts, I don't care how guilty the SUV is. It deserves better representation than this. Not possibly Lesko Brand. Stop wasting my tax dollars. Shut him up. I can waste them more efficiently. Pixie Jism. I think a ticker scrolling across the bottom of the screen with the pictures and names of the victims would give some perspective to this farce. Hey, that's a good idea. Maybe I'll do that. I don't know. Magician Sapphire, Your Honor, permission to summary execute this fool. John Diaz, I get that he's a dummy, but why does the witness get to say, Judge, I prefer not to answer? Is that normal? It's kind of weird, but there's no jury, so I guess it kind of works out. But that did make me uncomfortable. Shizzy Wiznut says, bro is pissed that he is ignorant. Magician Sapphire, the binger is stalling hard. I think his plan is to bore the court with his ramblings so that the judge dismisses the case out of frustration. John Kirstian says he is concerned for others because he has COVID, but not when he was running them over with an SUV. Fuck off. Here we go. Christian Wolf, crazy how lenient the judge is with him compared to the one in the Alex Jones trial. Well, Alex Jones is the actual murderer here. I hope you know that, especially considering DB actually killed people, whereas Alex Jones just said slanderous things. Whoa, about people who were killed. No, he murdered them. An idiot with an opinion says, where was the concern for the health and safety of others when he ran over a bunch of people during a Christmas parade? Pinochet's helicopter tours. Can court force this guy to take the Moderna jab? Sanzo Ivalis says, I hope they have Uncle Ruckus on the jury. Jensen, like you, I'm mostly against the death penalty. However, there are exceptions. I've said that too, by the way. And this guy has earned an exception, not for the mass murder, just for being annoying. Arias Rofocal says, save us from Darrell Corona Chan. Pam Ronning, he's going for a time served after this trial sentence. Pinochet's helicopter tours. Could you see a law group similar to the Kamala riot bail folk suggesting defendants self-represent in trial with the intent of causing a mistrial? That would potentially violate their ethical obligations. Blue Fur says he better go away for life, or there's truly no justice in the world. If not, I hope the cellmate teaches him the real meaning of super spreader. Oh, shit. Shizzy Wiznut. Judge has a breathing issue when talking. Cameron Nelson. Gage Grosquitz petitions for name change. That's true. Corpus Delecti Rackets. Is it just me, or is he clearly doing the sleeping in class defense, holding the objection up just enough to cover his face as no one sees he's actually sleeping? As I never covered my face when sleeping in class. Sleep shamelessly. Vienna waits for you. Mr. Brooks should try the "you're out of order. He's out of order. The whole damn court is out of order" card next time. Yes, he should do that. It'd be better than what he's doing. Josh D. What are the odds this ends up in the Supreme Court to balance self-representation disruption? Very low. Evelyn Ziegler, for the love of everything that is good on this earth, I want Judge Schrader to rip a new a-hole on this a-hole. R.E. Mango Esquire, DVM MD. I think the judge is just trying to wear Brooks down, just rambling on and on and on to waste his time. Jared Hood, can he ask for counsel during the trial, or is this decision he has made permanent for the duration of the trial? I believe he can assert his rights, even though he's waived them previously. Stephen Goldstein, unfortunately, if one abuses objections by raising them with no basis, eventually there must be an order to stop objections until there is a legal basis to do so. You both should know that. Yeah, but she said you can't stand up and object to every question. There's a difference there. You can stand up and object to every question, so long as you have sufficient or a good faith basis. Good faith belief that you have sufficient basis for it. It depends on the questions, though. It's not like, well, they've asked 20 questions. They're all bad, but 21 gets through. Jared Hood, can he read that one. Romo Drummer, read that one. Jerkoff Juggernaut. Are we sure Mr. Brooks is a black man and not a white woman named Karen? Nope. Colby, can I get a toast for my grandfather who passed away today from cancer and heart failure? He was technically my step-grandpa, but accepted me as his own. I knew him for 24 years, and he was a good man. Yeah. Yeah, I guess. Just a little tiny bit. To the grandfather of Colby. He said he was a step-grandfather, but that's not how it works, right? I mean, that's how genetics works, but that's not how family works. A guy who came into your life maybe later, but for 24 years treated you as a grandson, treated you as a person, treated you as family, inspired you and taught you things that you did not know before. May his passing, cancer and heart failure, a nasty combination. May his passing bring peace and an end to pain. May it inspire family members to go with grace and dignity and courage when their time comes. And may their memories always be fond. And may their criticisms fade. Like Marty McFly almost did in Back to the Future 1. Cheers. One Man Band, Unbreaded, brought to you by the Birch Gold Group. Joey Flores, I've been thinking about getting into something like that, but what do you do if you need money, just find someone to sell it? Dude, if you, these are retirement accounts. Withdrawing from retirement accounts is a huge pain in the ass already. Evil Bunny read that one. Simulation 115. When will you do another painting stream? I have some models that I would love to see you critique. Sargon is doing a painting stream tomorrow. I think it starts at 3 p.m. Central Time. If I can join them, it's going to be late because I'm going to be covering the trial. But we'll see. I got to figure out tomorrow. Actually, I got to confer with some bros about that because I'll have to leave in the middle of the stream tomorrow to go teach. And I can't really, it's the second day, but it's the first like real day. So I have to leave to go teach around 1:50 p.m. So I'm going to hopefully have someone to fill in and just keep the stream going at that time. But I got to confer with some people on that. Eldred Jonas says, can you describe your personal line between personal freedom and your internal morals? Something besides as long as it doesn't hurt anyone. Like, does a person have the right to remove their penis? Yeah, of course they do. You can chop off your body, whatever you want. It's not so long as it doesn't hurt anyone. It's so long as it doesn't infringe on the rights of another person. That's the limit. Your personal morals are your limit. That's the interplay between your personal liberty. And my personal morals are different than anyone else's, and my personal morals should not be imposed on anyone else because theirs can't be imposed on me either. So the limit is what do you want to do? I hope that helps. Not applicable. This is the worst. How can anybody watch this? BC, need the Edgecombe judge on this. Sidebar. Borowski's great. Ender says, I love the Honorable Judge Milky's. Corpus Delecti. I got it. Prosecutor's the mom from Goonies. So shit sure is. Whew. Ryan McKenna. Is that prosecutor Mark Richards in a wig? Yes. Adam Prenger. The judge kind of looks like Michael Jackson. Hee hee. No white guilt clips. Why was Brooks not charged with a hate crime? He attacked a parade full of white people after making many violently anti-white social media posts. Do you want the real like legal answer? Because Caucasian isn't a protected class under the Civil Rights Act. There you go. Should be, but it's frankly just not. Red One says he could have got B. Ivory Lamar as advisory counsel. Sned Music. Hey, Nick, friendly neighborhood audio engineer here. Your mic is a bit low compared to the judge's audio. You're being drowned out. I don't know what happened because at the beginning of the stream, the audio was fine. And then somewhere in the middle, it changed. I don't know if it's when I changed to the other stream or what, but I got to tell you guys, because this will come up over and over every time I do a trial. StreamYard, the software I use to broadcast, has back-end processing to try and level out the sound. I can't adjust it on the audio feed. It's my biggest complaint for StreamYard, and it's the one they're least intent on tackling. It's very frustrating. I can't see the levels on StreamYard. I can see them locally, and my levels were higher than the courts when you guys are saying we can't hear you. StreamYard has some criteria, and I don't mean my faders were higher than the courts. I mean the actual audio levels, like, you know, me up here, and then there's, you know, peaking here like this, bouncing, undulating. I can't do anything about the StreamYard audio. There's no way for me to control it. And it's really fucking irritating. So I will try and work on it as much as I can from my end. But I also noticed those issues came when I became the only person on stream. So I think StreamYard was having a better averaging balance when there were multiple sources. And then as it became just me and the other source, that got out of whack. Haley's comment. This is a clown show and a mockery for the victims. This needs to end. Well, it has to end with due process because that's the only way it does. Wait, what the fuck?